Good afternoon. This is the House Judiciary Committee. It's Wednesday, the 29th of March. We have a number of bills. Some of them are not clean cross files, and we're going to try to move through them all as quickly as we can. Senate Bill 221 is first. Chief Justice is here. We're going to hear from him with regard to 221. I think it's just you, correct?
Yes.
All right, that's fine. We will hear from you. Go ahead.
Okay, thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I appreciate the opportunity to be here to testify in support of cross-filed Senate Bill 221. I do need to point out at the outset that the Judiciary had originally sent in a bill for consideration. A different version of the bill was introduced first. An amendment was made to conform the bill, but it's my understanding that when the vote was taken, it was on the wrong bill, and that was inadvertent, and that the intent was to vote on the amended bill, which is what the Judiciary had originally put forward. So there's some confusion there, but I understand that it is hopefully being addressed. The purpose of this bill is to provide some protection for judicial officers whose official roles necessarily place them at risk of personal attack from disgruntled litigants. And the intent is to provide a mechanism to keep their home addresses and previously unpublished phone numbers from being available on the internet. Several high-profile incidents have led the news coverage on this topic, such as the shooting of a husband and son of a federal judge in New Jersey a couple of years ago, the armed individual who came close to Justice Kavanaugh's Maryland home last year with a firearm. In addition to those high-profile incidents, there are many others that have not been reported. A judge on the Appellate Court of Maryland received a letter from the Capital Gazette shooter indicating that he was on that individual's list shortly thereafter. Just within the last 5 weeks or so, on February 24th, in a Baltimore County District Court courtroom, an individual threatened a judge who denied a protective order by claiming that he could find information about the judge online and said, quoting, "I can get to your house, I can get to your kids." On February 28th, a Cambridge man was arrested after making death threats against 2 judges because of his dissatisfaction in a child custody case. Individuals that would be protected by this bill are Maryland judicial officers, federal judicial officers in Maryland, and parents, spouses, and children of those officers. We also support a request by the governor and lieutenant governor to be added to the bill, with the exception, of course, of Government House itself. This bill is narrow and modest in what it protects: home addresses and previously unpublished phone numbers. The basic requirement of the bill is that if a protected individual requests removal of the information, and the entity that is posting it can verify that the individual is who they say they are, that the entity would have to remove the information within 7 days. Remedies for a violation would include declaratory relief, an injunction, and attorney's fees. Remedies for violation by a private party could also include damages or, if willful, punitive damages. I note that one category of records that is not covered here is land records. There are special challenges posed with respect to land records that haven't been worked through, so the bill includes an uncodified part that would create a work group to look into that issue. I thank you for your consideration, and obviously I'm available for questions.
Are there questions? Seeing Delegate Tolles.
Thank you so much, and thank you for being here. I have a quick question. I think I indicated this when the House bill was here about, so there was an amendment to add, you said the governor, lieutenant governor, and are there any other state elected officials that will be added to this bill? Thank you.
Not by the Judiciary. I know there were a number of questions that were asked when we were here before about others, and our position is that we don't take a position as to any other officials outside of the Judiciary. We certainly aren't opposing that, but we're not requesting it either. Our request is limited to the Judiciary officials, and we do support the request for the governor and lieutenant governor to be added.
Would you support the request of any other state elected officials or any state elected officials, including, which we're not really state, but you know, we serve in the State House, any elected official serving in the State House. Would you support that amendment?
That would be so. We wouldn't really take a position on it. The judiciary obviously needs to be careful with respect to bills that might come before it. So we take a limited approach to this, and so we really don't take a position on anybody else. We certainly wouldn't treat it as hostile. We wouldn't oppose it, but we really think that our position should be limited to judicial officials.
Okay. Okay. Thank you so much. Thank you, Mr. Chair.
Further questions? Seeing none, we thank you very much, and that concludes the testimony for Senate Bill 221.
Thank you.
We're going to go to Senator Beidle now, Senate Bill 67. Is this a cross-filed bill that passed in the same fashion as the House did?
No, it does not have a cross-file. It was supposed to have a cross-file, but I'm not sure what happened. But
All right. Well, then let's hear the bill. Go ahead.
thank you. Thank you, Mr. Chairman, Vice Chair, and members of the committee. This is a pretty simple bill. It's Senate Bill 67, Clerks of the Circuit Court, Civil Commissions, Presentation and Reporting. For the record, I'm Pam Beidle, Anne Arundel County. Senate Bill 67 is a reflection of the current practice for the clerks of the court, and this was presented to me by the statewide association for the clerks of the circuit courts. So currently what happens if you apply for a license that needs a commission, you don't reach out to the clerks, they reach out to you to schedule your appointment. But currently the bill says you reach the clerk. The second issue says it deletes the requirement for a monthly report to the secretary because currently the clerks send a notice every time an oath is administered. That's current practice. And third, it deletes the requirement for the clerk to withhold the oath until the appointee has paid the tax on their commission. This has not been the requirement for many years. So these three changes reflect current practice. Senate Bill 67 passed the Senate 46-0. Thank you for your attention, and I respectfully request a favorable report on Senate Bill 67.
All right. Questions? Delegate Kaufman?
Yes, Senator Beidle, it's always great to see you. I just have a quick question, again, because I'm getting an accelerated CLE here as a non-lawyer. Can you explain what a civil commission is? You said the people apply for it, but what is it?
Well, certain people, I think an example would be a notary. You
okay.
apply to be a notary, and then you have to go in and actually do your pledge and get your notary.
Oh, okay, I get it. So somebody in the 32nd District has you sponsor them as a notary, and then they need to, do the pledge, and that's the civil commission.
You know,
All
they
right.
go into the clerk of the court and finish the process and pay their bill and receive their commission.
Thank you for your indulgence, Mr. Chair, and thank you for the education, Senator Beidle.
Thank you.
Further questions? Seeing none, thank you all. Thank you very much.
Thank you,
That
Mr. Chair.
concludes the testimony for Senate Bill 67. Now going to go to Senate Bill 5. Senate Bill 5 with Senator Kramer. It is just Senator Kramer. Senator Kramer, is this in the same posture as the House bill went to the Senate?
Mr. Chairman, it's in the identical posture, and I thank you for your good work on this bill and the good work of Delegate
So
Crutchfield.
it's because you had an adequate delegate sponsor that it all worked out well?
Perfection.
Really?
Perfection.
Okay.
And with that, I am open to any questions, Mr. Chair.
All right. This is any further. This is the legislation with regard to the civil remedy connected to hate crimes. You want to give a brief synopsis of what the bill does, please, and then we'll let you out of here.
I will be very brief, Mr. Chair. The committee, thank you all, passed this bill both last year and this year. The bill provides for a civil remedy to the victim of a hate crime. There are specified remedies within the bill, and because I know you all are very familiar with it, I won't take up any more of your time, but certainly would welcome any questions. And again, I thank you all for the good work that you've done on this bill and other legislation.
Any questions with regard to this, the identical bill that we've already passed? Seeing none, thank you very much. That
Good to
concludes
see you,
the
Mr.
testimony.
Chair. Good to see you, committee.
Good to
Thank
see
you.
That concludes the testimony on Senate Bill 5. I saw Senator Guile, Senate Bill 450, so we'll take Senator Guile now. Senator Guile, is this bill in the same position as the way that the House version of the bill left the House?
Yes, Mr. Chair. SB 450 is exactly the same as HB 323 that this committee already passed favorably and the House already passed.
All right, you want to give a quick synopsis of it?
Sure. So SB 450 ultimately protects tenants from eviction merely for calling emergency services. It also prevents landlords from writing into any lease agreements, any provision that would limit the ability of a tenant to summon emergency services.
All right, it's in the same posture as the bill that left the House. Are there questions for the senator? Delegate Bartlett, with probably an Anne Arundel County-related question.
You know me too well,
Happy
Mr.
to do
Chair.
so.
So, Senator, good to see you.
Good to see you too, Delegate.
Is this your very first time ever coming to Judiciary?
It
to
is
testify on the
indeed
bill?
my
Hi.
very first time coming to Judiciary, and it is a pleasure to be here. And thank you for the round of applause.
Well done. That was my question.
Oh,
Thank you.
well, thank you. Thank you so much.
All right, any other questions? Seeing none,
All
that
right.
concludes
Thank
the
you, Committee.
testimony.
Thank you, Mr. Chair.
Thank you. That concludes the testimony on Senate Bill 450. We're going to go to Senator Hedelman now for Senate Bill 100. Senate Bill 100. Senator, is this in the same posture as the House bill?
It is.
All right.
It
Give a
is.
quick-
Senate Bill 100 is the same posture as House Bill 36, and it is an agreement between Maryland Multi-Housing Association and the Public Justice Center. And what the bill does is, with some exceptions, it allows, it enforces licensing laws in jurisdictions where they have them. In order for a landlord to be able to evict, they must be in compliance with the license, with some exceptions if there are issues that are caused by tenants. So we came to a kumbaya after much negotiation. So I'm happy to report that both bills are in the same posture.
All right. Are there any questions for Senator Hedelman based on that information? Seeing none, thank you very much. That
Thank
concludes
you.
the testimony on Senate Bill 100. Now, we're going to some pieces of legislation that did not pass the House as yet. Senate Bill 351, Senator Washington, did I hear she was in the room? She just stepped out? All right. Well, we tried. All right, Senate Bill 252, Senator Carrozza, please. All right, we'll let you do the full hearing. Here you go.
Good afternoon, Mr. Chair and distinguished members of the House Judiciary Committee. I'm proud to be here as a former delegate, senator that represents District 38, and that's Worcester, Wycomico, and Somerset counties. And I'm here today to present Senate Bill 252 and ask for your support. This bill is intended to close a loophole pertaining to reckless or negligent driving regarding fatal accidents. Quite simply, to cut to the chase here, under SB 252, a person charged with negligent driving that contributes to a fatal accident must appear in court and cannot prepay the fine. As amended, a person convicted of reckless driving that contributes to a fatal accident is subject to imprisonment not exceeding 5 days or a fine up to $1,000 or both. A person charged with reckless driving, as you know, already is required to appear in court. And there is background. You all, I understand, have heard this bill in the past. It's been highlighted, especially with 2 victims, highlighting that fact that with these victims, on July 5th, 2019, Sherry Zoden and her husband Thomas were out for a late afternoon drive in Conowingo, Maryland, when they were struck head-on by an oncoming vehicle. Both Sherry and Thomas suffered severe injuries, and unfortunately, Sherry later died of those injuries. Her husband had to have his left arm and left leg amputated. To this day, the person who caused Sherry Zoden's death has not appeared in court, as it was not required. Travis Christian Butcher is the other person that's referenced in the bill. He was driving to work the day before Thanksgiving in 2016 when he was hit on Route 7 in Abingdon, Maryland. He had the right of way, but the driver did not yield to him, and after 3 days in shock trauma, Christian passed away from his wounds. He was only 19 years old, and despite a long rap sheet, the driver never had to appear before a judge for her actions. So this, I just want to be very clear, this bill is focused on a must appear if it's a accident involving a fatality, and that person who's charged with negligent driving would be required to appear in court. And then the bill's been amended that a person convicted of reckless driving that contributes to a fatal accident, again, I'm just tying this all to the fact that it's involving a fatality, that person would be subject to imprisonment not exceeding 5 days or a fine up to $1,000 or both. So that it's simply what the bill does.
Questions? I have a question. You said that it only if the accident results in the death of another would there be a 5-day penalty. I don't believe that that's what the bill says. I believe it says that it changes the penalty for reckless driving and requires a 5-day penalty for all of them.
Mr. Chair, you're correct. I'm sorry. My comments about the fatality would involve negligent driving.
Okay.
A person charged with negligent driving involved in a fatality.
If a person is charged with a crime that carries jail time, are they eligible for the services of the Office of the Public Defender?
Is that a suggested amendment?
I'm just asking.
I don't know.
Okay. We'll have to.
And
work on that.
I present this to the committee. I just, in a full candor, this was the first opportunity I've had to present the bill. I did not know until this year that a person involved in a fatality did not have to appear in court. It's the first time I learned that, and I offered to be the bill sponsor this year. I know that you all have heard this bill in the past, so the bill is in the committee's hands, and I appreciate any guidance and support for it.
I guess the other question is, in many counties across the state, state's attorneys don't engage with fine-only offenses where you don't have any jail involved. So the speeding ticket docket doesn't include a state's attorney. Now that this includes jail, I guess one of the questions is going to be whether there would need to be both a state's attorney and potentially defendant would definitely have the ability to have a defense counsel there, whether they would be eligible for the Office of the Public Defender as well. That could change the fiscal note probably substantially. But we'll take a look at that. Does anyone else have any questions? Delegate Conaway.
Thank you, Mr. Chairman. Thank you for coming in to testify and presenting the bill. I was wondering, the person that has to go to court, what are they going to court for? What are they?
Well,
what are
they would have been charged with negligent driving.
And so they're going to go to court to defend their charge or to explain to the judge what happened, or?
My understanding, it's when by being charged, it's a must appear in court.
Okay. Thank you very much.
Delegate Cardin.
Thank you. Just real quick, thank you, Senator, for bringing the bill. If in one of the unfortunate, tragic examples you gave, the person was injured and then later died, if there's a situation where a person is injured, but the trial happens before the person expires, this wouldn't be able to take effect because it wouldn't have caused, they wouldn't have known at the time of the trial whether it caused the person's death. Isn't that so?
The bill is tied to a fatality.
Right. So let's say that somebody's injured and they're in the ICU for 6 weeks. The trial happens after 4 weeks. The person pays the fine, doesn't appear, and then the person dies. What happens at that point?
I would ask for your guidance on what you think should happen.
We have to think. Okay, thanks.
Delegate Erican.
Thank you. Thank you, Senator, for bringing this bill forward again. I think, just to make sure I'm understanding, if the person is first charged with negligent driving that does not involve a fatality, and there is a fatality later, they could simply be charged with a fatality later. I believe that's the appropriate response. So that person could end up in front of a judge still.
I would think so.
I would think so, too.
Again, I'm very careful on this committee.
I know.
I am not an attorney.
Yeah.
But I come to you in full disclosure about my agenda behind this bill. I was absolutely stunned when I found out that, there was not a mandatory must appear. Mainly, for me, it was also about the victims and their families.
Exactly. So, yeah, thanks for bringing this bill. We really appreciate it.
Any further questions? Seeing none, thank you very much. That concludes the testimony on 252. We're going to go now to Senate Bill 540. If he's here, there he is. The bill from the Attorney General's office. We've just passed the House cross-file on Senate Bill 540, and I believe that the version before us of Senate Bill 540 is in the same posture as the House version that we just passed. Is that correct?
That's correct, Mr. Chairman. Hannibal Kemmer for the record.
All right. So this is the Civil Rights Enforcement AG's bill. Being that it's in the same posture, are there questions? Any questions? Seeing none. That concludes the testimony on Senate Bill 540. Thank you very much.
Thank you, Mr. Chairman.
Senator West, just that simple. All right, Senate Bill 446, decanting.
Thank you, Mr. Chairman. May I bring up my witness?
Sure.
And Sarah Call from the State Bar Association's States and Trust section, she's the chair. She can explain any intricate details of this bill. This is a bill that we passed unanimously in the Senate and was passed, this cross-file was passed unanimously in the House. It's called decanting. The Senate bill was passed with an amendment attached to it. The House bill, which we're going to vote on in my committee, Judicial Proceedings, this afternoon, we're going to add the amendment to my bill, to the House bill, to conform the two bills. So with that, should I explain, Mr. Chair, decanting a little bit? Okay. So a testator forms a trust, and several beneficiaries are named to the trust, and 20 years later, when the trust assets are to be given outright to one of the beneficiary has a problem. Either it's a drug problem, or a divorce problem, or a bankruptcy problem, or a gambling problem, and the trustee says, gee, if the testator were only still alive, he never would have provided for these assets to be given outright to the beneficiary at this time in the beneficiary's life. So what this bill provides is in trusts where the trustee has the power, the trustee can literally decant or pour into another trust instrument created by the trustee those assets from the trust that are supposed to go to the beneficiary at that point. And that way protect those assets from being dissipated if they were given outright to the beneficiary. 30 other states have decanting rules. And because in Maryland it's a little iffy as to whether you can do it, many people move their trusts to another state in order to take advantage to the other state's decanting rules. So this would put Maryland in the same position as the 30 other states. There is a uniform law recommended. This follows the text of the uniform law to try to make Maryland's decanting provisions very similar to the other states. So that's how it works. Now, the bill is 28 pages long, and so you can get deeply down into the weeds if you want, and that's why Sarah Call is here to answer your questions if you'd like to get down into the weeds. With that, I'll stop and take questions for both of us.
Would you like to testify at all, or you're just here for questions? And
Oh, yes, thank you. I appreciate the bill being passed and here for questions. Don't want to take your time.
all right. Any questions? Okay. That concludes the testimony then on Senate Bill 446.
Thank you so much,
Thank you
Mr.
both
Chair.
very much.
Yep.
All right, Senator Washington. Senator Carter. Let's go ahead with Senator Carter then. Going to be starting with Senator Carter with Senate Bill 851. It'll be 851, 97, and 291. Senator Carter, we're going to take your three bills, 851 first, then 97, then 291. So whenever
you very
you're ready,
much.
go ahead.
851, Mr. Chair and members of the committee, is a bill that you already passed the House version of. Delegate Terry Hill worked on this very diligently. I'm merely the conduit, but this bill is a product. It initially came out of the Attorney General's Task Force on Access to Justice, and then it became a mutual product of the Elder Law, Estates and Trust sections of the Maryland Bar Association. Over this 2-year period, they've worked on the bill, they've worked on amendments, and it's in the same form as you passed. It's basically a bill. The purpose of it is to allow individuals to use agents to help them get access to government benefits. I'm happy to take any questions, or I might have to ask for a lifeline if it's too complicated.
That's all right.
But I think it should be an easy call.
It's in the same posture, though, as
exact same.
as the House bill. Okay.
Yes, actually, the amendments came from here. We put them on and passed the Senate bill.
All right. Any questions based on the fact that it's the same bill that we already passed? All right, seeing none, that concludes the testimony on Senate Bill 851. Let's go to Senate Bill 97 now, please.
Thank you. Is this sponsor only, or do I get to bring up a witness? Or can I acknowledge a witness?
You can acknowledge a witness. That'd be fine.
Okay, I think John Giannetti is here, and
Great.
He's been working with me for about 3 or 4 years, maybe 5, on this bill. This is the bill, the Juror Reenfranchisement Bill. Both houses have passed a version of this bill in the past, but it's a very, very important bill because it would allow us to end discrimination against people that have paid their debt to society and stop prohibiting them from being eligible for jury service. Why is this good? If you're in a place like Baltimore, you have constituents, including yourselves, that are called to jury service all the time, multiple times, and they wonder, why am I always called? Well, if we could expand the jury pool and stop categorically denying these persons access to jury service, I think that would be a step in the right direction. But even more than that, we've restored the right to vote for people that have felony convictions years ago, and this is just, in my opinion, the final step. Most other states allow this, and as all of you know, there are attorneys, and also if you're not in serving on this committee, you know that in any jury selection process, there's a process called voir dire, where attorneys get both peremptory strikes and strikes for cause, and so most likely someone that is inappropriate would be stricken from the jury. Studies show that people are not necessarily biased in any way based on the fact that they have a prior conviction. And not to belabor this, but I really do think it's time for Maryland to get this bill passed. We don't deny any other category of people eligibility for jury service. We don't say because you've been a victim of a car accident, you can't serve on a jury where it's involving an accident. We don't say to medical doctors or professionals, because this is a medical malpractice case, you can't serve on the jury. We leave it up to the court to decide, up to the attorneys in the court to decide. We don't even say, if you've been found responsible in excessive force or you're a police officer, you can't serve on a jury. So I just think this is really an issue of fundamental fairness, and I would really ask for a favorable report. Mr. Chair, members of the committee, if you recall, the last time we sent the bill over, the Senate did put some amendments on the bill. I think that was part of the problem. We had amendments, you didn't have the amendments, and the bills weren't able to be matched up. But in my opinion, this is a step in the right direction. I'd ask you to support the bill with the amendments. The amendments just eliminate a few different categories of people unnecessarily, I think. But if you've ever been found guilty of witness intimidation or perjury, then you would not be eligible. Thank you very much.
Questions for Senator Carter? Seeing none, thank you very much. That'll conclude the testimony on Senate Bill 97. All right, now we do have witnesses for Senate Bill 291. And I believe they will start to come to the table. There's going to be a panel in favor and then a panel opposed. We're going to do the best we can. Frank Boston, Bruce Plaxton, Emily Malarkey, George Tolley, Kelly Donahue. If we need to add chairs on the sides, we're going to just need to do that. And Senator Carter, if you would like to begin.
Thank you, Mr. Chair. I promise to keep this brief because there are a lot of witnesses. Well, you passed this bill in the same form that it's in now, and we've passed the bill over. This bill is simply a bill that's about fairness to our constituents as well. It does basically would prohibit the use of clauses denying liability for different recreational facilities. It's my understanding that since we both passed the bill, opposition has sprung up. And that opposition, I believe, is primarily limited to health clubs. But I have done a scan, and I'm sure the other witnesses will talk more in depth about this, that there are other states that don't distinguish or carve out an exception, and there is no reason, in fact or law, to carve out this one exception. Basically, every establishment should be responsible for ordinary care, and if they don't exercise ordinary care, they should be responsible for their negligence, and there shouldn't be a way that they can get out of it by a clause that most people are required, that people are required to sign to participate in their business. So with that, I'll turn it over to the witnesses. Thank you.
Whoever would like to go next.
I think I'm going to begin. Thank you, Mr. Chairperson. I'm Emily Malarkey. I'm the current president of the Maryland Association for Justice. I want to thank this committee who previously voted this bill, the House version of it, out unanimously. We had 9 members of this committee jump on to co-sponsor the bill, including bipartisan support, and when it got to the floor, the vote was 135 to 3. The Maryland Public Schools have come out in support of this bill. There should be a letter in your bill file from MAVE, which states in their written testimony that this bill is needed to protect students, parents and guardians, educators, and administrators who are forced to sign exculpatory clauses and waivers. They're right. You were right several weeks ago. We don't think there is any reason for you to change your mind or your vote, and we ask you to vote yes again. In their opposition, what the health clubs who have come out opposing the bill are essentially asking you to do is to change your mind and give them special protections that would permit them to negligently injure their customers with no accountability. And I want to be very clear about what this bill does and doesn't do. So if you're familiar with some of these waivers, they're very long. Some of them are multiple pages. We are only trying to deal with one little clause, one little sentence in those waivers. The bill will not ban Maryland businesses from having people sign waivers. It will not ban businesses from warning customers about the dangers that they are going to encounter when they use the equipment, the facilities, or the recreational business. They are not prohibiting any argument in a subsequent lawsuit that the customer was contributorily negligent or assumed the risk of their own injuries. They are only, this bill is only designed to touch the one clause in these waivers that says things like, I agree that I'm giving up my rights and the rights of my spouse or children to sue for any injury caused in whole or in part by negligence. That's what we're trying to deal with today, and thank you for your support.
Okay. Good afternoon, ladies and gentlemen of the committee. My name is Kelly Donahue. I'm the current legislative chair for the Maryland Association for Justice. I apologize, I'm kind of leaning over my colleague here and not ignoring this side of the room. So I'd like to piggyback on what Emily said. All this bill does is say that a commercial recreational facility cannot, when they bring a customer in for business, they cannot waive away their liability if they negligently injure a consumer. And that should make sense, because if somebody comes into the General Assembly in the front doors of these buildings and there's water on the floor and it was there for 2 days and nobody bothered to clean it up and I fall and I break my hip, somebody is responsible for that. That's what the law in Maryland says, and this is no different. The opposition, the health services industry, the health club industry, they are asking you to include an amendment which says that this bill would not apply to health club services. The reason I am asking you not to honor that amendment is because when you look at the commercial law code in Maryland, health club services is defined so broadly as to not only include gyms, but to also include any physical culture service enterprise, which includes trampoline parks, amusement parks, and everything under the sun. So really what the opposition is asking you for is for permission to negligently injure their customers with no accountability. And that just doesn't make any sense. So as Emily mentioned, MABE has a letter in the bill file that says they think this bill is really important for the protection of parents, educators, and children. And I'd also like to point out in my last 12 seconds that one of the parties that signed up to oppose this bill, and this is just an example, is a fitness club domiciled here in Maryland. And piggybacking on MABE, they offer services for kids ages 3 and up. They offer after-school programming where they will transport children from schools to their club for after-school care. And following what MABE has asked, we are simply asking that they are responsible to 3 and 4 and 5-year-olds and adults and educators if they are negligent.
Thank you.
Thank you very much.
Mr. Boston, then if Mr. Claxton would switch seats on that side, then we'll do the same thing on the other side.
Mr. Chairman, members of the committee, I'm Frank Boston III. I'm here on behalf of the Maryland Association of Justice, but I also, in my law practice in this space. The committee has already spoken. It's basically the exact same bill that you voted on. The breakdown has already been articulated, but I'll repeat it. 22 to zip in this committee. Floor vote 135 to 3. Senate committee 9 to 2. Senate floor 35-11. This means bipartisan support. Remember, the bill does not waive away any affirmative defenses. So assumption of risk, contributory negligence are still there. The bill does, and this is important, it does not waive away indemnity clauses or hold harmless clauses. They still exist. As Emily said, it's a one line basically saying you can't waive away your negligence. The opponents will argue that this bill should be limited to children, or they may even argue that gyms should be exempt. But if you are at a gym and the ceiling comes crashing down on your head, you should be able to recover. If you're in there overexerting yourself and you're lifting weights and they're too heavy, you're not going to be able to recover because that's on you. But if the negligence of the facility, you should be able to require. And I think it's important to reiterate that, we're not trying to get rid of the whole waiver. So you're going to hear in testimony about insurance and how insurance is going to increase an exorbitant amount. Yes, maybe if you got rid of the whole waiver. We're talking about the one line, the exculpatory clause that says that they can't waive away their negligence. We ask that you continue to support this bill as a favorable. Thank you.
Thank you, Mr. Chair, members of the committee. I want you to imagine a world where you deal with immunities in this committee a lot, that the health clubs come to you with a bill that says, we'd like you to pass immunity so that anything that happens at our health clubs or our facilities, we're not responsible for and we're immune from suit. You would not pass that bill, but a no vote on this bill is equivalent to passing an immunity, a blanket immunity for health clubs and health facilities. I want to give you an example of a case I had as a young lawyer, a roller coaster, where is an amusement park, where I had a teenager who was in a roller coaster and the strap came off because it had not been put, they had not put it in deliberately because they said in deposition it would slow down. We couldn't get as many rides in per hour, and we make more money if we don't strap people in. So my teenager flew out of the scrambler and was laying on the track while the car was whipping him around and repeatedly hitting his head until he broke his neck. And if you vote no on this bill, there'll be no recourse for people like that, or zip line accidents, or any type of catastrophic injury. So keep in mind, a vote no on this bill is a vote for immunity.
And the world does not become safer at all when you give out immunities. Go ahead, George.
Thank you, Mr. Chairman and members of the committee. I want to pause and thank Senator Carter for bringing this bill over from the Senate, and I want to thank Vice Chair Moon for sponsoring the House version. And I want to thank the members of this committee that signed on as co-sponsors. Mr. Plaxton just mentioned, if the fitness club industry came to you and said, we want immunity from responsibility for the consequences of our negligence by law in statute, my hope would be that this committee would say, no, you shouldn't be treated differently. You shouldn't get a free pass. What they've got, however, by contract, is they're making an end run around the legislature and saying we can get immunity by putting it in the fine print. And that fine print loophole is what they're exploiting. The amendment they have offered wants to put the fine print loophole into the statute books, that they can continue to use that fine print loophole to avoid the consequences of their own negligence. We're not taking away anything else. Contributory negligence, assumption of the risk you've heard, all of that is still a defense. But responsible fitness clubs, responsible businesses in Maryland who don't cut corners on safety, they will continue to be in business and act. This isn't going to affect any of them. If insurance costs are so much higher without these waivers, we would have to look at a state like Virginia. Virginia has prohibited these waivers as a matter of public policy since 1890, more than a century. In Virginia, they have fitness clubs. They have the Y of Central Virginia and the Y of the Peninsula Islands, and they offer summer camps for kids, and they offer all the amenities that we in Maryland have come to enjoy. They can do those things at the same price or cheaper because their insurance isn't 5 times more expensive than the insurance in Maryland. That's a red herring, and we ask you to resist the amendment and continue to support the bill. I apologize for going over, but thank you very much.
Questions now, Delegate Arikan, then Cardin, then Bartlett. Arikan.
Thank you, Mr. Chair. Thank you all for being here today, and thank you, Senator, for bringing this bill forward. So I just want to touch on a couple things. I know it was mentioned that there's still liability protections for these recreational facilities. Can you just touch on what those are still that exist? I don't know if, Kelly, you want to do it? Ms. Donahue?
Thank you, Delegate Arikan. I appreciate the question. And yes, you're absolutely right. So even if this bill were to pass, health clubs, recreational facilities, all the like, they still have the benefit of what's called contributory negligence. Maryland is only one of 5 states to have contributory negligence. If the plaintiff is even 1% negligent, there is no recovery. That's a huge incentive for fitness clubs if the argument is that their insurance rates will increase because of the passage of this bill. Maryland is one of 5 states that imposes one of the strongest liability protections. Piggybacking on that, when you look at Planet Fitness and LA Fitness in Maryland versus Virginia, where Virginia doesn't allow these exculpatory clauses, if there was truth to the argument that insurance rates will increase for fitness clubs in Maryland by passing this bill, presumably membership rates would be higher in Virginia. And when we did the research, I actually have it with me, the membership rates for LA Fitness and Planet Fitness in Virginia are the exact same number as they are here in Maryland. So there is no basis for an argument that insurance rates will be higher by passage of this bill. And even if this bill is passed, fitness clubs here will still have the benefit of contributory negligence. They'll still have the benefit of assumption of the risk. They can build into their waivers, as they always have, that clients assume the risk of the, of the activity in which they're engaging. And plaintiffs still would have the burden of proving that their injury is the result of negligence. You don't win as a consumer just simply because you're injured.
Right. Yeah, that was my question. Yeah. So if, for example, someone was misusing a machine or was running by a pool, those kinds of situations, we want to make sure the facilities are not being sued for those kind of situations.
That's exactly right. And so if you have a consumer that's misusing a machine or is running by the pool, Well, that's the consumer's fault. And under Maryland's contributory negligence law, there is no recovery.
Right, and the difference between many other states who have some version of contributory is that here it's, you get nothing.
That's
Nothing.
correct.
And in other states, there's a sort of percentage sometimes, but in Maryland, you are out on your own.
Correct.
Yeah, okay, thank you. And you touched on my other question about the insurance concerns, because we have heard some concerns about insurance rates increasing, but what I'm hearing is that that's not really panned out. It's more of a sky is falling situation.
Well, I think that's exactly right. And, you know, the YMCA example that George gave, you know, Virginia doesn't allow exculpatory clauses. Maryland does. The membership for a YMCA in Maryland is more expensive than in Virginia.
Like everything.
And not only
So-
that, but Virginia doesn't even cap non-economic damages for health clubs the way
Wow.
Maryland does. So,
Wow.
and still, the Y of Central Maryland's membership rates were cheaper at every membership level.
Oh
They still sponsor summer camps. They still do all these things.
Yeah.
That's not consistent at all with the idea that insurance rates would be significantly higher if these waivers were not allowed.
Right, it won't be prohibitive. Okay, thank you guys very much.
All right, delegates Cardin and Bartlett and Phillips.
Thank you, Mr. Chair. Thank you all for coming in, and I'm a proud co-sponsor of this legislation. And Ms. Malarkey, you actually, I think your office is about 300 yards from my home. And so I'm a little bit familiar with some of your practice area, but I think, Frank, we've actually discussed this a little bit. Can you give an example? First of all, I'm amazed that exculpatory clauses have been deemed to be enforceable, but can you give an example maybe in either your practices or maybe anybody else in their practice of where you've had a case perhaps with either a fitness center or where you can give us kind of so that maybe we can talk about this with the opponents when they come up?
Yeah, absolutely. I actually had a case in a fitness center where the gentleman was working out. He was lifting weights, and the machine broke and fell on him. Okay, and you know, it wasn't intentional. The machine broke. Okay, but the gym had the waiver, and when we brought the suit and we were negotiating and everything, the waiver became an issue. I was scared to go to trial because of the waiver. We ultimately settled, but I had to settle for a lot less because the waiver was sticking out there, and I was afraid that I could lose on a motion to dismiss. And so, you know, it was a compromise settlement as a result of specifically because of the exculpatory clause of the waiver. Now, in that same example, if he would have been overexerting himself, lifting too much, and pulled the muscle, that would have been on him because he assumed that risk. And this bill doesn't take away that. I mean, it's a resounding theme you're hearing over and over again. It just says if there's the negligence of the facility, just like in that case where the machine broke and came crashing down on his chest, they should be responsible. And I take it one step further. They should want to be responsible.
Delegate, I handle a lot of these types of premises cases, and we just concluded a case where a young boy was at one of these play parks where you take your children, and there was broken metal on one of the pieces of equipment he was crawling on. The facility knew it was broken. There had been repair orders put in, but they hadn't put in. And he got horrifically injured on this piece of metal and lost a testicle, and there was a waiver where they denied liability, even though they had notice of the defect, and the young boy lost a testicle. So, yeah, it comes up more than you think. Sorry.
It's okay.
Thank you, Mr. Chair, and thank you for bringing this legislation. It's interesting to me that we've had such a firestorm in between, and folks have come out. Help me with the reality in terms of exculpatory clauses or limited liability clauses, not necessarily just with this, but how it works in the real world. And when is it appropriate and when is it not? Because in my mind, here, it's not appropriate. So let's be clear so we can understand it as well.
So the now Supreme Court of Maryland, okay, has said that Maryland citizens can enter into a contract to do anything they want. We're going to enforce those contracts as long as the contract is not void as against public policy. Specifically, when it's considered cases involving facilities like the ones we're talking about, it has said it's not void as against public policy. You can choose to walk away and not enter that business. We're going to enforce them unless the legislature tells us that we can't, because it's now the public policy of this state that they're not enforceable, and that's what we're here to ask you to do.
And so it's incumbent upon us as public policy to make sure the citizens of Maryland are protected from clauses in which they have no control.
That's right, and the legislature has done that in other contexts. So there is a statute already on the books with respect to commercial and residential leases that says when you sign a lease, you cannot put a clause in the lease that exculpates your landlord from liability for negligence. I actually got into a fight with our business landlord because he tried to put one of those in our new office, and we had to tell him that no, the legislature said you can't do that. So there's precedent here in the state for you to do it in this context. You know, we theoretically, Target or Walgreens or Starbucks could make you sign a waiver to walk into their facility and buy a cup of coffee or a jar of peanut butter. They don't, probably for good customer relations, but if they did and you were injured because you slipped on the water, then that case could be taken to the court and an argument could be made that that waiver is enforceable because it was not void against public policy. So, you know, in the context of lawyers and doctors, you know, I don't put in my retainer agreement, you can retain me to be your lawyer, but if I'm negligent, you can't sue me for legal malpractice. I don't go to the doctor and sign a consent form to have a surgery that says I'll agree to this surgery, but if the doctor messes up and I die, my husband can't bring a lawsuit because I've waived away my claim. This is just no different.
Mr. Chair, one more follow-up. In this day and age, often as we are signing up to jump on a trampoline or to attend an amusement park, we're doing a lot of things in an automated fashion today, right? Mm-hmm. Where do those waivers show up often?
Yeah, that's a very interesting question. So some of them are still a piece of paper that you sign. Many of them are actually online. So as a mom, and I don't know if any of the other parents in this room are aware of this phenomenon, I literally just the other day got an email from Sky Zone that said, your family's liability waiver is about to expire, click to renew. And I'm not kidding you, and every birthday party that I send my kids to, I get an email from the other parent that says, to come to the birthday party, please fill out the electronic waiver. And then it's on file in their facility forever. I have one that I brought to share with you today that literally says when you sign this waiver, it is valid not just for the day that you're coming into our facility, but for any future time you ever come back. And it's the click of a button, and all you have to do is scroll down to the end. And
I think you've answered my question.
Thank you. As you can see, I'm very passionate about this issue.
Thank you, Mr. Chair, and I'll be brief. I want to exercise this muscle briefly because I found out exactly how many gyms I have in my district, and I've actually managed to talk them back from the edge a little bit. So this only applies in cases where, frankly, the negligence is there. There's a part that's in use outside of its window when a pulley breaks. A machine is constructed outside specifications. They're required protective gear that should be there that's not there per the manufacturer. Am I ballparking this right?
That's right. Yep. That's exactly right.
All right. Thank you so much.
Yep.
Seeing no further questions, thank you all very much. We're going to go to the panel in opposition now. Mark Miller, John Favazza, Patrick Connolly, Michael Johansson, Keith Rawlings, and Mike Gazinski. 6, we're going to need the same number of chairs up there, so just leave the chairs and we will load everybody in. I see 5, I called 6, so that's fine. If there's somebody missing.
I don't think so.
Okay, that's fine. Happy to start. Whoever, Mr. Favazza, go ahead.
Thank you, Mr. Chairman, members of the committee.
John Favazza from Manus Cannon Associates. I'm here today on behalf of the Global Health and Fitness Association. We're in opposition to Senate Bill 291. I'm joined by Mike Kaczynski from the association, Keith Rawlings from the Arena Club in Bel Air, Mark Miller from Merit, and Mike Johansson from the Rifkin firm. Our members are here today. They're going to go through their commitment to creating healthier communities, increasing access to physical activity, and we just need to tell you how this bill is going to threaten our ability to continue to do so. Our facilities are primarily adult-oriented facilities. They're membership facilities. There's options for the consumers to come in. They take a tour. You get to talk to the staff, you know, and get a feel for this facility that you are entering into a membership agreement with, right? This is not a trampoline park that mom and child are walking into cold for the first time and, you know, have a liability agreement thrown in front of them in a place that they've never been before. We do have an amendment, as was mentioned by the prior panel, to address our concerns. Sellers of health care services have been regulated by the Consumer Protection Division of the Attorney General for 40 years. They look at our contracts. They look at the terms of the agreement. If there's upfront payments, we can be bonded. There's contract renewal. All these issues are filed with the AG's office, and you know, our amendment would say that for these healthcare services or health club services entities that do this, they would be exempt from this bill. Trampoline parks do not register with the Office of the Attorney General for under that program. Finally, this is a very broad bill. There's defined terms and exemptions that are frankly circular. There's undefined terms in this bill that are defined in other sections of the code, and the scope and intent is, frankly, it's confusing. You know, one example I can talk about is commercial. There was a lot of talk from the prior panel about these agreements are void against public policy in every instance. Well, guess what? This bill exempts all kinds of agreements from the scope of this bill. This bill does not outlaw liability waivers. It picks some and exempts others. It says in this one circular definition, I won't go through all of them, but recreational facility means a commercial or recreational facility. That doesn't really help me understand what a recreational facility is. So commercial must have meaning. So that must mean someone's being exempt from it. Some place that you are going to visit, some place you're sending your child, some place you are going to do some sort of recreational activity that isn't commercial, but waivers are okay in that instance. Thank you, Mr. Chairman. We appreciate the opportunity to testify today. I'll turn it over to Mike Kaczynski.
Mr. Chairman. Mr. Chairman.
Don't touch it.
Mr. Chairman, members of the committee, my name is Mike Kaczynski. I'm the Vice President of Government Affairs for the Global Health and Fitness Association, and I urge your opposition to this bill as currently written, eliminating the ability for small and medium-sized businesses to obtain insurance and to operate in the state. As written, the legislation puts the industry at risk of unrestricted litigation exposure and opens the door for frivolous sue and settle actions, ultimately leading to increased operating costs and putting upward pressure on affordable access to physical activity, which, as you know, significantly benefits mental and physical health of the state. Maryland health clubs and studios are diverse as the communities they serve, ranging from small studios and low-cost national chains to premium regional and national brands. Statewide, some 700 facilities serve more than 1.1 million residents and employ nearly 30,000 Marylanders. Many are coaches, trainers, class leaders who work part-time during school for extra family income or to support career passion. Our members appreciate the bill's intent of protecting safety and are good actors in this, providing safe environments for consumers to pursue a healthy lifestyle. Unfortunately, the bill does not take into account private membership organizations that establish an acknowledgement of risk, are not open to the general public for free use, or do not offer the types of use referenced by earlier testimony or in earliest hearings. Further, the bill exempts these activities on government property, which is unfair given the wide array of gym and studio-type facilities and classes offered by local governments across the state. Enactment of this bill without revision would cause small and independent clubs to close or require price increases, making their health benefits inaccessible to the communities they are specifically designed to serve. After years of inactivity and impact from COVID-19, when the industry faced decimating losses due to closures and Marylanders were unable to access the industry's health benefits, we urge you not to compound the impacts of mental and physical health by removing affordable access through this bill. We have prepared an amendment, as mentioned, for your consideration, and we look forward to answering your questions.
Yes, hi. Thank you, Mr. Chairman and committee members. So my name is Mark Miller, and I am the Chief Operating Officer of Merit Clubs in Maryland. We have 9 locations, multi-purpose fitness centers, service about 34,000 members, have about 1,200 employees. And I'm here to kind of tell you a little bit about the opposition to the bill. We're not roller coasters. We're not amusement parks. We are facilities that provide health and wellness. And during COVID, we were regulated. We were constantly regulated. We have health departments that come in on a regular basis. Our slides are inspected. We have fire marshals that come in. All of our employees are certified. We carry AEDs. We do utmost safety. And during COVID, we actually were able to share with the governor and our county executives how we were safe facilities and how we stayed open and had the lowest transmission rate. Again, we're not the trampoline parks and things of that nature. What we provide is a member experience that's onboarding, that focuses on mental health and well-being, that focuses on socialization and community support. And, you know, we're asking for you guys to make this amendment, not to just support us, but to support your constituents, to support the public, right? Because these are public facilities. During COVID, when the city couldn't open up their pools, we stepped in and tried to offer to help them, to train their staff, to give them our safety protocols and all that stuff. Now, that didn't go into effect, but we offered it. And why would they be excluded and not us? Why is it okay for them when you bring your children to those facilities that could potentially endanger them when we take all the safety precautions? We measure things, we do inspections, we do walkthroughs, we have repair and maintenance logs, we keep track of everything in our facilities, and we do the utmost to make sure that members know how to use the equipment through an onboarding process and doing all that. Where when you go to a trampoline park or a roller coaster, they don't teach you how to use the equipment. We do. Thank you for your time.
Hi, Keith Rawlings. My wife Kathy and I appreciate y'all's time and taking a chance to hear our concerns. My wife Kathy and I own the Arena Club. It's an 80,000 square foot facility in Hartford County. We serve you know, from preschool age to seniors. We have a physical therapy business on site. We take safety very serious. We were just talking about the water slides. We have water slides at our facility. We had contractors out replacing some bands yesterday because the health department came out and said we want those replaced. So we called the manufacturer, got them replaced. Contractors there. I'm the one that climbed in the slide yesterday because I want to make sure there's no metal shavings. I want to make sure that when you go down the slide, there's nothing you hit. So we take it very serious, and through the grace of God, we haven't had any serious injuries. I pray every morning for our pools and protection. You know, the biggest concern is rising costs. I did talk to my insurance provider on the drive down here. We currently have 2 carriers right now that are interested because we have a lot of services. We do flag football, we do indoor turf field, we have basketball. We're a full service club serving many people. Two carriers have interest in insuring us. We were talking about this bill, and he said, Keith, you're going to be lucky to have one at the end of the day. So I seriously ask you to consider, you know, protect us. We had a member that bent down on as a treadmill 10 years ago as it's moving. She tried tying her shoe, okay, fell off the back. Are we negligent there? No, but we had an attorney sue us and said we were. We had cameras, thank God, that showed that she just, in the middle of working out, she bent over to tie her shoe. So I guess the big thing is, you know, the waiver is an issue, I understand, but there's 2 sides of it, and we really appreciate your consideration of that. Thank you.
All right, we're going to go to the person who's on virtually now, Patrick Connolly. He'll get 2 minutes. I'll ask the 2 of you to switch on the end here. Just the 2 on the end, Mr. Palazzo and Mr. Johansson. Ask the 2 of you to switch. All right, so Patrick Connolly now for 2 minutes, please. If you can hear me. You're on mute, though. You're going to need to unmute yourself. There you go. Off you go.
Mr. Chair, thank you for the opportunity to speak to you in front of your committee today. My name is Patrick Conley. I represent Self-Esteem and Public Affairs Department, which includes our signature brand, Anytime Fitness. In Maryland, we have 16 franchise owners that represent 20 locations with nearly 14,000 members. Our franchise and small business owners are the true definition of entrepreneurs. taking on greater than normal financial risk to operate their clubs. Their entrepreneurial spirit was evident over the past 3 years, trying to navigate through the unfair times during the pandemic. Our franchise owners not only care about the health and fitness of their members, but the health and well-being of the communities that they opt in. I want to lend our voice in support of URSA and the other bills in front of you today. We are asking for this amendment to nullify the use of liability waivers. Legislation is passed in its current form. It will result in significant frivolous lawsuits and increased insurance costs, adding unnecessary risk to our small business owners that are already taking risks to stay open. We support the request to amend this legislation, specifically exempting the health clubs as defined under the Maryland Code of Common Law, Title 14, Subtitle 12B. Mr. Chair, unfortunately, one of our colleagues in the industry was unable to register for today's hearing, and I wanted to make sure that you're aware that Eric Linseth from Lifetime Fitness is also in support of this amendment. Lifetime has 4 clubs in Maryland with 630 employees and 30,000 members. Mr. Chair, members of the committee, thank you for your time today.
Mr. Johansson, please.
Thank you, Mr. Chairman. I'm Mike Johansson with the Rifkin firm. The proponents didn't talk about what the Maryland courts have really held for the last 150 years, where they've said exculpatory agreements are okay, unless the legislature acts, and we appreciate that's your policy decision, as long as they're unambiguous, and it's not an essential service such as a utility that they're the only provider. It would be unreasonable, unfair for them to require that. But this industry has existed with all the cases and all the problems that apparently have arisen under that same standard, and the courts have repeatedly said it's not void against public policy. What you see here, then, is not us asking for anything. We're not asking for you to pass a bill. We're asking to maintain the same legal standard that's existed in this state for 150 years. The fact that the Virginia courts have seen different, that's their courts that have decided that. Maryland would be in the minority of states, the vast minority, if you legislatively pass this. We have support from the Maryland Association of Counties, the school boards, and MML. They're all exempt from the bill. Sure, they're going to support it. And their actual amendment still allows the individual contractors to have waivers signed on their property. They won't be sued. I'm not sure they were going to be sued to begin with. I'm not sure they ever use waivers. But if they have a football camp at a public high school run by the coaches who are being paid, I assume that's commercial, they can still have all the students sign waivers. Does this bill limit the bar that has a riding Bronco? You have a couple beers and you can ride a Bronco and you can still sign a waiver, an exculpatory agreement? This is not a complete review, and what we're asking is maintain for us how we've been regulated for the last 150 years. Thank you.
Thank you, Mr. Chair. This question will go to those that actually own clubs. Okay, because I'm a business owner too, so whenever there's something that comes along that I think my costs are going to rise, that enhances my spidey senses, so to speak. So I really want to be careful here and make sure that I understand your business. Do you have waivers now? You do?
Yes,
now,
we're a privately owned club. My wife Kathy and I, we own the Arena Club, and yes, we use waivers now.
Okay, my husband and I are in business together too, so I completely know what that's like. In your waiver, is there a clause that says your client or your member can't sue you if you are negligent?
To my understanding, I don't have that waiver in front of me, because I used the example of the lady bending over as the treadmill's moving. We were sued, so
Right.
I think,
But because you weren't negligent,
correct. And we had videos showing that
Right.
she actually shouldn't have done that. And I guess my fear is of something like this, am I going to be negligent the next time someone bends over as the treadmill is moving? Do I need to have signs saying, please don't tie your shoe when the treadmill is moving or you'll fall off the back? I mean, that's the kind of stuff that I think that go deeper in this and some examples, and you'll see where we're kind of coming from.
Yeah, and I think the way I understand the bill is that it's just that language that would be taken out of the waiver. You still have the opportunity to have a waiver signed, but that language that says you can't sue, I mean, you can't waive away my right to sue if the facility is negligent. Is that the way you understand it?
So I think going back to what we were trying to say is, so we've been operating like this way. So Merit Clubs, we've been in existence for 46 years, and we've had waivers this entire time. And sure, we've had our lawsuits, and sometimes they weren't even our things. We had we kicked an individual out because they weren't following the mask mandate that was given by the city mayor, and we asked him to leave the facility, and he sued us for $10,000. And, our concern is that when you change what's already in establishment and already working, what it does is it opens the door for other frivolous lawsuits on every little thing, right? My car got damaged in the parking lot. I bent down on a treadmill, got injured. I reached over and strained myself. And, it does happen, right? And we had a lady who fell off the curb, and she tried to sue the city because the curb height wasn't the right height, yet the city approved all the curb heights. Then she tried to sue us because we put the curb in, and, the insurance companies then end up settling, and what ends up happening is all of our premiums go up, and then our costs have to go up, and we end up putting things out of reach for the public to actually improve their health and well-being and their mental health. And so that's why we're just asking for it to stay the way it's always been, because our contracts and our liability waivers that are in our contracts do have to go to the Attorney General's office, and they have approved them for the last 46 years, at least at my clubs.
And one item that I would add there is that if you look at similar states that have done this, so you look at New York, which I believe the bill has been amended to reflect as well. We hear from members in the state of New York that since that has gone into place, the insurance companies themselves are not even investigating the issues of when the lawsuits are being brought. They are simply settling and passing that through premiums onto the club owners themselves. So that's where the concern comes. So if you look at the barrier to entry from business operation perspective, you look at the small and medium-sized businesses, you look at the woman that wants to create her lifelong dream of a yoga studio, right? The barrier to entry is already so high for small business owners in the United States and for small business owners in the state that by putting this in, when they go to get those insurance policies to cover their business, to perform their lifelong dream, they're already unable to do so or unable to get insured at that point. That's what we're concerned about, and that's really what we're worried about here today.
Gonna go Grammer, Kaufman, Tolles, Cardin, Phillips. Grammer.
Thank you, Mr. Chair. Very briefly. So I have a 2-year-old and a 6-year-old. I've signed these agreements several times. There's a place on 40, 43. There's actually a jungle gym up in White Marsh. I think we're coming to Arena Park next. I also take my kids to playgrounds, public facilities, local county jurisdictions. Mr. Favazza, I think you mentioned the facilities that are excluded from these agreements. But I can't think of another example of a public facility that uses these kind of agreements. Can you?
Well, sure. So I think my concern is the way this bill is drafted. I assume words are intentionally used and they have to have some sort of meaning, right? So there was a Court of Appeals case, right, about one of these waivers about 10 years ago, and it did discuss this sort of definition of commercial, right? So, and the Court of Appeals speculated and didn't really come to a conclusion about what it meant. And here's a bill that just says commercial, right, without any clarity attached to it. So, a couple of examples. My daughters volunteer at a camp every summer at their church. You have to pay to send your child to this camp, right? It's the Catholic Church. It's the Archdiocese of Baltimore. Is this a commercial enterprise? Maybe, probably, right? Was that intended to be included in this bill or excluded from this bill? I don't know. The Court of Appeals mentioned like the Boy Scouts or the Girl Scouts. Is that included in this bill? I don't know. Right? So I think some of these definitions in the bill sort of are inexact, right? And I think raise questions where, we're sort of being, today told this applies to us, and they're being applied to us because these waivers are totally against public policy in every single instance, and it seems like there's some instances, in fact, when this bill is still going to allow them. So that's our concern, is sort of the vagueness of this language. The government exemption is very confusing for a number of reasons. It exempts a lease. Recreational facilities not including a unit of state or local government that leases land or facilities to a recreational facility. Well, we sort of know what a recreational facility is from the definition. What if they lease it to a person? What if they lease it to the coach? Hey, you can use the field and you can have the camp.
I get that.
Is
and
that
that's
clear?
What
I just don't know.
Yeah, and I'm trying to suss that out from you. So, for example, I take my kid to Angel Park up in White Marsh or Perry Hall, whatever it's called now. I'm inclined to say if my kid got hurt there, and it was negligence, I should probably be able to sue. But they don't require me to sign one of these agreements. My kid goes to Rosedale Baptist. They do all kind of services all over the place. They do all kind of activities. I'm never required to sign one of these agreements. And while we might look at the definition and say it's a little wonky, well, I mean, tell me how it needs to be fixed. Who else uses these agreements that we need to consider?
Well,
because that's the question, right? Because I'm a dad, that's kind of how I'm coming at this.
Well, and I think to jump in there, I think one of the examples that we're using are items that are open to the public without agreement to begin with. There is an agreement and assumption of risk upon going to the clubs and using the clubs in general. You go and you sign up as a member. These are not open doors for free public access. Your child cannot walk off the street and jump on a treadmill. These are agreed into contracts with a member service with the assumption of risk in mind.
Okay. All right, thank you.
Two brief questions. Thank you. First of all, Mr. Favazza, welcome back to the House. You're a former Chief of Staff to the late Speaker Bush, so it's always nice to see you. Send my regards to your lovely wife. My question, though, is I understand that I understand the anxiety that I'm hearing from your clients, the fitness owners, but I'm afraid I do not really understand it, because you've just heard from I empathize because anxiety is my middle name, but I don't understand the anxiety in this instance, because you just heard them say that that in Virginia they already have this, and I don't read about massive gym closures or so-and-so pool shutting down in Virginia. So why are we so concerned that it's going to be catastrophic in Maryland when it hasn't been in Virginia? And then my second question, sir, is were you guys at the first hearing? Because I must admit, I'm a little bit annoyed because this is the first time I'm hearing from you all, and it's 12 days till sine die. So did you all come to the first hearing and I just was out that day or something?
So in terms of the hearing, you're right. We weren't here. We're here now. Session is not sine die. So yes, in a perfect world, we would have been here sooner. And we're very grateful to the chairman for granting us the courtesy of a hearing today so we could express our concerns on the bill. In terms of Virginia, look, I think as Mr. Johansson pointed out, this has been long settled law in the state of Maryland for generations. And businesses here in Maryland, when they're making these investments, made these investments based on a certain set of assumptions, right? In terms of what their sort of ongoing, costs of doing their business will be. So, different states do things differently. Business owners go into business with their eyes wide open and figure out how to manage those costs and how to manage their business. This is a dramatic change in Maryland law that's taking place. And as I pointed out, the bill is imprecise, to put it mildly. And, we just urge the committee to take a careful look at our amendment and carefully go back and look at this bill and really think about, is it doing what you intended to do?
And if I may jump in, one item that I would add is that there's a real-time example of this going on right now in the state of Oregon, where the courts have nullified the use of these waivers for all outdoor and indoor recreation. As they've proceeded this throughout the year, over the past year and a half or so, there have been outdoor recreations that have ceased to exist, clubs that have began to close, and groups that have begun to just shut their doors because the cost of liability insurance and the cost of interacting with the lawsuits that have come through is too high and too great of a risk. So I would caution as well to please take a look at what's going on in Oregon and the work that's going on there as well.
We'll just agree to disagree because the sky hasn't fallen in Virginia, but I thank you all.
Thank you so much, Mr. Chair. Thank you all for being here. I will admit I am a co-sponsor added on during our House hearing because I think this is a wonderful bill. So I will come to you with some questions where I am in a friendly disagreement. And so I have a rhetorical question and a non-rhetorical question.
Will we be able to tell which is which?
Probably not with me. Right. So the rhetorical question is, do you agree that our fitness centers are essential to our lives?
I would answer that with a resounding yes, and I think we proved that during COVID.
So the gentleman right here said that when you have a utility service and other services, they are essential to your life. So they can't make you sign a waiver to say, hey, for whatever reason, for utility or other essential services, the court doesn't make you sign a waiver.
Correct.
So if this gentleman that's on your panel agree that's essential, then you should not need to sign our individual, consumers should be able to not have to feel like they can move about, enjoy your health clubs or any other facilities that you're here representing without any type of waiver.
It's actually a great question. Thank you. So when the court used the phrase essential services and they mentioned a utility, what they're talking about is a consumer doesn't have choice. So, for example, if you have an electric utility
So
that
let me
serves
back
your
up
house.
and say, I know what you mean. I have a
Correct.
little legal background.
Correct.
So I don't kind of need that. But that was the non-rhetorical question.
Okay.
I mean, I'm sorry, that was the rhetorical question.
Okay.
Confusing
Thank you.
myself here. So the other question I have is a more sort of process question. Can any of you all explain to me what is the process? What is your normal sort of course of business for having inspections done? Are they pop-up inspections? Are they inspections that, it's once a month, it's 30 days? And I want to know, you have a small business, which is great, but also for your business and also for the bigger chains, like a Planet Fitness, LA Fitness, or whatever, do they do pop-up inspections? Is it planned inspections? What is the process for that to occur?
So every year we run a very large summer camp. We average about 250 to 300 kids a week. And we are regulated by the health department of Harper County. So they'll come in and they'll look at our facilities. They will go through all of our emergency procedures. We do get random visits by the fire marshal, just going through the facility, making sure push bars are working, alarm systems are operational. So our inspections, happen a lot. The health department, we're in a situation where we're also monitored because we're on a private water system. So our water is monitored, our discharge of our septic system is monitored. So we have a lot of contact with, regulations of what we do at our facility.
We are very much the same way. So all of our summer camps are state accredited, and so we have to go through an entire inspection process, and it's random. It's surprise during the middle of the season. We have to put all of our waivers, liabilities, everything into it so that they can see it, they can inspect it. Sometimes they come twice a season. We also have AEDs that we check daily and have a whole inspection log, and then they get inspected as well. The fire marshal shows up when they want to show up. They're random. Same thing with the health department, the liquor board, any of those types of things. We have no recollection of when they're coming, and they just kind of walk into the facility and the inspection happens. And then we get a report, and obviously, you know, if there's anything of issues and all that, we have to rectify it immediately in the moment. We also have a preventative maintenance team that we ourselves take inspection to the next level, where we use a Connect 2 platform, and each shift we have a manager on duty that is doing shift reports where we log everything. So if a dryer breaks down, if there was a kid that got injured, we do an incident report. We do all different things and everything. And then in addition to that, we do run code ATOM drills. We have active shooter programs and all those things so that we take safety as the utmost priority.
But would you agree that there are chances where, or situations where you could have a treadmill that the tread is not as strong as it should be, or, you know, some other, you know, situations going on with the equipment? Do you agree that that is a possibility? We heard from the previous panel that there was a case, I think Mr. Boston indicated that he had with the client that obviously had some issues with the machines. Do you agree that you all are just, you know, stellar pillars of the community, but you could have situations where that occur? Do you think it's fair that, and I will be unapologetic about, I am really concerned about those individuals who cannot afford to have representation and be able to afford an attorney or take the time to sue if something does go wrong. So they just have to sort of deal with whatever situation that unfortunately happens to them. So do you agree that there are situations that could occur with equipment?
I think situations can occur in anything. You know, Delegate Graham over here, when his child is on the swing could break at a public playground, and he could get injured and end up suing the child, right? When you go in for surgery and you sign a liability waiver for surgery, that's essential, and something goes wrong, a malfunction of a machine and all that. So yes, anything can happen to any of us at any moment in our lives.
I think where the question comes down to is with the writing of the bill as it currently stands. As Mark mentioned, those items can happen, and they go through, and you heard the processes that they go through to ensure that they don't internally, and that they work to in the inspections that they go through from the state themselves. What we're afraid of is because of the ambiguity in the bill, that when these situations do arise, because of the drafting of the bill and because of passage of the bill, it will eliminate even the inspection and investigation as to if that negligence even exists. It will immediately cause settlement from the insurance companies, and those premiums will be passed on to the business owners, as I said. As I mentioned earlier, right, you know, there's a lot of folks that can afford and will be, you know, they'll afford the riders, they'll afford the increase, they'll afford. It's those small business owners, it is those ones that, to your point as well, don't have the same voices, that are still trying to operate their businesses in a safe and sound way, that are going to be unable to do so.
Okay. Thank you, Mr. Chair.
Thank you, Mr. Chair. Thank you. Thank you to the panel very much for coming. As a former member of Merit, and Merit used to have a place right on Amarillo Drive right down here. I don't think it's there anymore, but I used to go there every session. So you guys run a great ship, so keep up the good work.
Thank you.
It's always, I used to see Mr. Johansson, Mr. Favazza in Ways and Means quite a bit. I don't see you guys in the Judiciary, so it's good to see you guys. So I think this is probably for you guys on government relations side, but maybe if the members want to talk. Is it my understanding that you're not opposed to the idea, the concept, it's more about the language of the bill, that this language that says that you should be, your limit or indemnify or hold harmless any facility for liability or injury that's caused or resulted from the negligence or other wrongful act of the facility. Is it your testimony that you are against that language and that concept of avoiding liability for a wrongful or negligent act of the facility? Or is it, so let me ask that. I don't want to get too compound.
We oppose the provision, that provision being applicable to registered health clubs.
Okay, so if there's a wrongful, if a facility manager winds up miscalibrating a machine because this person's a real jerk and they don't like this member and they wanted to give them extra weight and the machine winds up falling on them, the facility shouldn't be liable for that?
If that's an intentional tort, is that negligence, or is that something that you can't, waive anyway?
So,
what you seem to describe was an intentional tort.
Okay, so if the facility manager forgot or didn't turn the air conditioning down at night, and therefore the machines that were required to be at a low temperature were too high, therefore the oil melted and the machine broke down.
Right.
So that's the fault. It's negligence. It's not intentional.
We would agree with the Maryland courts for the last 150 years that an adult can sign that release of negligence, and we would proffer that to them and see if they sign it. If they don't choose to sign it, they may go to a gym across the street that may not require them to do it. There are obviously a lot of gyms in a lot of neighborhoods. There's plenty of competition out there, and if someone wanted to hold themselves out as saying, we don't require you to waive negligence, they'd be able to do it. Under this bill, none of the clubs would be able to maintain the practices that they've safely maintained for the last 150 years.
But assuming that they don't perform negligent activities and they actually keep up to speed, as the gentleman from Merit was talking about how and the gentleman from the Arena Club, I don't think these are the facilities that are going to worry about this because they seem to keep everything up very, very high quality. The question is, if you're negligent in how you uphold you want to protect people who are negligent in how they uphold their facility. And that is the concern. I'll give you my final example, Mr. Chair. 11:30, we had an hour break. We didn't have to be here till 1. I ran to the gym and ran on the treadmill for an hour. I happen to have done that. If I overexerted myself and hurt myself and fell off the treadmill, I understand. I took the assumption of risk. It was my contributory negligence, and I can't sue. But if I'm running on that treadmill and all of a sudden the ceiling falls down on me, you're saying because I signed an exculpatory waiver, I shouldn't be able to get I mean, the gym doesn't want to negotiate a settlement with me because they injured me?
They may. Mr. Boston, in fact, said even with a waiver, he was able to negotiate a settlement. Okay? No one is prohibiting anyone from suing under these current waiver agreements. You can sue, and perhaps you'll allege that the equipment was defective and sue the manufacturer of the equipment as well. Perhaps you'll allege there was gross negligence. Okay? If you allege simple negligence, the court's going to tell you that you signed a release of that if the release was worded unambiguously and isn't for some other reason void for policy. So yes, it limits the number of cases that are likely brought, limits the number of settlements, but it doesn't say that you can't sue and seek a settlement for convenience, reputation, whatever that club would be willing to settle for.
All right. Thanks, Mr. Chair. I'll just say, Mr. Vavaza, if there's ambiguities that you think need to be corrected, you should certainly, I'm happy to talk to you, but I appreciate you guys here.
Thank you.
Thank you. Thank you, Mr. Chair. Thank you guys for being here. I just wanted to the gentleman who mentioned Oregon. That case was quite unusual in that Oregon, as you probably know, doesn't have assumption of risk in their state law at all. It's like the only state in the nation. So that case was like a dirt bike or some kind of, and the person in the state of Maryland had that occurred would not be eligible for any type of compensation, even if this bill passed, because he was clearly contributing to the outcome of that situation. So I just want to make sure that the situation where places were closing down and they couldn't get insurance was because they lacked something. And Maryland has it. We reaffirmed it recently in 2009.
Yeah, and I thank you for that, and I appreciate the opportunity to clarify. What I was using that as an example of is similar areas where the liability waivers are no longer in place. And I'm not talking about the parks with the dirt bikes. I'm not talking about those recreations themselves. What I'm talking about is the fitness and health facilities within that state that are now unable to get the startup insurance policies, that aren't able to operate the way they used to operate because of that negligence, which goes to the conversation around this bill and the ambiguity about who's covered, and looking back on to your mention here, right? A fitness center in this building is exempt in this bill.
I don't see where that's true. Could you be
From
more
the
specific?
state policy, and we'll follow up.
Yeah, I would love to see, because I just don't see.
The state facility themselves would be able to ask you to sign a waiver based on this bill.
They can't ask us to sign a waiver. They don't. Like, I haven't signed a waiver here. There's a gym in this building. We haven't signed
But
a waiver.
that's our concern is that unfair competition, and if you look again to those small businesses and those who are trying to get the policies, that will no longer be able to afford them.
There is no competition between what you guys offer and the Senate gym. Let me just tell you that for sure. And I'll just add that Oregon has a bill right now to remedy the situation. I mean, obviously ours was established through case law, but they are immediately trying to remedy this so that all of their businesses can immediately get insurance, and they're probably going to model it off of what already exists in states like Maryland. So, thank you.
Thank you, Mr. Chair. My question had to do with Oregon too, but I think Delegate Arcand really hit it. So if y'all could just provide the committee with whatever the case is and any analysis you have, we would appreciate that, because I'm not respectfully going to go looking for it. Thank you, Mr. Chair.
All right. Thank you all very much. That concludes the testimony on this legislation on SB 291. Now, so that she doesn't get caught behind the next bill, Senator Washington, Senate Bill 351. Senator Washington's here. We heard this bill.
You did.
Deb Seltzer is here with you. We did not move this bill. It had a fiscal note. My understanding, it has a different fiscal note now.
It does.
All right. Why don't you talk about that?
Okay. So we're right under the fiscal note. First of all, it's nice to be here. It's my first time here in this committee in a while. For the record, Senator Mary Washington. I actually didn't mind being here. It reminded me of my first year over in the Senate in JPR. Then I was paroled to another facility. Okay, so my transition. So anyway, this is a great bill. It sets up, as you know, low bono program, and my cross-file, who I hope when you move this bill, we amend her and move it at the same time. We amended it so that it's under the level of the B&T scrutiny of $200, I believe, $49,000 or something like that. I think it's $250,000. So we've amended the bill for an appropriation of $250,000 to set up the program. Although we believe we need 1.5. So.
Wishes and dreams would make it so. I'm sorry, Ms. Seltzer, do you have anything you want to?
Thank you, Mr. Chair. Deb Seltzer, Executive Director of Maryland Legal Services Corporation. Just want to clarify that last time we were here, we had a discussion about the eligibility guidelines that Delegate Embry had also proposed. Those are included in the version of SB 351, so they match MLSC's statutory guidelines. Happy to answer any questions.
Any questions for this panel? All right. We thank you very much. That'll conclude the testimony.
Thank you so much. Good to see you.
No problem. Sorry to make you wait.
Again, I enjoyed it.
She enjoyed it. Well, that's great. Questioning the sanity of the sponsor now, and now we're going to go to Senate Bill 1. We'll go with the Vice Chair of JPR, please. And there is a panel. These folders. Senator Waldstreicher, Sam Levy, Jen Polikonis, Lindsay Nichols, Karen Herron, please. Should be 5 chairs, should be room for everybody. We're missing 2, or are 2 virtual?
2 virtual, Mr. Chairman.
We have a couple virtual, please. All right, thank you. Mr. Vice Chair, go ahead.
Thank you, Mr. Chairman, members of the committee. I join you today testifying in support of Senate Bill 1. What started as my bill is now before you as something quite different. SB 1 is very much the work product of the Judicial Proceedings Committee and indeed the full Senate. It reflects months of dedicated hard work, line-by-line vetting, drafting, and redrafting. Its words come from both advocates of the bill as well as opponents. We took friendly amendments from Democrats and Republicans, from those who voted for the bill and those who voted against. And beginning today, it will be your turn to pour your input into the legislation, a process I welcome enthusiastically. As amended, Senate Bill 1 does 4 primary things. 1, it provides increased specificity for licensing requirements. We took this language directly from the Chairman's House Bill 824, which this chamber has already passed. 2, it defines the rights of private property owners. Private property owners may allow or disallow firearms on their property as they see fit. 3, it regulates firearms in highly sensitive places as explicitly allowed by Bruin. 4, it strikes the good and substantial permitting requirement, bringing Maryland law into compliance with Bruin. That's what the bill does. Here's what it does not do. It does not affect our police officers, military service members, and similar professions. We also included carve-outs for organized shooting competitions, historical demonstrations, and hunting. It does not prohibit the transportation of firearms. In fact, we specifically included a safe harbor provision in the bill. And it does not criminalize good faith efforts to abide by the law. We included specific language to avoid this outcome. At its core, this bill is not simply designed to deal with firearm policy in a post-Bruin world. Instead, it specifically utilizes the guideposts of Bruin to achieve that policy. Like Justice Scalia in the Heller case, Justice Thomas in Bruin provides a roadmap to common sense constitutional gun policy within the 4 corners of the decision itself. Justice Thomas makes clear, and Justice Kavanaugh and Chief Justice Roberts emphasize in their concurrence, that licensing regimes are constitutional, that private property is different from public property, and that sensitive place regulation is explicitly allowed. In fact, we already see judges utilizing this roadmap, including here in Maryland, where the United States District Court for Maryland upheld a reasonable federal regulation in United States versus Robertson. In sum, Mr. Chairman, what you have before you is months' worth of work and elbow grease. We believe it is vetted, concise, and narrowly tailored. Now the bill is in your possession. I welcome your recommendations, edits, and input, and respectfully ask for a favorable report.
Good afternoon. Karen Herron, Executive Director for Marylanders to Prevent Gun Violence, here in support of Senate Bill 1, addressing the wearing and carrying of firearms in public spaces. As has been highlighted, the purpose of this legislation is to clarify and strengthen the tools that the Maryland State Police have at their disposal as they vet applicants for a permit allowing them to carry firearms into public spaces, to strengthen those requirements for individuals wishing to do so, and to enumerate those spaces that are deemed too sensitive for public carrying. Importantly, it manages to do this within the confines of the Bruin decision. We are witnessing around this country the national nightmare of what happens in states that have loosened their gun laws, and I'm sure that no one wants that here in Maryland. We acknowledge the Supreme Court's position that the ability to carry firearms outside the home is entwined with their view of the Second Amendment, but it cannot be doubted that to do so is an incredible responsibility. We can provide MSP with a process for evaluating candidates to help ensure that each and every person is thoroughly vetted for whether or not they have a propensity for violence and that they are adequately trained for the special circumstance of carrying a firearm into public space. In addition, as the Bruin Court acknowledged, there are spaces for which the public carrying of firearms is simply inappropriate. This legislation seeks to lay out with as much specificity as possible those locations. The bill before you, as you just heard, is the result of countless hours of work by the bill sponsor, JPR leadership on both sides of the aisle, as well as advocates on both sides of the issue. It has been narrowly tailored within the confines of the Bruen decision and is designed to be specific enough for its implementation to be fair-minded and clear. MPGV urges a favorable report on SB 1. Thank you.
Okay. All right. Chair Clippinger, members of the committee, my name is Jen Poliokonis. I am the Policy and Programming Director at the Johns Hopkins Center for Gun Violence Solutions. My testimony is offered to me by me today as an individual and does not represent the views of Johns Hopkins University. I urge the committee to support SB 1. Maryland's ability to address the growing gun violence epidemic was further complicated by the decision of Bruen. And it's important to highlight the dangers of a permissive concealed carry permitting structure. Carrying in public places can pose a serious threat to public health and safety. A study led by John Donahue of Stanford University estimated that right-to-carry laws have increased violent crime rates by between 13% and 15% over the first 10 years that they were enacted. Additionally, a follow-up study revealed permissive concealed carry laws or right-to-carry laws increased violent crimes by firearms by 29% and robberies by firearms by 32%. And the increases are more complex than just more permit holders committing crimes. The Stanford studies show a direct association with more stolen guns, typically from cars. The authors posit, and I agree, that the increased stolen firearms impact the firearms trafficked on the underground market, increasing community gun violence. More guns means more crime, more gun injuries, more gun death. The people who carry firearms in public, the more people who carry firearms in public, the more opportunities for the escalation to a deadly interactions. So even without knowing the exact number of permit holders who commit crimes, and even if those numbers are low, we see increases in gun violence with permissive right-to-carry laws. According to MSP, there are already over 80,000 additional permit holders carrying firearms since the Bruen decision. It's imperative that this body address this issue with a comprehensive bill of SB 1.
Thank you. Lindsay Nichols, please, then Sam Levy. They're testifying virtually. Ms. Nichols, please.
Thank you, Chair Clippinger and Vice Chair Moon and members of the committee for the opportunity to speak here today, and thank you for considering this important bill. My name is Lindsay Nichols, and I am the Policy Director at the Giffords Law Center. I am also a resident of Montgomery County. Giffords urges you to support this bill, which will update the law and set critically important parameters on where guns can be carried. People are safer when firearms are not allowed in the sensitive places listed in this bill. People shouldn't have to worry about their safety or the safety of their children when they enter a school, government facility, or any other sensitive area, or when they exercise their First Amendment rights at a parade or a protest. Preventing firearms from entering these areas will increase the security of Marylanders. This bill encourages responsible gun ownership by ensuring gun owners think critically about when and where it is appropriate to carry firearms and obtain permission from a private property owner for carrying a gun on the property. It will also reduce the risk confrontations will escalate into shootings and the risk that guns may be stolen when they are in these places. And this bill is in keeping with the new test established by the Supreme Court for Second Amendment challenges. Every state has some prohibitions on where guns can be carried. These kinds of restrictions are common in states across the country. The Supreme Court's decision requires the legislature to change the law regarding wear and carry permits, but without the sensitive places piece of the bill, there's an argument that this bill is weakening the law. The only reason these location limits are not already on the books in Maryland is because it was so difficult for people to obtain permits, so fewer people were carrying guns. Now, because of that decision and what this bill is doing regarding the qualifications for a permit, it will be easier for people to obtain permits, allowing them to carry guns in public. Therefore, the legislature needs to consider what areas exactly you want guns to be allowed in. I urge you to support this bill. Thank you.
Mr. Levy, please.
Thank you, Mr. Chairman, Mr. Vice Chair. My name is Samuel Levy. I'm the Regional Legal Director at Everytown for Gun Safety. As you've heard, the Supreme Court's decision in Bruin for the first time held that responsible law-abiding gun owners have a Second Amendment right to carry handguns outside the home in public for self-defense, and struck down a portion of New York's concealed carry law that mirrored one in the state of Maryland, which required those seeking a permit to carry to demonstrate a special need. The impacts of that ruling were immediate. The bar for obtaining a carry permit in places like New York and Maryland was significantly lowered, and the results are stark. The Maryland State Police saw about an 8-fold increase in just the months following last summer's Bruin decision, year over year, in the number of people seeking wear and carry permits now that no special need was required. And the result is that there are going to be far more Marylanders who are licensed and who are now carrying guns in public, and that is their right. But that right is not unlimited. More guns in public, as you've heard, means more risk of guns being used to commit crime, to threaten or intimidate, firearms being stolen, firearms being accessed by children or other vulnerable individuals, and those risks now have to be addressed as a result of the court's decision. And so we ask you now to act with respect to Senate Bill 1, as you have previously with House Bill 824, to begin to mitigate these risks and put forward a solution that will ensure public safety. As you've heard, it's a two-part process, one of which tracks almost identically with what's in 824, and those are improvements to the permitting system themselves to ensure that the only people who obtain permits in the first place are in fact responsible, law-abiding gun owners and not a danger to themselves or anyone else, and a number of other fixes to make the system more comprehensive, more transparent, and more fair and equitable. And secondly, to create a clear list of sensitive places where even wear and carry permit holders cannot be near guns, places where guns don't belong. Those changes, as well as the clarifications on the private property rights of other Marylanders to exclude guns from places where they don't want them, are all vital parts to ensuring public safety in the wake of the decision, and I urge a favorable report.
We'll take questions now for this first panel. Go to Delegate Williams first, then Delegate Arikan, then Delegate Cardin.
Thank you, Mr. Chair, and I just have two questions. My first question is for the bill sponsor. Hi, Mr. Vice Chair. How are you?
Oh, good to see you.
A quick question. With your bill, you have a list of sensitive places, and I was wondering if you could just elaborate a little bit more about why you feel that that is needed in response to the Bruin decision.
Sure. That's a very good question. Thank you for asking it. So the Bruin decision, within the four corners of the decision itself, indicates that sensitive places is an area around which we can constitutionally regulate. Justice Thomas makes this clear in the main opinion, and Justice Kavanaugh and Chief Justice Roberts, for whatever reason, felt compelled to write separately just to emphasize that exact point. The justices indicate some places that are presumptively sensitive, and then indicate that analogies to presumptively sensitive places are appropriate. In other words, the 5 presumptively sensitive places are not the entirety of all the sensitive places. And so what this bill does is create 3 categories of sensitive places and then list with specificity the types of locations within that. The first is areas for children and vulnerable adults. The second is government or public infrastructure areas, and the third is special purpose areas.
And just as a follow-up to that, I apologize, I noticed in the list, it didn't include like mass transit or mass transit facilities or anything along those lines. Is that something that you think would be outside of the scope of what was stated in Justice Thomas's opinion, or would that fall within the scope?
So we know that mass transit is subject to current litigation in the WMATA system in Washington, D.C., which of course comes into Montgomery County and Prince George's County as well. The bill does not specify sensitive places that are already specified in other areas of law. My understanding is that the regulation of guns on MTA is separately regulated in our code, and so thus not included in Senate Bill 1.
Okay, thank you. And then my second question I have, I think I missed the name. Is it Ms. Morris? Is it, or
Heron?
Heron. Well, either one. Well, actually, yeah. You were mentioning earlier about kind of the increase in violent crimes in areas where states have permissive or things like that. And I see in the bill, I think it's around page 14, where we have the secretary to do a reporting on various factors, preparing a report with regards to the total permits issued and the total number of applications and those types of things. And my question that I had is whether or not we should also be tracking whether or not do you think, in terms of the permits that are issued and permit holders that are out there, whether or not any of those guns from those permit holders are used in the commission of a crime? I don't know if that's something that the state police is currently tracking now or not, but your comments made me think, well, how do we know whether or not the increase in the number of permits issued are linked to the rise in homicides that we may be seeing, or any other violent crimes for that matter, where a gun is issued? And is that something that we should be trying to track or not in terms of the permits that are issued?
So one of the things I was really excited about was this inclusion of data collection and data analysis in the report. Speaking as someone who works with research, it was, my love language from the lawmakers who are putting this in. I would say the more data that we can collect, the better. I do know that part of this is going to collect the demographics of the permit holders, which would be good to understand any racial equity disparities within there. And one of the points that is going to be collected is going to be how many permits have been revoked.
Right.
It would be interesting to find out why. I don't know if there was a reason. This is all pretty straight statistics of numbers. There aren't a lot of short answer data collection, so it might just have to be a conversation about what could be included and what not. But I would always argue for more data versus less.
Okay, thank you. Those are all the questions I have.
Thank you, Mr. Chair. Thank you, Mr. Chair. Thanks for being here. This question's for the sponsor. I just wanted to touch on some of the concerns that have been raised around the Section 4203 conflicts. So, as you probably know, on all of our cards it says that we have to abide by the current laws under Section 4203. It looks like what this bill would ostensibly be doing is that if someone, and as you probably know, there's no mens rea for this, if someone inadvertently carried their firearm outside the scope of this bill, they could be subject to up to 3 years imprisonment. And I'm hearing that that's not what your intention was, but that is in fact what this bill will do.
So this, as you know, this bill does not alter 4203.
Right.
And as you know, under current law, guns are prohibited in certain places. And so the issue that you are raising is an issue that is under current law. This bill does not change that with regards to 4203.
Correct. And under current law, it's just a few places. But under your bill, there's going to be thousands of places that would be restricted. And so the risk of someone inadvertently violating 4203 is very high. So was it your intention that people would receive up to 3 years in prison for an unintentional violation of your law?
Sure. Good question. So as you know, the penalty for 4203 is between 30 days and 3 years. This bill does not alter that penalty. 4203 regulates the penalty for under current law when people take their weapon where they are not allowed to take their weapon. This bill expands the number of types of places where weapons are disallowed, but doesn't change the penalty whatsoever.
Okay, so it was your intention then that people who accidentally carry this would get up to 3 years and therefore be completely barred from ever purchasing a firearm again?
Our intention was to maintain 4203 under current law.
Okay, and apply it to this new space. Okay, thank you.
If I may, can I answer?
No, thank you. I just wanted the sponsor.
Delegate Cardin.
Very much, Senator, for bringing the bill. And I think people know that I think that we have too many guns, and while I think everybody should have a right to be able to utilize guns as the Constitution permits, that I am very much in favor of trying to figure out a way to regulate this to keep our communities safe. That being said, two questions. The first is kind of going off of a little bit of what I think it was actually Delegate Williams was asking. In terms of the Bruin decision, which I'm very unhappy about, it seems as if given the sensitive places in the bill, kind of outdoors and in private businesses is all that's allowed. Can you enlighten us on maybe how this doesn't just, I'm worried about a court case challenging the expansiveness of the sensitive places. Where else would you be allowed to be able to carry your gun except in like private businesses and outside, not at a public licensed function?
So I think under Bruin, it's in fact the opposite. Not to disagree with the premise of your question, but Bruin makes clear that you are allowed to carry your weapon in public for purposes of self-defense. This bill has a specific list of sensitive places. Anywhere outside of that list, you are allowed to carry your weapon.
Okay. So I was trying to think of other places besides what's in the list, and I worry. I want to do this. I just want to make sure that we're not being a little too expansive. That was my first question. My second question is, it's on page 7 of the bill. There's no line numbers or page numbers because it's all been in the reprint, but it has to do with posting that a person wearing, carrying, or transporting a firearm may not, and it says, 1, enter or trespass on property that is posted conspicuously prohibiting it, and number 3, entering a dwelling of another unless it's been given express permission. Those seem to be at odds with each other. Either you got to get permission or you got to post against, but it seems like if you're doing both, that may be confusing as to whether you have to either post no or give permission yes. So those are question number 1. And why should I, as a private citizen and a homeowner, require the posting of a sign to make sure that people aren't bringing guns onto my property? I mean, I feel like 3 is okay. They have to ask me permission, but I shouldn't have to assume that they might bring it on unless I tell them no. So I'm wondering if you can.
Yeah, that's a really good question. So I'm not looking at the reprint. I'm looking at the bill as with line numbers. So I think for everyone following along, that's on page 9 with the new section 6-411. And so this was extensively considered and vetted in the Judicial Proceedings Committee and again on the Senate floor. And the compromise that was reached and the consensus that we came to is that dwellings, meaning your personal home, is different than other areas that are publicly accessible. And so the default for dwellings under the bill is exactly as I think your policy preference is. In other words, you do not have to post against someone coming into your home with a weapon. It's your house, and as a matter of policy, and to be honest, as a matter of propriety, anyone coming into your dwelling should say, hey, I'm wearing a weapon, is that okay? And you can give permission or not give permission as you wish. But other areas, commercial property and the like, the default becomes the opposite, because under Bruin, there is kind of this notion that in general, people should be able to carry their weapons in public. And so if they're going to stores or other places, the default for there is you have to post conspicuously against the weapons.
So in my law office, I can't assume that somebody's not going to bring in their gun unless I conspicuously post, can't bring your gun to my law office.
So that's correct under the bill, and that feels as foreign to you as it does to me. But we live in a post-Bruin world where currently someone could bring in the weapon because the Bruin default. And so this is just making clear the new norm that if you don't want someone to do that, you should post against it.
And then if I live, just last question, if I happen to live where I work, I guess, could the argument be made? Could there be a colorable argument that my living quarters is upstairs and I guess it's defined in here that dwelling, it actually, I think specifically says that dwelling is only where the beds are as opposed to the common area. So I guess you would have to, if you have a live at home and work at the same location, you'd have to figure out both of those.
That's fair. Yep. No, dwelling is specifically defined at lines 6 and 7. Dwelling means a building or part of a building that provides living or sleeping facilities for one or more individuals.
Okay. Thank you.
All right, I have a couple questions to go back to Delegate Arikan's questions because I think that she may have left the committee with an incorrect understanding of the law. Under 4203, 4203 of the criminal law article says that a person may not wear, carry, or transport a handgun, whether concealed or open, on or about the person. But in Section B, it talks about if you have a permit to carry a gun, then you're not liable under 4203. I believe that what I think I heard, which I don't think was intentional, but the thought was that carries right now a 3-year penalty. There's another bill that's floating around that would raise that to a 5-year penalty. But in any case, that relates to people who do not have a permit to wear or carry a firearm, correct?
That's correct.
Okay. So if someone had a permit to carry a firearm, but under Senate Bill 1 violated one of the sensitive areas, they would not be subject to the 3-year penalty. They would be subject to what appears to be a 90-day penalty for, as the bill is written. Is that correct?
That's correct. I apologize if I misunderstood the question.
Okay. So this does not carry automatically a 3-year penalty. But to go to another point, right now, if you don't carry a permit, no matter where you are in the state of Maryland, whether it's a sensitive place or not, if you're wearing and carrying without a permit, you are subject to the 3-year penalty. And nothing changes about that in the bill as it's written, right?
That's exactly right, Mr. Chairman.
Going a step further, as I read it, looking on page 8 of the bill in section 8H, one of the fun legal concepts, and unfortunately Delegate Kaufman's not here, so he's going to miss this and we'll catch him up later. But having said that, we always have to go to law school in the committee, is the rule of lenity. And so at first blush, when you look at this and you don't, and maybe you miss section H, you could say, well, if they get picked up at a sensitive place, that they could potentially see a lower sentence than what is already in the law. But what, as I read it, and I'm just trying to make sure that I've got this right, under section H on that page, it says that a conviction under this section may not merge with a conviction for any other crime. And then in 2, a sentence imposed under the section may be imposed separate and consecutive to or concurrent with a sentence for any crime. The reason I'm talking about this is that the language is the same basically in 4203 and what you have in sections C, D, and E in the bill regarding the sensitive places. But what I see, and just getting finally to my question, and I'm doing what I yell at everybody else not to do, but having said that, the goal here is to add, at least in the way you've drafted it, as I understand it, a 90-day penalty or a subsequent penalty, if that should happen, on top of any other penalties that may happen with any other law. So if it's a person who is wearing and carrying illegally, they didn't have the permit, plus they were in one of the sensitive places, it would be 3 years plus 90 days.
Well, that you are correct as a matter of law. As a matter of practice, the second section, line 25 through 27, allows those sentences to be served either consecutively or concurrently according to the judge.
But it addresses the rule of lenity issue that says that if you have two statutes that basically read the same, they may be different in some way, but they basically read the same, that you have to choose the lower penalty of the two. That would not apply here because you've got effectively the magic words are there to say that the rule of lenity would not apply in
That's correct.
Okay. So just to review, if you don't have a permit, it's a 3-year penalty still, just as it is right now. If you do have a permit, but you go to one of the sensitive areas, it's 90 days, or if a subsequent, another penalty. And so that is your intent with the bill.
It is our intent. That's 100% accurate.
Thank you very much. We'll go to Delegate Barton.
Thank you, Mr. Chair. Thank you, Mr. Vice Chair, for bringing this bill. I just have a couple of questions on, I'll try to be brief here. So I heard you say that some of the items that are not, some of the places that are not listed, it's because they're already somewhere else in law. And I just want to confirm 2 places that came to my mind. One is on page 4, at section under 4-111, we talk about section at
under 2.5. The bill language is a location that is being used as a shelter for runaway youth. Are DV adults still included somewhere else in the law? So if there's a shelter being used for domestic violence victims, is that somewhere else where one would not be able to have a a firearm?
So that's a good question. So DV shelters were in the original bill. We were informed that most DV shelters are private property. In other words, they're third-party contractors and could therefore utilize the private property provisions. That's why it came out. But to the extent that this committee wants to return it for just to have it explicit, I am open to your input and additions.
Okay, thank you. And also wanted to ask you about movie theaters. On page 5, I see a live theater performance. I was just wondering about movie theaters, since we had the horrible shooting at the movie theater.
Yep. So movie theaters also were in the original bill. They were removed in part because of the contention around movie theaters specifically, but also because similarly movie theaters are private property and they can make these decisions for themselves.
And two more quick questions. I'm sorry, but I found that answer problematic, but that's okay. I'll go with it. Not your answer, just anyway. It kind of just leads me to the same question: is what is my right to be able to sit in a movie theater without someone having a firearm next to me? But that's okay. We won't go there. The other two more questions: possible amendments, which I know you. I love what you said. I understand the work, and I know the work that has been put into this bill. I appreciate you saying that it is now in our hands. So, my understanding is that on page 6, at B, where it says the section does not apply to, under B7, Roman numeral I-1, the official, we're talking about retired police force or off-duty police law enforcement. The official or person is displaying the official's or person's badge or credential. I'd like that to be changed to carrying. Do you have any objection to it saying carrying as opposed to displaying?
I do not. Lines 23 through the end of that page, we were informed came from the federal LEOSA law and was designed to mimic the federal LEOSA law. What we learned subsequent to passage of the bill is that LEOSA treats the display of a badge slightly differently than the wording here. Your wording more accurately tracks the federal LEOSA law, and so 100% open to taking that language.
Okay, and then my last question, if I may, Mr. Chair, my last question is on page, with respect to page 9, and this may be for the same reason, may not be, but under section 6, in section 6-411, under B, this section does not apply to, and we don't talk about other states. So a law enforcement official from another state. So if we could just probably have in there a law enforcement official of the United States, the state, another state, or subdivision thereof, or a local law enforcement agency of the state.
So you're exactly right, Delegate. I believe that may be covered at lines 23 through 25 at Arabic 3.
Okay. All right. All right. Well, if they're not temporarily here, I guess they would go under the retired, if they're not temporary, because that one is temporarily here. That, a law enforcement agent is temporarily here.
Sure. If a law enforcement officer from another state is here permanently, I would be working under the same factual assumption that you are, that they are a retired law enforcement agent, not a law enforcement agent from another state.
Okay. All righty. Great. Well, thank you. Great work. And let's see what we can do with it.
Delegate Munoz, then Grammar, and then Tomlinson, then Embry.
Thank you, Mr. Chair. And thank you to the sponsor for bringing this bill. I really appreciate the intentions behind this. Reducing violent crime in Maryland is one of my most important issues, something very close to my heart, especially illegal gun violence. It's a huge problem. My only concern, and I ask this to anyone who can help me understand this piece, so my only concern in hearing from different advocates and obviously what we've just experienced as a nation in Nashville is the sensitive places. And if criminals are aware that our schools, our churches, synagogues, these places where there's large groups of people gathered that could potentially be targets, are not protected in any way, shape, or form because it's illegal to have a firearm on the premises. What do we do then when we're effectively making them soft targets and we're just handing that to criminals who want to, we've seen tons of hate crime legislation come through this session. Like, we are very concerned about, everyone in general, but specific groups especially that are being targeted every day, and we don't want to leave them vulnerable. And some of these communities have come and said, at every synagogue we have, there are armed members that are trained, always there. And if we don't allow that, or even in a school, so I'm a mother, right? And so what happened this week is horrific, and it's every parent's worst nightmare. And I just think about, if these people were so bold to realize no teacher, no staff member, no one in that school would be carrying because it's illegal for them, when a criminal wants to commit a crime and they come in there with 7 firearms to kill small children, like, how do we justify that as a body? You know what I'm saying? How do we feel good about that? Because I just see, the war on drugs just gave us more drugs, right? So if we outlaw firearms in places where we have, children and vulnerable adults, what's going to happen when, criminals target those places and they know that there's no one there to protect those children and vulnerable adults?
Thank you, Delegate Munoz. That's a great question. The bill anticipates that. And so if you were to look at page 7, beginning at line 13, and then traveling down to line 19, this allows people in sensitive places to carry under certain circumstances. And so the synagogue reference that you talk about is line 18 and 19, and was specifically added at their request. And so the bill anticipates the concerns that you've indicated. And I appreciate the question.
I'm sorry, can you give me the page number one more time?
Sure.
In the third.
So I have a version of the bill of the third reading Senate Bill 1 as passed.
Mm-hmm.
So it's not a reprint. And so it's page 7. And then beginning at line 13, which is Roman 2. So a person who is authorized by the owner or lessee of the location to wear, carry, or transport a firearm at that location for the purpose of employment as a security guard, or protecting any individual or property at the location without remuneration or compensation. That was added specifically at the request of our synagogues who utilize the method that you reference. And so sensitive places are not inherently disarmed. This section of code allows sensitive places to hire or otherwise have volunteers who are armed with the agreement of the owner or lessee.
And so would that apply to schools then?
It would apply to schools.
So public
yes.
or private schools, if they had teachers who, had their permit, they would be able to have their weapon, and if someone were to enter the school?
As long as they had permission of the owner or the lessee, yes. And I think Ms. Polyakonis also wanted to address the question, if that's okay, Mr. Chairman.
I also wanted to address the myth that most mass shootings happen at gun-free zones, and that there is a targeted approach for gun-free zones. The overwhelming majority of mass shootings actually occur in homes, which are not gun-free zones. Typically, they're related to intimate partner violence. There's also community violence, which are mass shootings. The types of high-profile mass shootings that you're most talking about, it's actually only about 2% of all gun violence. And yet, with gun homicides, we've seen an incredible increase over the last couple of years, almost 45% increase of gun homicides over between 2019 and 2021. And so gun violence is an incredibly complex issue with lots of different root causes, and we also need comprehensive solutions. This is one important solution. I know that there are other bills here, but I really just wanted to point out that myth about gun-free zones and mass shootings.
I'm sorry, so from 2019 to 2021, what was the increase?
From 2019 to 2021, there was a 45% increase in gun homicides in this country.
And that was before the Bruin decision?
That was before the Bruin decision, when there was an increase of millions of guns sold between 2019 and 2021.
Okay, okay. And so I hear, like, we all want to reduce homicides, but specific to my question, even if it's only 2%, or I don't care how little it is, no children should be gunned down in school ever.
We can all agree on that, absolutely.
Or in their places of worship. And so those sensitive spaces are the two that I was asking about. And so you feel that this legislation, the way it's written, will allow those places to still be protected, and they will not be targets for violent criminals with the intent to harm our children and vulnerable individuals.
Yes.
Thank you.
Before we go to Delegate Grammer, I have some more questions. On page 8 of the third reading copy of Senate Bill 1, on page 8, and where is that? Lines 19 through 21, talks about a 15-month penalty for somebody who violates subsection F, which says that you can't be in one of the sensitive place categories with the intent to cause death or injury to another. How would a prosecutor prove that?
So I'm going to defer to Mr. Levy, who's a former prosecutor.
Okay.
Thanks, Mr. Chairman, for the question. Again, I think it's all going to be fact-specific. It could be evidence of, notes or postings online, people who create plans to carry out acts that, in this case, would be prevented or intervened, and then later evidence is recovered that it was planned and there was malicious intent. Could be statements made by a defendant prior to or at the initiation of an attack, something like that.
But the intent to cause, okay. More likely than not, it would be because somebody took a gun to one of these sensitive places and engaged in and had the gun there. I mean, that would be more often than not probably brandished the gun. That would be the cleanest way to demonstrate intent, but that's first-degree assault. So, and this is in the section of the bill where there's a lenity provision and everything else. I don't think that this, I may have, when I first read it, thought, oh boy, that's not great. But having said that, this doesn't get subsumed into, or this doesn't basically take down a first-degree assault conviction. It would be a first-degree assault charge plus this. Can you go a little further? Why 15 months? It's one of the most unusual. As a prosecutor serving 15 years here in Anne Arundel County, I don't know of many crimes that carry a 15-month maximum penalty. Why 15 months?
That's not a number I chose, Mr. Chairman. I don't have an opinion on
Anybody
the
else
exact
want to
right
answer?
number.
Why 15 months?
I think we wanted it to be more severe, obviously, than the 90 days, but not inherently disqualifying. So anything going above 2 years, as you know, Mr. Chairman, is disqualifying. The whole idea of the bill is not to jam people up or create disqualifying crimes from within the legislation. And so we are open to other ideas, but the notion was to go above the 90 days for the first offense, but below the 2-year disqualifying amount.
I guess specific to that section, it strikes me that really the main ways that you'd be able to prove it is because there is some other bigger crime that is happening. And so it just strikes me as odd that I don't know if I would be as worried about a disqualifying crime sentence if they are brandishing their weapon and pointing it at somebody. They're already in trouble because it's going to be a charge for first-degree assault in the first place. So I kind of have a question with that. But I need to go, again, on my lenity kick, because why not? Because lenity. On page 10, where it talks about, and this goes to the question where people have their own personal property, whether it's a home or whether it's a business, and if it's posted conspicuously against wearing and carrying or what have you, if they violated going onto somebody's property, either as a business or a residence, the penalty there is a 90-day penalty. But there isn't the lenity provision. Was that deliberate? Did you mean that to undercut fourth-degree burglary, second-degree burglary? Because it does right now.
I'll let Sam follow up with me. Our belief is we took this directly from the trespassing law under current law. That was my request to the drafter. So to the extent that it does not include a lenity provision, that's on me. But I believe that's because the current trespass law, and you would know this better than I do, Mr. Chairman, may not have a lenity provision. So to the extent that burglary and trespass under current law merge, that was repeated here. So my request to the drafter was that trespass law be repeated exactly as it is under current law.
It feels, at least in going into a business in particular, I mean, if they went into the business, I don't know. I think you could see a lot of cases where second-degree burglary for a business, fourth-degree burglary, at least at a minimum, maybe first, could be an issue there. But I am going to stop wonking out. I might ask some more questions, though. Delegate Grammer.
Thank you, Mr. Chair. So first, I have several questions. First one I wanted to follow up on, I suspect had something that Delegate Arcand was inquiring about, and that was the penalties in criminal law section 4203. So there are several infractions in 4203 that also are in this section of code. Now, I listened to the chair's discussion about lenity, but as I'm reading this, it looks as if, for example, there's a very similar provision about causing death or injury, carrying in a vehicle, carrying on a school space. These are all listed in 4203. Does the lenity apply there, or am I, in reading this properly, this would be a duplicative offense which a person could be charged for not only illegal possession, but illegal possession in violation of a permit?
They could, yeah, so the chairman is right. So 4203 is applying for people who do not have a permit. This is for people who do have a permit, but nonetheless enter places where they are disallowed under the bill.
So was that your intention, to create a duplicate charge for illegal possession and illegal carry?
Well, if they don't have a permit, it's already illegal under the very code that you're referencing.
Okay. So I want to follow up on something that Delegate Cardin spoke about. And, you know, I'm very comfortable with guns. I was raised with guns, but I'm always very sensitive to people who feel uncomfortable around guns and just being safe and feeling safe. I'll also note there are guns in this room. And as privileged people, we tend to operate down here surrounded by people with guns. And what I want to ask about is something your panel has mentioned several times, and that's the idea of more risk. We have more guns, there's more risk, more opportunities for things to spiral out of control. So this was one of the arguments raised when we passed the Gun Criminalization Act of 2013. But it proved to be radically false. We were told that straw purchases would decrease. We were told that gun crime violations would decrease. Those two things spiraled out of control. And what didn't happen, we had approximately 30,000 permit holders in the state of Maryland. After Bruin, that's, I believe, 110,000, 115,000 permit holders. And when the state police presented to us earlier this session, I asked them specifically, have you encountered any irrational, illegal, criminal use of permits? And they could not cite one. So now that we've heard several times that this idea of more risk, can someone factually quantify that for me? How more people with more guns, knowing that our permit holders in Maryland has tripled, how I'm supposed to look at that factually?
So there are studies that do quantify exactly that. As I was saying, the study out of Stanford, they're not only looking at, the first 12 months of more permissive permitting structures, but they're looking at longer periods of time, so they're looking at 10 years. And so they did find in one study that there was an increase in violent crime from 13 to 15%. And as I said, in a follow-up study, they found when there were more permissive concealed carry structures, there was an increase of violent crime with firearms by 29%, robberies with firearms by 32%, and there was a recent study out of my own center at Johns Hopkins, the Center for Gun Violence Solutions, by Professor Mitch Doucette, where they looked at assaults with guns after the first 10 years of states moving to a shell issue, and that was increased by almost 10% of assaults with guns. So we do have quantifiable evidence that shows that we are not seeing less crime with more guns. We are not seeing the same amount of crime with more guns. We are seeing more crime with more guns, and that is exactly what we're trying to limit here. And in talking about the Firearm Safety Act of 2013, we did start seeing some positive implications in the first 2 years. And it was after the protest with Freddie Gray that there were increases again. And we've also seen nationwide that there have been increases of gun homicides over the similar period. So our nation has a problem with gun violence. The answer that we are finding, though, is that more guns is not the right answer. And so we're trying to make sure that we can balance, as we're talking about Second Amendment rights, the Bruin cases, with these public safety issues, and we're trying to do that through evidence.
Okay, one final question. So in Criminal 4203, the Maryland Supreme Court has talked specifically about that section of code and the lack of mens rea. For example, one thing that gets cited frequently is the language on or about, and then everyone gets arrested for that. Do you or do you not have a problem with that kind of culpability language here, layered on top of the fact that we already have problems with a current section of code?
So our goal in the legislation, and as it was vetted through the judicial proceedings and the full Senate, was not to radically change current law. And so there was a strong effort to mimic other sections of code. And so you heard earlier that a portion of this bill mimics our trespass law and does so closely. The idea was to keep it within the bounds of concepts and words that we already use in our code. Similarly, we mimic 4203 in portions of this bill, and that was a purposeful choice.
Don't you think it prudent, already knowing the culpability problems with 4203, to maybe weave that in here?
I think it's fair to say that if 4203 were struck down by the Maryland Supreme Court, that would create problems for the legislation that is in front of you. The Supreme Court has not struck down 4203, and we believe this bill is constitutional.
Okay, thank you.
Thank you, Chairman. I'm looking at page 5, where it gives the definition of organized sporting or athletic activity. It means an activity in which 3 or more individuals are competing in a sport or athletic activity together as part of the same league. So I think the obvious places that you're referring to there are, a high school, whatever, football game, or, Major League Baseball game, Camden Yards. Like, those are obvious places, but is this also applying to, I'm just trying to think of places, like a bar that has a pool league? Does this apply to a bowling alley? I mean, I would imagine, that's 3 or more individuals, and it's a lot of times leagues. Would that apply to, I know where I grew up, we would have, 15, 20 kids in the backyard playing, touch football or whatever like that. So would my parents not have been able to have a concealed weapon on their property if there was, a game of touch football being played in the backyard? So does this kind of cover all of that, or just the first 2?
Thank you for the question. This language was heavily vetted, and the portion in front of you was taken as a friendly amendment from the Republican senator from Frederick County, who wrote this portion of the bill himself, and we adopted out of deference to him. It is intended only for organized leagues, not for pickup games, not for things that happen in the backyard. So no, this was written and rewritten multiple times, and written by a Republican member who did not vote for the bill, but whose input we took to heart, because he was exactly right. We do not want to capture activities that are not intended to be captured here. As indicated previously, our intent is not to jam anyone up, and this language, we believe, provides the specificity necessary to limit it to organized sporting leagues.
So, but the example of a bowling alley, because I mean, there's lots of leagues that compete there, or a bar that has like an APA pool league. I mean, that would apply there, right?
Well, this gets beyond my expertise about whether bowling is or is not a sport, or a pool is or is not a sport. I can't. That's a philosophical question to which I cannot answer. Some of these questions will be fact specific.
Okay.
To the cases that come in front of them.
I'm not
For what
going
it's worth, delegate, if it's a bar, they're prohibited anyway. And if the bowling alley sells alcohol, they're prohibited anyway. There's a place that's licensed to sell liquor on premises for consumption on premises. So that's a moot point.
Oh, okay. But just to be clear, next time I'm at a bar and there's a pool league, I'm not going to ask them if they consider that a sport or not.
Okay, good.
I don't know if that'll go over well.
Don't ask golfers. Yeah,
That might be more controversial than this issue.
Thank you.
Now that we're going horribly wrong, Delegate Erican.
Thank you, Mr. Chair. I'm sorry that I confused you guys with my question about 4203. I'm just going to read you from the back of my card. These are the restrictions. So for those of you who haven't taken concealed carry classes and don't possess a card, the restriction is very clear on the back. It says in capital letters, not valid where firearms are prohibited by law. So if I have this card, and if this bill goes into effect, it is as though I do not have this card anymore if I am now carrying this anywhere where firearms are prohibited by law. So while you have created a separate penalty structure, in fact, because of my permit very clearly lays out for me, any violation of any area where it's prohibited triggers the penalties in 4203 for me. That's what the back of my card says. So that's what I have to assume is true, and I believe that's what a judge would tell me, because I knew when I looked at this that I could not go anywhere that it was prohibited by law, not just in this area of 4203, but anywhere in the code, and we are changing the other parts of the code to increase those spots where I can't go. So that is why I believe that it will be triggering up to 3 years and will then make anyone who doesn't intend to trigger that prohibited person penalty. So if you'd like to comment as to whether or not that was or was not your intention.
Yeah, let me first apologize. I didn't mean to imply that your question was confusing. I was confused by it. It was not your question. I would just go back to the chairman's statement that I think accurately reflects the current state of the law and how this integrates with the current state of the law.
Unfortunately, it doesn't. That was the problem. This tells me that I am now in trouble with 4203, not under the new code, because I just don't have a card anymore. It doesn't exist, essentially. So even though that was the attempt of the bill, the actual outcome is that anywhere I carry, no matter what you put into the other part of it, I'm in violation of the part right here that says 4203 on the front.
So I have a question. So again, your intention is to say that the 90 days would be on top of a 3-year penalty for somebody who did not have a permit. And your intention is that somebody who did have a permit would only be subject to the 90 days. Is that correct?
That's correct.
Okay. So we would have to address, seeing that issue, I hear that issue clearly, so we would have to address that issue. Delegate Conaway, do you have a question?
Yeah,
Go ahead.
Thank you, Mr. Chairman. Thank you, Delegate and panel, for coming in to testify. So I believe the chairman just threw me a curve. Are you saying that the penalty now could be increased to 3 years and 90 days? For certain.
So
I understand what your
Yeah.
intention is, but as we have this bill written right now, potentially someone could receive 3 years and 90 days for having a firearm on a restricted place, a sensitive place.
So I'm going to kick it to Sam, who knows the intricacies. But as intended, and as I think we wrote it, and if we did not, we should change it, 4203 is current law and is intended to apply to people without permits. The law in front of you is intended to deal with people with permits who enter sensitive spaces where they are disallowed, which has a 90-day penalty. And so, Sam, do you want to expound upon
Sure.
that?
Yeah, happy to, Mr. Vice Chairman. So think of it this way. The 4203 has a blanket exemption that the chairman just explained, right? If you have a valid permit, if you've obtained a wear and carry from the state, that section of code does not apply to you. The section of code that's in the bill before you that names these sensitive places would apply equally to people who have a permit, a wear and carry permit validly issued by the state, by Maryland State Police, and people who would not. The question of merger and how those sentences would be combined by a person who had no permit and therefore was chargeable under both is a separate question, and one that I would defer to you all in terms of how two charges for those two different offenses would stack up alongside each other in terms of charging or penalties. But the purpose of the new language in the bill before you is to address people whose valid permit authorizes them to carry outside their home, but make clear that there are places that even they may not go with that card. And I'll say for just to follow up on some previous questioning and to reinforce the Vice Chair's point, this is not meant to be a trick for anyone, right? One of the other features of the bill that's in front of you is a really expansive set of training that's going to go into anyone who's going to obtain one of these permits that includes not just self-defense training, how to safely use a weapon and fire it, an understanding of the laws of the state related to firearms, but specifically listed where firearms are not permitted, even by people who are licensed to carry them by the state. And so this is information that we want publicly available.
Thank you for allowing me to ask the question that was not on the bill, but I want to ask a question on the bill. On page 6, where it says video lottery facility, could that be a supermarket or 7-Eleven?
The video lottery facility is a defined term under our gaming law.
So I'm asking you, could that be like a 7-Eleven that sells video lottery tickets and things like that? The racetrack, the horse.
So it definitely includes racetracks.
So therefore, if a person, what I'm trying to get to is if a person has the permit and they're going to 7-Eleven, now you could take your firearm into 7-Eleven, is that correct?
That would not change under current law. A video lottery terminal is a slot machine and is defined at current law, and this would apply at racetracks and casinos, not like where you buy scratch-off tickets.
But not where they have the horse racing in the 7-Eleven?
Are you talking about like Keno, like the...
Well, they have the horse racing. Yeah.
So I don't know how Keno is defined.
No, it's not Keno, it's horse racing. Video horse racing.
We can get that answer for you.
Okay, so you're going to get that answer for me. But now, under this bill, that if this bill passes, a person that has a permit could not go into 7-Eleven potentially with their firearm. Is that correct?
So I believe that video lottery terminal is just a euphemism under our law for slot machines.
Okay.
And would apply
Right now, can a
at
person
casinos.
go into a supermarket if they have a wear carry permit with their firearm?
After Bruin, they can, unless the supermarket disallows it.
So now, with this bill, we would be disallowing the person that has that permit from going into the supermarket with their weapon. Is that correct?
We would not. They would be allowed to enter the supermarket with their firearm if they were permitted and if the store allowed it.
Thank you very much.
Okay. 4 more. We're going to start over here. Boucher, Stewart, Schmidt, sorry. Got the first part right. Boucher, Schmidt, Tolles, Young.
Thank you, Chairman. Thank you, Senator, for being so thoughtful and patient in your presentation. We heard the importance of data and statistics. Is there any data to show the percentage of gun violence perpetrated by illegal gun owners?
That data is not collected.
So I'm a bit confused. And then why does this panel find licensed and legally trained armed citizens scary and dangerous?
I do not.
Okay.
This committee has passed other legislation by the vice chair of this committee dealing with illegal firearms. We can walk and chew gum at the same time. We can both deal with legal firearms in a post-Bruin world, as well as deal with the epidemic of crime traced to illegal firearms. And so this is one portion of a larger solution. And this committee and your chamber have already passed legislation that is the other part of that solution. I think we can do both.
Thanks for your reply.
Thank you, Chair, and thank you, Senator. I just have a quick question. It was brought up earlier regarding, and it's some of the questions that we've heard already. A lot of the guns that are stolen out of vehicles. So let's say we have a permit to carry a weapon, and we know that we're not allowed to carry it in these spaces any longer, and we leave it in our car. Does that present more opportunity for stolen guns, is my question.
So,
And I'm surprised it hasn't been asked yet,
No.
honestly.
I'll just point out that on page 7 of the bill, at the bottom, 26 through, I think it's 30.
Yep, I have it right up here on my screen, number 10,
There
yep.
is a provision for leaving a firearm in an automobile. You would do so unloaded and in a suitable container. So I think most indications are that when it's stored properly within the vehicle, you significantly reduce the risk that it will be stolen from the vehicle.
I guess my question would reference, though, would the criminal now know that maybe a gun could be potentially higher probability of a gun in a car? Even if it's unloaded, they steal the gun, they go and buy ammunition, and then we have a connection that it becomes a circle of more guns on the street, more opportunity to steal guns. I'd rather have it be on the person than in the car.
It's a significant problem. It's definitely one that I think this language does address. I mean,
Okay.
it's more than just unloaded and with a trigger lock on it, right? You want to secure it in your vehicle some way. I mean, some gun owners probably know this better than I do, but
Yeah, I'm not a gun owner.
There are devices
So-
that have the boxes. Literally, you can slide them under your chair, and the cable links to
Sure.
the metal workings of your car, which significantly reduce the risk in that scenario. So.
All right, thank you. Appreciate that.
Thank you, Mr. Chair. Hello, Mr. Vice Chair.
Hello.
And the rest of the panel. I just want to well, first I have another question, but I want to piggyback off something that my colleague here indicated in terms of the being in a car, because I have a constituent who years ago was involved. I guess he had like a routine traffic stop, and he didn't separate, he owns a business, citizen, law-abiding citizen, and he did not separate his ammunition from his gun, and it's been haunting him for the past 20 years. So based off this on page 7, this 10, is there, what could be done about that in this bill in terms of addressing someone that's a law-abiding citizen, traffic stop, police search, didn't separate it? What could be done there?
That's a good question, Delegate. So Section 10, which I earlier referred to as the safe harbor provision of the bill, is not a requirement at all times. It is an exception to the sensitive places portion of the bill. And so this provides a safe harbor that if you are going to a sensitive place, you can secure your firearm unloaded and in a locked container and be free from any criminal risk. So this section of the bill does not apply generally in society. The current law would apply in every other situation. But This was designed to allow people who regularly wear or carry, if they're going about their day and they happen to be going to a sensitive place, that they have the ability to do so without having to return to their home to secure the weapon. So this safe harbor was designed to protect people and not jam them up. That's why it's in the bill. So if you're traveling and you're heading to a hospital, you can secure your weapon unloaded and in a locked container in your vehicle and go onto the grounds of the hospital without any legal risk.
And you don't have to separate, because I think current law, you have to separate your ammunition, so you would not have to separate in this safe harbor provision, you would not have to separate your ammunition from your weapon.
You would at line 29 and 30.
Okay, so I'm sorry, locked and contained. Okay, got it. I'm sorry, I didn't see that. All right, I mean, didn't pay attention to it. Thank you. He was texting me and trying to get to what his issue was.
Completely fair, of course.
So thank you. Then I heard Stu's question here. So my question is, a couple of my colleagues here indicated, this is my very good friend, everyone knows that. I'm sensitive to him. So one of the questions that some of the questions that my colleagues asked was, hey, can you have your weapon out back, playing, your kids playing in the backyard, you having a barbecue with, your family birthday party or some other holiday or some other celebration, can you have, your weapon? And I believe I know the answer to that. You can do kind of what you like in your own home. Isn't that so?
That is. And it is required under Heller.
And no one is taking away your ability to be in your home to protect however you feel like you need to, your family, by visiting, you're in your home, you're in your backyard, your front yard.
That's correct.
Is that correct? Okay, thank you. Is there something in this bill that we saw different, provisions, and my bill is all marked up here, but is there like a catch-all phrase that individuals can communicate that if I'm in my home or I'm in, my second home I own, or someplace that, my car, is there someplace that I, sort of like a catch-all here, that I have the right to have my weapon on me because I'm in my home, and even though folks are visiting and being a part of activities taking place in my home?
Yeah, so I think Justice Scalia in Heller makes that unambiguously clear.
Okay.
But nonetheless, should this committee feel the need to codify that portion of Heller to make that clearer or to provide comfort to the committee, 100% open to your input and thoughts.
Okay. I mean, I kind of know the answer to that, but if some people feel that need that comfort, that's up to you all. And
It's up to you all.
Yeah. I don't think it need to be codified, but I'm just wondering. I'm just, asking the question for the good of the order. So thank you, Mr. Vice Chair. Thank you, Mr. Chair.
Thank you, Mr. Chair, and thank you, Senator and panel, for your, what's the word I'm looking for? You've been here for a long time. Endurance, that's right. Pardon me if this has been asked, because I did step out for a moment. In my district, a lot of violence. And so you have folks, I have residents, some of which have been here to testify this year, who want to make sure that they have a concealed carry permit for when they walk around their neighborhood. They don't have cars. They have to walk to the grocery store. So I think my question and concern that I want to just raise for your consideration is for those individuals who do live in those neighborhoods who, may be subject to a robbery, one walking down the street, and want to protect themselves. And when they go to the grocery store, and then they get to the grocery store, and they find out that they can't take that legal firearm inside, how do they manage? And I'm talking about circumstance again. We don't have a car that they could, put their firearm in. They're walking down the block. How can we help guide that individual to stay within the bounds of the law?
Yeah, I think that's a really good question. Thank you. So under current law, private property owners have the ability to disallow firearms on their property. This bill doesn't change it. So under the concern that you've addressed, that concern is a concern under current law, meaning the grocery store could ban weapons under current law, and could continue to do so under this bill. And as we've indicated earlier, the design of the legislation and the philosophy behind it is to keep current law intact as much as possible, and where we are legislating anew, to do it in a way that is analogous to existing sections of current law. But to the extent that earlier in the process of this bill, as introduced very early in the process, as pre-filed, it was a much broader bill that would apply, for example, on the sidewalk or in other places, just walking down the street. That has been fully and completely stripped out of the bill. The bill does not apply to places of public accommodation, with the exception of protests. It does not have a buffer zone in any of the sensitive places. It is concise, specific, and narrowly tailored.
Understood. Thank you, Mr. Senator. Thank you, Mr. Chair.
Thank you all very much. That's the first panel.
Thank you, Mr. Chairman.
In favor of the bill, we have a second panel with Laura Morris, Melissa Ladd, Ramya Swamy, please. Whoever would like to go first, go right ahead, please. Who'd like to go first, please?
I will.
All right. Thank you, please.
Good afternoon. My name is Laura Morris. I live in Annapolis in District 30A. I volunteer as the Anne Arundel Local Group Lead of the Maryland chapter of Moms Demand Action. I am also a survivor of gun violence. I was terrorized with guns and then shot and wounded by my ex-husband. I support SB 1 because looking at concealed carry as a survivor, an abuser can quickly turn from a good guy with a gun to one that can harm or kill their partner, family, or indeed anyone that crosses them. Nothing in my ex-husband's past or record would have prohibited him from obtaining a permit. He had bought the gun for protection, but in fact used it to frighten and intimidate me. To abusers, the gun gives them power over the person they are pointing it at, and many times their impulse control fails them. This bill would ensure that people with dangerous histories cannot obtain a permit to carry a gun in public. It would also require state police to revoke permits from and take steps to disarm anyone whose violent conduct disqualifies them after they obtain a permit, including those who are subject to a domestic violence restraining order or who are convicted of domestic violence crimes. I speak today as someone who knows firsthand how terrifying it is to have a loaded gun pointed at you by someone who wants to do you harm, to beg for your life, and to think that you're actually dead after you've been shot. No one else should have to go through that trauma. It's taken me years. Please support SB 1 to keep guns out of public spaces, keep permits and firearms away from those who are a danger to themselves or others, and keep Marylanders safe. Thank you for allowing me to speak.
Good afternoon, Chairman Clippinger, Vice Chair Moon, and members of the Judiciary Committee. My name is Melissa Ladd. I live in District 14, and I'm a volunteer with the Maryland chapter of Moms Demand Action. I come from a family of hunters. I am the mom of two high school students, and I'm also a part-time middle school teacher from Montgomery County Public Schools. Carrying guns in public is a tremendous responsibility. Up until the Bruin decision last June, Maryland had smartly set a strong minimum standard for who may obtain a license to carry concealed weapons in public. This was done to ensure that people who are too dangerous or irresponsible to do so were blocked from obtaining the permit to carry. We need to ensure that we are continuing that strong standard in our updated regulations. The Bruin decision dangerously lowered the bar for obtaining a wear and carry permit by striking down the state's long-standing proper clause requirement. And state law now has to be updated to reflect that decision. However, we must also seize on this opportunity to respond to the court's ruling and the resulting surge in people carrying handguns in public by strengthening and updating the many common sense permitting standards in our law so that they can continue to keep permits out of the hands of those who shouldn't have them or who pose a danger to themselves or others. The Supreme Court affirmed that states like Maryland that utilize these safeguards can continue to do so. The Bruin decision also reaffirmed that there are sensitive places where concealed carry firearms can be lawfully prohibited. Maryland should set clear rules defining sensitive places where guns may be brought, even by those with wearing carry permits. We need to keep guns out of the places where our children gather to learn and play, out of the places where our communities gather to demonstrate and participate in our democratic process, so that these places remain free from armed threats and intimidation. We also need to ensure that those obtaining concealed carry permits are thoroughly trained on the safe handling of firearms in public spaces, de-escalation, and deadly force when justified by state law. At a time when gun violence is the #1 killer of America's children and teens, as we saw so terribly this week, we need to ensure that we are doing everything we can to keep our communities safe as possible. Thank you.
Thank you. Please.
Good afternoon, Chair Clippinger and members of the House Judiciary Committee. My name is Ramya Swamy, and I'm the State Policy Manager at the Brady Campaign to Prevent Gun Violence. Thank you for the opportunity to speak today in support of SB 1. Since the release of the Bruin decision until the end of 2022, it has been reported that MSP received nearly 80,000 concealed carry permit applications, bringing the year's total of new applications to 85,266. This figure is a more than 7-fold increase compared to around 12,000 applications received in all of 2021 and around 11,500 in 2020. This is a jarring number, and absent action like that proposed in SB 1, those living in Maryland will be faced with a reality where guns are everywhere. This bill ensures that those who are carrying firearms in public have proper licensing and are not at risk of harming themselves or others. It maintains the state's requirements for background checks and strengthens Maryland's firearm training requirements to include live fire instruction and safe handling of firearms. The court in Bruin deemed the concealed carry permitting systems for Connecticut, Delaware, and Rhode Island constitutional. These states have strong permitting systems to vet applicants, which is exactly what SB 1 seeks to implement in Maryland. Further, in his concurring opinion, Justice Kavanaugh reiterated that states whose permitting systems require a licensed applicant to undergo fingerprinting, a background check, a mental health records check, and training in firearms handling in laws regarding the use of force, among other possible requirements, pass constitutional muster. SB 1 further outlines sensitive places where firearms cannot be carried, such as schools, government buildings, legislative assemblies, polling places, and courthouses, all of which have been explicitly deemed constitutional by the Supreme Court. The Supreme Court in Bruin made it clear that its holding was neither a regulatory straitjacket nor a regulatory blank check, and that restrictions on guns in sensitive places are still permissible so long as they are objective, and the measures proposed in SB 1 are objective. In the wake of the Bruin decision, we are urging this body to yet again prioritize public health and safety and protect its citizens from the threat of senseless firearm violence. For these reasons, I respectfully urge a favorable report. Thank you.
Questions for the panel? Thank you very much. That concludes that panel. We're now going to go to those in opposition. Going to hear from John Jocelyn, Mark Pennack, Katie Mooney, Katie Novotny, please. Carla Mooney, Katie Novotny.
Thank you, Mr. Chairman. Mark Pennack, I'm the president of Maryland Show Issue. I'm an opponent of this legislation, and let me tell you why. The bill, although far superior than how it started out, still outlines hundreds and perhaps thousands of locations in this state which are punishable by imprisonment if a permit holder strays into them. There's no knowing, there's no mens rea requirement, there's no willing requirement. A simple mistake, it will do. And I'll give you an example. It bans government-owned buildings. Entry into a government-owned building are controlled, are leased by the government, but no signage, in contrast to federal law, which Section 930, which requires a sign. We ask only that you put a decal on the door. which is what the government does, the federal government, in order to have conviction under this statute. That's the least. Now we have video lottery facilities. And the definition for that is set forth in the statutory provision that says it means any place, any facility, and facility is not defined, facility that is actually has a terminal. Any terminal. One will do. And that's a 7-Eleven, a Royal Farms, you name it, a Corner Mart. So if you pump your gas and you go inside to use the restroom, you're entering a facility. Indeed, you may be at the facility when you're pumping the gas, because it's not defined. So what you're doing with this bill is using a whole bunch of definitions that were incorporated from civil regulations that were designed for totally different purposes and incorporating them into a criminal statute that is vague. Nobody knows when you're trespassing in there. Delegate Bartlett, you're absolutely right about the LEOSA provisions. There are actually 4 flaws in this, and they're outlined in my testimony, and you'll see how this statute violates all 4 of those.
Good afternoon, Mr. Chairman, members of the committee. John Jocelyn speaking in opposition to Senate Bill 1. As you saw and heard earlier, how exciting it was trying to decide what the bill really says, what the law really says. Now imagine the challenge for the instructor. We are now required to teach not only Maryland law, but federal law. We're required to teach on topics for which there is no law, specifically self-defense, defense of others, defense of property. There is case law, but there is no statute. I have verified this with the Maryland State Police, and in my testimony, my written testimony, you have everything they have responsive. We are now required to teach topics such as conflict de-escalation and resolution, anger management, suicide prevention. We are very good at teaching firearm safety and operation, but we are not trained for these topics. This raises the issue, what happens when we try to get insurance, professional liability insurance as instructors, when our carrier finds out that we're now teaching things for which we have no qualifications? I strongly expect that when they learn this, they're going to be no longer interested in insuring us. You should know that hunter safety instructors have $400,000 of insurance as part of the state self-insured program. The state provides a complete syllabus of what they're supposed to teach. Senate Bill 1 says teach this, but doesn't say what we're supposed to teach. It gives us the most general outlines. On a slightly different topic, not exempted under this bill, special police officers, armored car crews, private detectives, and bailiffs in court where they are armed. They are not exempted under this legislation. They would be banned from these facilities if this bill passes as it's written. Therefore, we strongly hope that you will render an unfavorable report on SB 1. Thank you.
Good afternoon. My name is Katie Novotny. I'm come to you from District 35B. I strongly oppose this bill. So this bill is in direct response to Bruin. Just because people do not wish to have firearms near them does not mean that the public does not have a right to armed self-defense, as Bruin has decided. I'd just like to make that clear. In my written testimony, I have a link to the New York Times article that was kind of briefly referenced earlier about a source of crime guns being stolen from cars. And this may very well be accurate. It likely is. But under this bill, we're putting more guns in vehicles. Cars are easily broken into. It's very easy to break a window, and even if you have it in a lockbox, many of us firearm owners have in our vehicle already a small lockbox. Preference, use a little cable, attach it to your seat. Great idea until you can go in any hardware store and buy a cable lock. Very, very easy to cut one of those. Boom, take the little case, stick it under your jacket, off you go. You can break into that at your leisure. Requiring the storage and the safe harbor provision for these sensitive areas to be unloaded. Now it's even more handling of firearms, which gives more opportunities for negligent discharges. It'd be much safer if you could leave it in your holster, and put that in. Even better, allow us to have it in our waistband where it's most safe. Less risk of negligent discharge, less risk of theft. Furthermore, restaurants that serve alcohol, that's banned in here. Even if you're not drinking, even if you're not sitting in the bar area, cannabis is covered as well. And that's absolutely absurd. There is no historical analog to that, and it's ridiculous. I request an unfavorable report. Thank you.
Questions for the panel? We also, I included in the first group Ms. Mooney. I don't see her. I don't know. Well, come on up. I called you up. Come on up. It's all right. We'll let you go. All right. Go ahead there for 2 minutes, please.
Good afternoon. Thank you, committee, for giving us a moment to speak. My name is Carla Mooney. I am a professional firearms instructor. I am a mother, a wife, a daughter, concerned citizen. I am the chapter leader and state leader for the Armed Women of America. This is a national program. I'm also the state director for the DC project, which is Gun Rights for Women. I represent a lot of people in this state. I wish I had more of them with me today, but I do have quite a turnout this morning. We have a lot of information going out today that changed since this started, and I appreciate that they worked really hard to make these changes. Our concerns are very, very clear that we want the ability to protect ourselves when we are victims of violent crimes. We tend to carry a firearm from that point on in our lives as a deterrent for that person that thinks they can continue to make us a victim. By having protection doesn't mean I go somewhere where I shouldn't be. I go somewhere because I have to be. These places that you list are many places that I have to be. Does that mean I need to be a victim in that place too? You talk about crimes of violence at home. Yes, it happens at home, but then that person was our domestic partner in many of those cases. So now if you go in public and you're trying to protect yourself, you no longer can, because those public spaces are safe spaces. Signs don't make it a safe space. I'm sorry, neither do pieces of paper that say they're not allowed to be near us. I ask you to give us an unfavorable report on this bill.
All right. Questions? We'll start with Delegate Arikan, then Delegate Kaufman, then Delegate Grammer.
Thanks, Mr. Chair. Thanks, you guys, for being here. I just want to touch on, there's been some discussion of the carrying and the transporting. There seems to be some misunderstanding of the current law as well as what the changes are going to be in terms of transport. Currently, it is my understanding that someone with a permit actually doesn't have to carry to transport their firearm unloaded. That's not really how it's done now. So can you tell me what's changing? Anyone who wants to comment?
Sure. This is largely controlled by Section 4-203, of which you referred to earlier. And of course, a person with a permit under 4-203 is in fact allowed to carry fully loaded. That's the whole point.
Right.
So it's absurd to make them unload, particularly unload in confined quarters of an automobile where the risk of negligent discharge is more pronounced than any other place because it's cramped. So, and you were quite right earlier, Delegate Arikan, to say that every permit, and I have one too, that says on the back of it, not valid where firearms are prohibited by law, and that's all these areas now prohibited, and there are thousands, as you say, in Maryland now prohibited. That if you carry inadvertently in one of those places, because no notice is required,
right,
then you are violating the terms of that permit, and that permit language is right out of Section 4-203B2, cited by the chairman earlier, in which in 2013, this committee and this body added, subject to the limitations placed on the permit under Section 5-307. And that limitation on where invalid, where firearms are prohibited by law, is placed there by the state police under that provision of 5-307. It is therefore a limitation on the validity of the carry permit under 4-203B2. Therefore, you're absolutely correct, and so is the chairman, that you can be punished for violating under 4-3 any of these zones.
Right, yeah, that's what my reading of it was as well. I just want to touch a little bit more on why right now, after Bruin, a lot of people were wrongly penalized for improper transport. So Delegate Tolles mentioned her friend that she had who got in trouble for not removing. That person was likely denied a permit unconstitutionally and was then punished because he was carrying in this vehicle in a way that was improper under an unconstitutional law. So is there any recourse for people like that who were prosecuted for failure to transport properly?
No, because of sovereign immunity of the state.
Ah.
So the state has protected itself. If 4-203 had been enacted by a municipality, then there would be compensatory damages under Section 1983 and attorney fee award, but we can't do that against the state because of sovereign immunity.
Right, so instead a lot of people were criminalized totally unnecessarily,
Exactly right.
unconstitutionally, and they lost rights for no reason.
And indeed, when Buren was decided, the instruction went out that persons who were basically arrested without another crime and who otherwise weren't disqualified for carrying a weapon could no longer be prosecuted, and the state's attorneys throughout the state dropped those charges because they were exercising a constitutional right affirmed in Buren. And there was no way for those persons to get a permit earlier.
Right, that's good. Unfortunately, we can't go back and help people that were harmed. so
Unfortunately, that's right. And you can't even get it expunged.
Yeah.
If I may, Delegate, it's actually even more murky now. Under 4111B10, a new twist has been entered. It was before that if you didn't have a carry permit, you could transport your handgun in an enclosed holster or case, unloaded with ammunition separate. Same applied for dealing with a long gun. But under 4111B10, it now says that it must be unloaded, no change, locked in a container. That is new. And many firearms are carried in soft-sided cases which have no locking feature.
Right.
The average citizen is not going to realize that this change has occurred. And this again goes to illustrate my point of the question of how do we teach the law when it's so confusing that even we sitting here wrestle with it.
And also, I don't know if anyone's noticed, but cars are in fact locked containers. So why even have it at all? Thank you, guys.
Thank you, Mr. Chair. Mr. Pennick, it's nice to see you again. You're a very good orator and advocate for your side of the issue. It's always nice to see you. I learn from you.
Thank you.
My question is, do you agree at this that at times guns can be lethal?
All guns can be lethal, Delegate.
Exactly. So what I want to know is you and Mr. Jocelyn, and it's certainly you're right, but we've gotten to be fast friends because each time there's a gun safety measure, here you've come to oppose and you do it eloquently, and that's your right. But, you know, it's very easy, sir, to emulate Mrs. Reagan and just say no. But the issue is, are there gun safety measures that your organization, is in favor of or would support? Because we have shootings, it seems, every other week, and I'm just curious: are there regulations that you'd support? Because current gun laws obviously aren't working, which is why we need strong bills like this and the chairman's bill. But I'm just curious: are there any, regulations or legislation you'd support?
Sure. In fact, I worked with JPR very extensively on SB 858, which is the Jalen's Law cross file. And
can you say that again? I
that's
just couldn't hear what you
SB
said.
858. That's Jalen's Law. That's the storage bill. in which we reached an understanding about how storage could be accomplished and the state code can be amended in such a way that both respected the right established in Heller and which also would promote state safe storage. We also strongly supported Senator Carter's bill, which is now incorporated in 858, that would actually fund through a tax credit the purchase of gun safes, safe storage again, by ordinary persons so that they can actually have a stake in making sure that they safely store these firearms. So we think that's a very big contribution to the law, and we were delighted to work with JPR in doing so.
Well, I'm delighted to hear about that. Hopefully, you can, next session, support some bills that come before this committee so you and I can have a nice kumbaya moment.
Delegate Grammer.
Mr. Chair, good to see everybody. It was mentioned that we don't want to have guns in places of democracy. I'm not going to talk about the guns in this room. Ms. Novotny, how many guns did you see? How many men with guns did you pass when you came here today in this building?
I ran out of fingers.
Okay. Mr. Jocelyn, you had some comments about the training requirements. Could you just walk me through that one more time, please?
Yes, under the terms of the bill, what they're adding to it is additional training. They have added in the bill training on Maryland law, non-specific Maryland law, and now federal law, also non-specific. So we really don't know exactly what course material we're supposed to cover. We're required to teach in areas of self-defense, defense of others, and defense of property. In 1999, I sent a Public Information Act request to the Maryland Attorney General asking about these particular topics. And what I received back from the AG was that there's nothing in Maryland statute, and he cited several case laws, some of which were not in Maryland at all of which I downloaded, none of which I feel qualified to teach based upon that particular instance and that particular decision. We have no guidance from the state on this at all. We've asked for it, we've not received it. In point of fact, I submitted my handgun qualification course to the Maryland State Police for their approval as an alternative program, just so I would have something from them to protect me legally and from liability saying, yes, my course was approved. I submitted that in October of 2022, and I'm still waiting for a reply.
Okay. Mr. Pennack, what is the general purpose of mens rea?
Mens rea, as defined by the U.S. Supreme Court and by the Maryland Court of Appeals, now renamed Supreme Court, ensures that people who are morally culpable are suitably, the criminal law is limited to punishment of these people who have actually willingly, unknowingly committed the crime, and not is contrast to strict liability. Unfortunately, 4-203 is a strict liability statute, as the Maryland Court of Appeals held in 2021 in Lawrence versus State. So it doesn't take any intention at all to actually violate 4-203 or to wander into some place where you're not allowed. It's simply if you happen to be there, that's good enough.
Right. So there are clear problems with criminal law 4203. What about this bill?
This bill doesn't do anything about remedying those problems. This has been a priority for me because the Maryland Court of Appeals in the Lawrence case said that they had major problems with the lack of notice afforded by the 4-203A1i on grounds that it basically punishes possession of a firearm, a handgun, on or about a person. And they found that that was inherently vague for a strict liability statute and specifically signaled, and that's the word they used, signaled to the General Assembly that this was a problem and please fix it. And to date, the General Assembly has ignored them.
Let me restate the question. If I want to prevent the problems in 4203 from occurring in this bill, what do we need to do to prevent that if this bill passes?
You need two things. You need notice provided on the locations in which carry is prohibited, and you need a mens rea requirement of willingly or knowingly carried onto those places. That would at least allow people the option of not violating this statute intentionally. So what I'm trying to convey here is that this creates enormous traps for the unwary, and these people are without culpability.
Right. Kind of like the situation Delegate Tolles mentioned.
Yes.
One final question, Mr. Jocelyn. We've talked about where shootings happen. Can you give me your perspective on where these mass shootings happen? You know, broadly, do you have any data behind that?
In the review I've done of the shootings, they seem to gravitate towards locations where you will have a confined area, a dense population of unarmed and helpless victims, and where firearms are generally prohibited. The mass shooters are not brave people. They are not looking for a gunfight. They're looking to go out and harm people. So they pick the softest, most vulnerable target they possibly can, and that is where they normally direct their intentions. And this has been time after time. We'll see it. You don't see them going to one of my ranges and doing that. You don't see them going into a police station and doing that. You don't see them walking in here and doing that. For this reason, they know there will be armed resistance.
And on that point, Delegate Grammer, Dr. Lott testified before the Senate in January, and so you have it on a tape, and he testified on that very point that mass shooters are attracted, and this is in their own documentations that police have found after the shootings, to gun-free zones because they know that they will not be opposed in those places. Right. It's over and over again that they pick these places for that reason.
There actually was one case, the guy walked into a police station and tried to shoot him up, but that didn't end well for him. But thank you very much.
Thank you, Mr. Chairman, and thank you, panel, for coming in today. I believe this was touched on by the first panel, and I just wanted to bring this up because I believe Mr. Pennick touched on it, and I'd like you to elaborate. As this bill relates to LEOSA, you were in the middle of a thought in your opening statement about LEOSA and how this legislation will affect that. Could you expand on that? Because I do have some questions about that portion of it.
Sure. In my written testimony, I have a whole written testimony on it. LEOSA is a federal statute. It expressly preempts anything in state or local law to the contrary, and it provides for the right of concealed carry of retired and active duty law enforcement officers of every state in the union and at all federal offices and agencies. And what this bill does, it violates those LEOSA rights, which are enforceable under Section 1983, as New Jersey just found out, in 4 different ways. First, Section 4-11B does not include the active duty law enforcement officers of another state. It's limited to federal and officers of this state, or localities of this state, and that's a violation of LEOSA. Second, the Section 4-11B4 exempts active duty LEOs of another state only if they're in Maryland on official business. LEOSA rights are not that limited. They could be on personal business. Doesn't matter. Third, 4-11B7 requires an off-duty LEO or a retired LEO to display his or her badge or credential, with the point that Delegate Bartlett brought up. And that is contrary to LEOSA, because the LEOSA only requires them to carry their credentials, not display them. And fourth, Section 4-11B7 little I, 2 little I, provides that the retired LEO or LEO need not display his badge or his credentials if he has a wear and carry permit issued by Maryland. No such requirement is found in LEOSA. In fact, New Jersey tried to impose that same requirement on LEOSA officers, and that requirement was struck down in the case that I cite in my written testimony. So those 4 areas are in direct conflict with and are superseded and preempted by federal law.
Thank you for that clarification.
Thank you, Mr. Chairman.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in today and testifying. My question is in reference to the Castle Doctrine, and I'm wondering, in your courses, will you be teaching about the Castle Doctrine, and do you have any comment as far as page 7, line 18, number 2 is concerned, protecting any individual property at the location?
According to the PIA that I put into the Attorney General, he said there is no provision in Maryland statute to protect property. Therefore, you cannot use deadly force to protect your property.
But how's that related to this bill?
So as I understand that provision, and Delegate, Senator, the sponsor was correct about that. That was placed in there because numerous places of worship employ their members of their congregation to provide protection at those locations, and they provide protection for anyone there, and obviously by necessary implication to property as well. So while you can't use deadly force to protect property, when people are in the property, you're protecting both. I don't have a problem with that provision. It's just that every person who has a carry permit understands, because I teach this course, that you can't use deadly force for protection of property alone. For example, if someone was marring the surface of a property on a church or synagogue, you couldn't use deadly force to protect that property. But you might well be armed for that, because that person might be armed and might thereafter threaten your life if you intervene to stop them from doing so. It is permissible in Maryland law to use reasonable force to protect property, just not deadly force. But if the person who's committing the crime of defacing your property thereafter becomes a threat, imminent threat to your life or to severe bodily harm, you may thereafter become able to use deadly force. So it may escalate. So that's why those people should be armed.
So you're going to teach this in your course?
I do teach this in my course.
Thank you very much.
So do I.
Yes.
All right. We're going to go Boucher, Bartlett, Munoz, Young.
Thank you, Vice Chairman Moon, and thank you for the panel for being here today. Do legally armed citizens prevent crimes and protect their fellow citizens in public when crimes are being perpetrated?
All the time.
Yes. Thank you.
I know better than that. Rookie mistake. Okay, couple quick questions. So were any of you teaching gun safety prior to the implementation
I was.
of 4203?
Yes.
Okay. Yes. Because in my notes, at first I had the Second Amendment, and I thought, well, nobody here was teaching prior to the Second Amendment. Okay. So were you? No.
Yes, I was teaching before.
I believe it, too. All right. So, you know, what did you do with respect to the card prior to 4203 being enacted?
I taught the card. In fact, I spent like an hour on it. On the Maryland Michelle Issues website, there is a long list of prohibited areas where you can't go with your carry permit, and we list them. And so when I teach this course, and I go into each one of those areas, and I put up on the screen the actual language of the regulation or statutory provision in question. So, for example, carry is not banned in a rest area, but display and discharge is banned in the rest area. So you put that up on the screen and you explain it. Carry on public school property is banned, but only public school property and not within 100 yards of a buffer zone. You put that up on the screen.
Right.
So
I agree with you. I agree with you. And I think that's the way you do it when we change the law. Because this isn't going to be the last time that we're going to change the law with respect to firearms. So I want to also know, with respect to permit renewals, right? That's another opportunity to update folks, I would assume. That
Yes.
you update folks, okay. And then my other question is, and this isn't that so, and I apologize in advance, Mr. Chair. We speak of gun-free zones, but in my mind, it's metal detector-free zones. And I say that because, yes, we know that no one in this room, other than law enforcement, is carrying a gun, yet many people in this room have a permit to do so. We know that, and we're safe, and I feel safe. I don't know, I can't speak for anyone else, but I feel safe. And it's because more so than having law enforcement here, and even more so than the law saying that you can't carry a gun in here, is the fact that we have that metal detector out there. And see, what I'm getting at is, while we never know, we, meaning ordinary citizens, law-abiding citizens, we don't know who's carrying and who's not carrying. We don't know who's abiding by the law and who's not abiding by the law. What we do know is if you go through that metal detector and it goes off, more likely than not, and if they can see on the screen, more likely than not, we know that you're carrying because we can actually see the picture of the gun, okay, except for ghost guns, which are now illegal anyway.
Even ghost guns, delicate.
Would show up on, well,
Absolutely.
yeah, the photo would show up on there.
Yeah, of course.
So isn't it so that perhaps it's not so much gun-free zones that we need to be talking about? It's these metal detector-free zones. And would that, in fact, protect our children if we did have metal detectors?
I'm a big advocate of securing places, sensitive places like schools, with metal detectors and school resource officers. Because when a rampage arrives, you don't have time for the police department to arrive 15 minutes or 5 minutes later because the rampage is over by then.
Right.
So absolutely, but I would say that if you're going to use a metal detector, you better have an armed officer manning the metal detector because he's going to be the first one to go down.
Yeah, gotcha. I don't have a problem with that.
I don't either.
Okay, thank you. We agree on something. Yeah.
If I may add, Delegate?
Yes.
So I agree with you that, and that's part of the problem, in this bill, we're going to prohibit firearms at restaurants and, video lottery terminals and all these places that don't have metal detectors. And I agree with you that I feel safe here. Now, sometimes we have these hearings that go till 10 p.m. and you're walking back. I maybe don't feel safe then. But, here, inside the building, guns, metal detectors, safe. Restaurants and those type places, we know people don't follow laws. And I think part of why these type bills are brought is because we know that people carry illegally. And so law-abiding citizens are going to go, I don't like this bill, but I don't want to get jammed up. I don't want to be a prohibited person. I'm going to follow this law. And when I go into this restaurant with my husband that happens to serve alcohol, I'm going to be disarmed. And we have no guarantee that other people in there are disarmed as well. And I think that's one of the really big problems of why you have so many people here today opposing bills like this.
Delegate, if I may, to touch on your question on the firearms laws, yes, I do give my students the pertinent sections of Maryland law. I also provide them with the link to my compilation of all Maryland's gun laws that's on my website, along with an index of table of contents. It's 250 pages long, so they have access to the data. No matter what it might be, they can find it, and it is updated every time a bill passes down here. As soon as the statute's available, I update the product. As to feeling safe here because of the metal detector, if you go over to the Senate Cafe, to the outside door and knock on it, someone will open it and let you in.
Every time.
They go down the tunnel, across here, and now they're sitting here beside us with whatever they had on them. As I sat here this morning, a man walked in through the outer doors with 2 big boxes in his hand. And he said to the guard, "Do you want to see my badge?" And the guard said, "No, go ahead," and he went ahead. So as far as your security goes, it's far misplaced. I would suggest your security should be on your hip.
Well, I will suggest that we don't have a tunnel anymore, unfortunately, to some of us. It's been nice to have, but we don't have a tunnel, so they couldn't get over here that way.
Oh, to the contrary, I got there this morning.
So you mean I've been walking all this time? Okay, anyway. Anyway, I appreciate the conversation, and thank you, Mr. Chair, for the discussion. But don't, metal detectors, I think they do work to some degree. And I think that SB1 is a good bill, and perhaps the next step is we go somewhere with the metal detectors. Thanks very much.
All right, we've got Munoz, Young, and Cardin.
Thank you, Mr. Chair. I had a different direction that I was hoping to go with my questions, but to follow up on my good friend's last comments, I will point out, I think it's very interesting that a large portion of this discussion is about people feeling safe rather than
being
Being safe?
Indeed.
Because as she's well aware, she's been here way longer than me. Only the people wearing stickers in this room walked through a metal detector today. None of the legislators, none of our staff, none of us have walked through a metal detector. And so one of us could be carrying, I don't know if it's my military upbringing, my personal, martial arts training, my firearm training, I don't know, but I do not feel.
So, Delegate,
don't.
Your point is well taken, and the gentleman in the back of you in the corner of the room is well armed, and I feel safer in his presence than without him, for the very reasons you outlined. I also feel much safer in the presence of people who are armed and who have carry permits, because I know they've been vetted, I know they're law-abiding citizens, and two, they've already demonstrated competency with a firearm in order to get that permit, because it's a live fire requirement.
Yes.
So I'm safer around my fellow people with permits than I am without them.
I actually feel the exact same way. And to another point, my question was going to go back to the question I asked the original panel about keeping our children in schools safer. And if we had, extensive metal detectors and entire armed security teams at every single school across the country, at every entrance point, I would sleep better. I would feel like those students were a lot more safe.
That's a very good point, and the problem with this bill is that it covers private schools as well as public schools. Under current law, only public schools are barred from having our gun-free zones. Private schools are left to their own devices. The private schools are not eligible for school resource officers. They don't get publicly funded. So they have devised means of securing their own facilities, and this bill effectively eliminates that by confining that to armed security guards or by people who are owners. That's it. So this is something that is overly broad because it interferes with the property rights of individuals to allow people with permits to be on their premises. So, for example, private property owners are, if you want to borrow somebody, you can put a sign out there under this bill. But that's not an option for private schools. They're barred completely, regardless of whether they want permit holders on their premises. That seems to me ill-advised. If private schools want to borrow permit holders, they can put a sign out there too. They're just private property owners like anybody else. But that's not an option right now under this bill.
Okay, so you think if this bill were to pass, these sensitive places would become, I think someone previously said, these soft targets where people would go to inflict the kind of death and violence that they're intending to inflict?
Yes.
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 Absolutely. And then I actually am working with a group of domestic violence survivors on some legislation to help them. And so I'm sorry, I missed your name on the end.
Carla Mooney.
Carla, thank you so much for sharing a little bit about your story. I really wanted to ask you if you feel comfortable. You talked about how so many of the sensitive places that you will not be allowed to carry your firearm are places you have to go, that you have no other option. And so I was interested in how you think that might affect people who are, perhaps domestic violence survivors, people who are survivors of any type of violence, who carry wherever they go in order to protect themselves for whatever reason they might have, elected officials, any judges, people who have a reason to fear violence when they're in public. How do you think that would affect their lives, their regular lives when they need to go to these places? And then I'm also interested in how perhaps it might affect their sort of mental health. And like you said, it was really powerful. You said you have to disarm yourself to go into these places, and that seemed like that would be very troubling.
Very limiting. So just clarification. My story is many of my students.
Okay.
I myself am very happily married 33 years and have never had an issue. My husband is a saint. Anyway, my students have shown me why I do what I do. I've been teaching since 2015, 2016. Many, many, many of my students have been victimized, have have almost died in the hands of someone else. And the empowerment that it gives them to be able to be their own first responder, it gives them the courage to get up every day and to try to live a normal life like you and I have. They don't feel that way prior to that. Many of them never really come back to a normal life because of the mental anguish that caused by someone they trusted most times. So even when the violence wasn't somebody they knew, it was still violence that scared them from normal life. Some of them, it's a lack of connection to people around them now. That difference, that lack of empowerment that came from their situation is life-changing, is life-altering, but the growth and the empowerment and the strength, the ability to have someone just sit upright after something like that, because now they understand where they can protect themselves, how they can protect themselves, and the fact that they can choose to be protected. My personal motto is pants on, guns on, and when I go somewhere, I don't have to be scared. I am aware. I have my head on a swivel. I'm looking for that person that doesn't ignore me but wants to follow me. I don't want to be a victim, and I'm going to choose not to be. That person needs a lot more encouragement to get out of the shell of I'm a victim. We have a whole community of victims that are 16, 15, 16, 17 years old because they've been hiding behind a mask for the last 3 years. Those are the people that need help. This bill doesn't have anything to do with them, but domestic abuse and what happens at home when they're locked in their home, that's definitely a lot of the issue that our folks need our support for,
And
being able to do this.
The issue is bigger. Under prior law, judges and prosecutors got carry permits for the asking. They still had to do the course, but they were deemed to be presumed risk occupations. I got my first permit under that. So these people who will no longer be permitted to carry their presumed risk weapons with them when they go to the grocery store if there's a sign there, or to the 7-Eleven if there's a video lottery terminal in the 7-Eleven, or to otherwise go about their daily places where they could have carried prior to this point. That means that these judges and prosecutors and the like are now placed at greater risk because they're disarmed in those locations where they would not otherwise be disarmed prior to the enactment of this bill. So you are not even putting people who suffer the abuse at the hands of others at stake. You're putting people who are high risk, that the state police have recognized to be at high risk of assault, at greater risk as well. I mean, what's the justification for that?
Yes. Some years ago, one of my activists was down here with me, and there was a gun control group doing a function, and this lady activist had printed these beautiful 6-inch diameter circular signs that were the circle with a slash and a firearm on it, and it said, "This house is gun-free," so that they could speak to, tell the whole world that they're gun-free. They all wanted them, right up until the time she gave them, and this harks back to a previous testimony, a waiver that said that she would not be held responsible if they were victimized because they'd put this gun-free sign on their home. Not a single person took one. They didn't want to advertise that they were defenseless. This very same lady, when things were getting bad near her home, had families come to her, the husbands, saying, "If things get bad, can we come to your house?" Now, they made fun of her because she was a gun owner. She said to them, "Your women, your children are welcome to my home, and I will protect them. You gentlemen are on your own."
That's powerful. Thank you.
All right, we have Delegate Young, Cardin, and then Phillips.
Thank you, Mr. Vice Chair. Earlier, my question has to do with the classroom instructions. Earlier, you referenced some of the barriers. Can you just repeat that? It's been a while. And then what the concerns you had about what the current draft had with regard to those classroom instructions?
The course has been increased from not just Maryland law, and it's nonspecific as to what parts we're supposed to teach, how extensive, but it goes on to federal law. And it goes to the point also that it doesn't really say which parts you teach, how you teach them. It doesn't go into the fact that some of the things you're supposed to teach, there is no Maryland statute to teach. And it also contains a provision that you have to be teaching these courses, some of which you're not trained for. And many of the points in SB 1 are not even relevant to carry permits. They apply more to the handgun qualification license and not at all specifically to carry permits. So now we're being required to teach things that are really extraneous to the original topic.
So I understood your point with self-defense, although I do think, you could probably leverage the case law. You talked about things that you aren't trained to teach. My question then becomes, it's a business to teach. Is there any reason you wouldn't be able to outsource those topics to supplement your course?
I have never, ever accepted funds in return for my classes. I do it free because I believe in it.
Mm-hmm.
So anything that I outsourced would be out of my pocket.
Okay, so understanding that barrier. Thank you.
So this course is already very expensive. The average cost is at least $400. If you start outsourcing things like de-escalation and anger management and suicide prevention, which are on this list, to outside professionals, I mean, these people are expensive, and that cost is going to go up rather dramatically. Mm-hmm. So now you've limited the exercise of the constitutional right to the rich.
And these outsourced people would also have to be certified as instructors by the Maryland State Police. And they probably would not have the credentials to meet all the criteria, because there's no provision for someone who just teaches conflict resolution. It's a package that you have to be qualified for.
Give me more to think about. I appreciate it. Thank you, Mr. Chair.
Thank you, Mr. Chairman. Just two quick questions. First of all, after you had, this is to Mr. Pennock only, after you had testified about video lottery terminal facilities, I looked up state government article 9-1A-01, and that is actually a term of art defined that it's a specifically to a casino or a facility that has table games. So
Video lottery terminals.
Video lottery terminals is a facility that has video lottery terminals and table games. So it would be only, or is defined as a casino.
I think it's disjunctive.
So I think you need to just, that's just one, I mean, you may want to just recheck that, that's all I'm saying. But my question is, would you, if, the other thing you would testify to is that there's an issue that you would be, you're just worried that people, that legitimate, law-abiding, wear carry permit holders are going to possibly go into a government building, not knowing it's a government-owned or government-leased building. And I understand that concern. I can feel for you. Would you support the legislation if we required there to be some sort of decal, like we have, like the bill requires for people to say in their homes that you're not allowed to have it? We just put it conspicuously. If there would be some sort of conspicuous notation that this is being leased or owned by a government official as defined in the code, would you then support the bill?
So I'll answer it this way. I will take it off the list of counts and I will file the complaint. I have an example of the federal sticker or decal that they use in federal buildings on written testimony. And if that was on the door of government buildings, I'd take that right off my list of things on counts.
You're not yet on the positive. You're just less negative.
Well, no, because there's a reason for that. I want to be able to go in a restaurant and get a bite to eat. I don't drink. But I would like to be able to get a snack or do a walk-in to a restaurant for a takeout in a place that serves alcohol. Okay. And not leave my firearm unloaded in a gun in an automobile, which I have to unload it, store the ammunition separately, put it in a lockbox, handle it, and I teach this course. I teach you don't handle your firearm unnecessarily. because the risk of negligent discharge is increased every time you do that, in the car especially. So I would have to do all those risky things just to go in to eat, and then walk out again, and reverse the whole process. So that's insane. I'm sorry to be that blunt about it, but it really is insane. And the same thing for some of these other locations. There's really no historical background that's justifying these other locations, so those are going to be accounts on the complaint.
Okay.
And the more carry permit holders you have, the fewer customers these facilities will have.
I got you. Thank you.
Delegate Phillips and then Tolles.
First, I want to ask a question because I think I heard very clearly from the Vice Chair of Judicial Proceedings, page 7, lines 12 through 17, seem to me, and I want to get clarification, to address this issue of private schools, other private facilities having the ability to have someone there to protect them with or without remuneration. Is that correct? Am I misreading that?
No, you're not. That's correct. It's people who, without remuneration, are a paid security guard or the owner.
So when I use the example of in the Baptist church on Sunday morning, the deacon is going to carry, and the deacon's he's got to wear and carry, and this has been going on for most of my years.
I hope he does.
He does. He does. In Baltimore City. Am I right, Delegate Young? Right. So this doesn't take anything away from the ability for someone to be available.
That's a fine point, Delegate, because he has to be the owner or the lessee of the facility, and I'm assuming your deacon isn't the owner.
He doesn't have to be the owner.
He has to be a person who does so without remuneration or compensation.
Correct.
Now, is he
a person? Wait a minute, let me make sure it's clear. A person who is authorized by the owner or lessee of the location to wear, carry, or transport a firearm at the location for the purposes of.
Without compensation. Now, I'm assuming your deacon gets paid.
Deacon doesn't get paid, but he can get paid. Employment as a security guard licensed under the occupation article.
But security guard is a licensed profession in Maryland. So he's not a security guard, I'm assuming.
So if we clear that language up, at the end of the day, we're saying if the person is permitted, they ought to be allowed to carry the gun for the purpose of protecting the facility. We agree with that?
Oh, absolutely. We agree with that. But this bill doesn't quite do that.
I think it's wording, but we could get the wording cleared up. I do want to acknowledge what Delegate Cardin said, and I do want you to look that up. The VLT is a specific term of art associated with casinos. It was used, that same language is used as something completely different, but has to do with funding for minority businesses, and it's not for horse racing machines. It's only for those machines that are in the casinos.
I would like for you to define it in such a way that everybody understands it, so they don't walk in and stand there
thinking that they
arrested.
can't go with a 7-Eleven. We got
Right.
you.
Same thing for healthcare facilities, which, by the way, is a very broadly defined term if you look to the cross-reference, which wasn't designed to regulate firearms at all. Some of those terms are extremely vague, and that's detailed in my written testimony. And like a place you primarily use for physical rehabilitation, is it a facility? Is it the place that is the home residence? Or is it some other place? And who in the hell knows what primary means? So these are sort of the terms that you're incorporating in this bill from other parts of the Maryland law, which weren't designed for this purpose at all, and therefore lack the specificity that's required in a criminal statute. So that's the problem we're talking about, is notice. If you want to punish permit holders who stray, at least put a mens rea in, at least gives them a definition that they can understand, and at least put signage out. That would take several counts off my complaint. And I would be delighted if you did.
So I do have to, I can't ask this as a question, but I will end it with our favorite term of art. I heard this conversation about accidental discharge. Accidental discharges happen almost every single day, almost everywhere, with people who have a license to carry and with people who do not, and with people who just have a permit. Isn't that so?
Yeah, and the first thing you want to do is to minimize the opportunities for it. So you don't force people to handle the firearms unnecessarily. I teach that, I stress it, I pound away at it, because permit holders, particularly new ones, like to fondle their firearms. And we teach them, don't do that. Don't mess with your firearm until you go home, take it off for the night.
I had an incident not too long ago. I won't say what professional that I go to, who literally dropped it out of his pants pocket and shot himself in the foot. So
it happens.
It happens, and he was in his establishment. So
I would like to minimize that.
I think, can we all agree that firearms are inherently dangerous?
Yes.
It is what it is.
Yes, but let's minimize that risk.
All right, Delegate Tolles, and that'll be it for this panel.
Thank you, Mr. Vice Chair. Just really brief. Would you agree that carjackings are at an all-time high? Have you heard that?
Oh, yes, they are.
That little rumor? Yes, they are.
It's certainly much higher. I live in Montgomery County. Carjackings at the two malls in Montgomery County, Westfield and Wheaton Mall, have shot up tremendously. Carjackings are now a common occurrence in Silver Spring. Indeed, people are getting shot in Silver Spring, which is recently. So yes, it's gotten to be very dangerous.
Right. So with that being said, as my good friend Delegate Erican said, cars are not a locked. They are. What did you say? They are not a locked vehicle. They are a locked vehicle, and they still at an all-time high. Thank you. It's late, and we still got more to go. It is so I'm delirious, but not that delirious. To understood what she was saying, that it's a locked box, locked container, but as you indicated, carjacking's at an all-time high. So having your gun locked, your ammunition separated, in my opinion, will keep more citizens safe, because carjackings are out of control. So to be able to separate your ammunition, separate your gun, will keep guns out of the hands of the people that do not need to have them harming our community. Isn't that so? Questions are done. Thank you, Mr. Chair.
Well, if I may answer the question,
We've gotten a lot of feedback here. Guys, there's 7 panels of unfavorables left to go. 7. Okay. Do you actually have a question? All right. Delegate Erican.
Thank you, Mr. Chair. Okay, so let me just go back through the carjacking scenario with you really quick. Let me tell you what would happen if I was carjacked. My gun would be loaded, and I would shoot someone, and then there would be no worry about him stealing my gun, because he would be dead.
All right. Thank you very much.
Yes, it is.
All right. Good times, people. Good times. All right. On to the next panel. Thank you very much. 7 more panels, people. All right. We're going to start calling up another panel of live witnesses. If we have you here, please step forward. Christina Price, Holly Marceau, Cindy Collier, Esther Rosberg, Rex Fuller. Are any of these folks here? Please step up and take a seat. Our panel people. All right, we're going to start calling up another panel of live witnesses. If we have you here, please step forward. Christina Price. Folks online, you need to mute yourself. Cindy Collier. Fortress Train. Yeah, there you go. Yeah, so the folks who are joining us online, please make sure if you're following on YouTube, to turn the audio volume off. It's going to create feedback otherwise. All right, we're going to start with our live witnesses. Whoever is ready to go first, go ahead, and then you can just keep flipping over to the next one, and please say your name. You each have 2 minutes.
Thank you for giving me the opportunity to speak. I am requesting an unfavorable report on SB1 by this committee. My name is Esther Rosberg, and I'm a resident of Baltimore City. I am a Jew, and I am a firearms instructor. I'm grateful that I live in a country that has a Second Amendment for many reasons. As a city resident, I live in an area where muggings, burglaries, and carjackings take place regularly. My own daughter, as well as my next-door neighbors, have been mugged at gunpoint within yards of my home. As a committed Jew, I cannot ignore that anti-Semitism is rising and that Jews are vulnerable. Synagogues, a kosher grocery store, and holiday celebrations have been targeted with guns and machetes. Just last month, the National Day of Hate was announced by anti-Semitic groups to be held on the Sabbath. When I legally carry a firearm to and from the synagogue, I cross and enter many of the locations that will be prohibited if SB1 becomes law. I shop at kosher supermarkets and other Jewish places of business. I am often on call to pick up children from Jewish preschools and private schools or from Little League games or summer camp facilities. I eat at kosher restaurants that have liquor licenses. If SB1 becomes law, I will not be able to leave my home with my firearm despite all the training and applications and background checks because I'll never know when I might be entering, traversing, or otherwise running afoul of this draconian law. As a certified firearms instructor and a member of several organizations for license holders in Maryland, I know beyond the shadow of a doubt that my colleagues, students, and fellow licensed carry citizens are well-trained, safe, and make you and your family safer wherever we carry. Senator Wallstreicher had said when he introduced the bill in the Senate Judiciary Committee that he didn't want to be in the same movie theater as somebody with a gun, and the delegate said the same thing as well, but I don't think you've thought through the scenario in which someone with ill intent walks into that movie theater. That's when you would hope that I or any other well-trained individual with a firearm would step up and save you and your family. Please do not let this bill become law. Thank you.
Good afternoon. My name is Holly Marceau. I'm a resident of Washington County. I'm a certified firearms instructor. I'm a wife and a mother of 7 children. I strongly oppose Senate Bill 1. I am in opposition to this bill because it takes away my ability to protect myself and my children, along with the rights of other Maryland wear and carry permit holders. This bill strips the rights of a law-abiding citizen in the state of Maryland who have complied with all the extensive training requirements and have legally obtained their wear and carry permits. This bill will take away their right to carry in places other than their home, which essentially prevents them from being able to protect themselves or their children. Having a firearm for self-protection is a great equalizer, especially for us women. This allows them to protect themselves and not be victims. Women are the fastest growing demographic in new firearm ownership, making up 3.5 million new firearm owners from 2019 to 2021. This surge in new female firearm ownership is due to the increase of fear, targeted violence, crime, and lack of law enforcement, and their desire to be safe when they are in public. I train many women in proper firearms use and firearms safety to give them the knowledge and education to be able to carry and protect themselves and those around them. Having the ability to legally carry their firearm makes them feel safe and secure in knowing that should a situation arise, they are able to stop the threat and keep those around them safe. This bill will only penalize law-abiding citizens for legally carrying their firearms for self-protection, while criminals continue not abiding by laws. By limiting where law-abiding citizens can legally carry their firearms, you are restricting their rights to feel safe and to protect themselves. This bill is trying to turn law-abiding citizens into criminals because, thank you, please vote unfavorably for this bill.
My name is Cindy Collier. I'm also a Washington County resident, a wife, a mother, and an NRA certified firearms instructor. I do oppose SB1, and I hope you do too. This bill will not reduce crime or violence in Maryland. I know that's what you're trying to do, and we would all like that, but this bill will not do that. It simply limits where legal law-abiding permit holders can carry their firearm for self-defense. It does nothing to prevent criminals from having guns and carry them wherever they want, unless, of course, you have your metal detector. I agree with that. The only thing it does is create a list of gun-free zones for criminals to use to give them targets, easy, soft targets. Places like local restaurants or even my local movie theater that serves alcohol will become areas where self-defense with a firearm is no longer an option for disabled citizens such as myself. I can't physically run or fight, and police typically respond to a situation. They can't be everywhere all the time to help us. So I do ask that you do not pass this bill. And I want to say that should I ever need it, my firearm is my equalizer. It really, truly is my method of self-defense, and I don't want you to take that away from me. Thank you.
Thanks for the opportunity to speak. My name is Rex Fuller. I'm a retired lawyer and a concealed carry permit holder. As has been mentioned several times, and I want to underscore it, maybe in a little more dramatic fashion. This bill, SB 1, simply expands the psychopathic killer protection zones. Wherever those zones are now, we know that they look for them. And there's several incidents I'm sure everyone can call to mind where the killer actually contemplated alternative targets, but decided to go where they did because it was a softer target. And at 75 years old, I can no longer outrun anybody. I can't fight anybody off. And as a blood thinner taker, let me show you some evidence of that. This bruise is almost a month old. It hasn't gone away yet, and it won't go away for a few more months. The reason is my blood doesn't coagulate. If I get hit with a hammer, a skateboard, a machete, or even just fists and feet with punches and kicks, I'm probably going to bleed out and die before anybody can do anything about it. It's just that simple. My gun, when I'm carrying it, only gives me a fighting chance. And that's something that I'm sure the drafters of this bill really didn't take into account, because the only evidence they offered for the bill in the form of studies do not take into account whether concealed carry permit holders commit offenses or not. And I've read some of those studies. They completely ignore the subject. And I respectfully and with heartfelt reasons ask you to turn this bill down.
All right, let's roll through a few virtual witnesses. I see, why don't we start, we'll just go across the screen. John Finesty.
Thank you, Mr. Chairman. Mr. Chairman, members, guests, I'm letting you know I oppose this legislation. Most importantly, no one can even explain it. There's things in here we don't even understand. The senator mentioned that there's a bipartisan group that participated in this, maybe, but not a single member of the opposing party even voted for this legislation, so we can't really say this is bipartisan. Part of me, though, encourages you to pass this, because ultimately Senator Waldstreicher will be the greatest advocate of gun rights in Maryland when Mr. Pennick ends up with whatever he's going to do. He's testified that he fears his constituents in the movie theater occurred with a gun next to him. The same people who in over half a century have not gone on murder sprees, carjackings, armed robberies, etc. We've never needed sensitive places in over 50 years. Why now? These are some of the most vetted citizens in the state, upstanding, honest people who desire to protect their families and their lives. No criminals the senator, not criminals, the senator should fear. I submitted written testimony that things have changed. No greater example that this legislation needs to end than today. Tennessee and the children being killed by Audrey Hale. People were not safe this week in a facility that didn't permit the carrying of firearms. Example, around children. Sadly, they lost their lives in this gun-free zone, and we're going to continue to see this. No shooter picks a hard target or an area where people are firearmed, only soft targets, and no one can defend themselves. It took 14 minutes for Ellie to show up, the law enforcement community. Appreciate them being there, but it was a little late. They could have been far more tragedy than was. So my suggestion to you, since I have 15 seconds. This is poorly written. It's an incredible overreach. It creates stop and frisk in simple areas that have alcohol, and ultimately will grant gun rights to citizens. My suggestion, put a group together, be leaders, use Mr. Pennick, Mr. Levy, myself, gun advocates, the mom, put a round table together
we
and
need you
do
to wrap
something
up.
better, because this will ultimately fail. Thank you.
All right, let's go to Evan Avnet next. Evan Avnet, you can unmute yourself, and you have 2 minutes when you're ready. All right, maybe he can't hear me. How about Michael Thomas? The tables are turned. Okay, Evan Avnet, can you hear me? If so, please unmute yourself. You have 2 minutes.
I can, thank you. I'm definitely against SB1. I've already stated my opinion in the previous, when the bill previously came up. I would like to call your attention to Title 13, which is in reference to private detectives. This bill essentially bans private detectives from carrying firearms, which is nonsensical because private detectives also engage in personal protection as well as criminal investigations for defense attorneys. Right now, I'm involved in 2 criminal investigations in reference to defense attorneys. I have to interview witnesses. Private detectives also serve subpoenas, so they have to go onto private property in order to knock on the door to serve the subpoenas. It bans that. Title 19 is allowed, which is security guards, but it does not allow special police officers. These are guys and gals that have arrest powers and have been certified through Maryland Police and Corrections Training Commission. It bars them from carrying a firearm, and it also bars railroad police. And it makes no mention about armored car drivers, which is also crazy to me. I've been shouting this from the rooftops since this bill was written. Hopefully someone takes the time to listen. Certainly we don't want armored car drivers driving around without handguns because, it's just a recipe for armed robberies. And in general, my history is I've been a police officer for 15 years. I've been security consulting for 25 years. And over 1,000 traffic and criminal cases. When I was a policeman, I never locked up anybody with a handgun permit. And for that reason, I oppose the bill. Thank you.
All right, next we'll hear from Michael Thomas for 2 minutes. Please unmute yourself.
Thank you, Mr. Chairman. Mike Thomas, I'm from Hartford County. Dear members of the House Judiciary Committee, as a husband, father, handgun permit carry holder, and a Maryland qualified pistol instructor, I oppose Senate Bill 1. This bill strikes at the heart of law-abiding citizens to defend themselves against violent criminals, which is a natural and self-evident right. Laws to restrict law-abiding citizens will not reduce crime, and there is no data to support this assertion by Senator Waldstreicher and this bill's supporters. When questioned about the data, the mantra is more guns equals more crime, without substantive data to support this belief. Correlation doesn't prove cause, and it's been admitted in this hearing today that we don't have the data tracking illegal firearm use. There is evidence to support that more law-abiding citizens legally carrying firearms do deter crime and do stop criminals without the increase of the feared repercussions of more trained citizens solving everyday problems or disagreements with guns. In addition, creating these additional sensitive areas will have unintended consequences. You will be creating new soft targets, as we talked about. There's been plenty of examples of that. Other unintended consequences is that these sensitive areas will mean more guns in cars, which we've already talked about, which according to Senator Waldstreicher is how legal guns get into the hands of criminals. So we're going to create more guns in cars. Does this bill also require metal detectors to be installed and armed guards to be posted at each of these sensitive areas? If not, please answer, who will stop the criminals from entering these spaces with firearms? Respectfully, criminals don't care if an area is inappropriate to carry a gun. Again, we've talked about it. Tennessee has the law. It didn't stop the tragedy that happened this week. Offenders are ordained by and responsible to our ultimate authority, the God of heaven and earth. Put another way, you would not have any authority if it weren't granted to you by a creator. You will be held accountable for unrighteous laws that you vote for. Primary purpose of government, as stated in Romans 13, is to reward those who do good and punish those who do evil. With this in mind, I respectfully deliver an unfavorable report on SB1. Thank you very much.
All right, thank you. Now we're going to go to Charlie Watkins. Please unmute yourself. You have 2 minutes.
Hi, I'm Charlie Watkins, U.S. military veteran and Maryland state resident. The bill. Today, a Maryland concealed carry firearm permit holder has had a background investigation, fingerprint search, firearm cleaning. Therefore, Maryland is screening everyone before issuing permits to those who request one. These permits allow individuals to be able to protect themselves and families against unprovoked attacks by others brandishing weapons such as hammers, knives, and guns. I recall an incident when I was driving my car with a friend to get a hamburger at a restaurant located in Maryland. When my passenger and I were getting out of my car, someone rushed up and put a knife to the throat of my passenger. If a woman in the parking lot wouldn't have yelled, "No, that's not him," my friend and I may not be alive today. Many criminals don't care about gun law. People in incidents such as this is what law-abiding citizens need to be able to protect themselves from. I request no further action taken to prevent this event. Thank you.
All right, thank you very much. So Galen Mohammed, we don't have you on our list. Are you signed up for an organization? Sorry, can you just unmute quickly?
Yes, I am. Yes, I am.
Which organization are you with?
The National African American Gun Association.
All right, give me a second. We'll go to Jill Capper, and we'll try and track your registration down. Jill Capper, you have 2 minutes when you're ready.
Hi. Yes, good afternoon. My name is Jill Capper, and I'm a lifelong resident of Maryland. I wanted to thank you for allowing me to testify today to oppose SB1. SB1 and bills similar to it should never see the light of day as far as I'm concerned. I'm not even a gun owner. Seriously, I've never had a gun. But I believe that the crimes they are seeking to protect would just remain. In fact, if anything, I believe it would turn law-abiding citizens into criminals. And it sounds as if the focus should lean more towards mental health, but that's a whole nother conversation. This is a slippery slope, and I believe we all know it. And I'm starting to believe that if more people were to carry in public places, we'd be a much safer place, not less. You are much less likely to mess with someone if you know that they are armed. My 4-year-old knows this because it's common sense. There was a movie theater or whatever scenario mentioned earlier that is going to happen regardless, no doubt, because we have those shootouts. But I hope that a legal gun owner is also in the theater with me, as the other woman mentioned. Do you really think that the school shootings would occur if they were prepared for it? No, because nobody is shooting up police stations. I know it sounds crazy, but we need more guns, I believe. And this is why the Constitution was created in the first place. It's un-American. It's not Nazi Germany, and at the end of the day, these rights are not yours to take. You really don't have the authority, and I just can't say that enough. An unjust law is no law at all, and I think you.
Okay, I guess that was it, but I caught that it was unjust. All right, Galen Mohammed, you have 2 minutes when you're ready. Please unmute yourself.
Good afternoon, delegates. My name is Galen Mohammed. As I stated earlier, I am the National African American Gun Association's State Director for Maryland. First and foremost, even with the very minor amendments, this bill is still unconstitutional. It goes completely against the spirit and intended practice of the Second Amendment. I am vehemently opposed to Senate Bill 1. Whilst the senator sponsoring this bill claims to be doing so for public safety, if this bill becomes law, it will actually make Maryland a less safe state. We are not the only ones watching this bill. The criminals are waiting to see if their field of opportunity for victims has broadened by this bill becoming state law. Passing this bill would only disarm law-abiding citizens who conceal carry to protect themselves and their loved ones. Secondly, much of what has been stated in support of Senate Bill 1 was mere conflation. Victims spoke of themselves and or their loved ones being injured or killed by gun violence, but they never state that the culprit of said crime was a concealed carry permit holder. Neither the sponsoring senator nor the Everytown attorney could cite even one such case. Concealed carry permit holders are not the problem. Don't penalize the most law-abiding citizens of Maryland by voting this bill into law. If the end goal is public safety, then I strongly recommend removing the military exemption, which allows current and prior military personnel to be exempt from the training for the wear and carry license. This allows individuals to publicly carry concealed handguns with no knowledge of Maryland's concealed carry gun laws. I urge that this bill receive the unfavorable ruling that it should have received in the Senate Judiciary Committee. I stand ready for questions.
All right, thank you very much. Because of the number of witnesses left and the number of witnesses on this panel, we have 2 questions. I'm going to ask you to direct it to a specific one person to answer your question in advance of your question. If you can please do that, and we'll go Grammer, Tomlinson. Go ahead, Grammer.
Thank you, Mr. Chair. So this past interim in my district, I represent Essex, Dundalk. A gentleman tracked, it was a pair of drug dealers, one tracked the other to a courthouse. He scoped his car while the first drug dealer was in the court, followed him up the road, pulled out a fully automatic machine gun, and started shooting him in the middle of an intersection. Criminals don't care how many laws they have to violate. I'm not going to explain to you how many laws you have to violate if you're willing to pull out a federally regulated fully automatic machine gun and shoot at somebody with it. With that said, there are still people who insist that passing laws that inhibit the ability of average people to carry a gun throughout the day, there are still people that believe this is going to make us more safe. I guess the person I'm going to direct my question to is the young lady from Baltimore City. Without exposing your personal safety, can you tell us, can you share with us the breadth of places that you carry a firearm for your personal safety? And you mentioned a couple places, kind of like the places you visit in a day, the deli. Can you maybe touch on the scope of where it's normal for you to carry a gun for personal protection?
Well, if I'm leaving my home, the first thing that I do is I put on my gun, and I'm concealing my gun. And it's actually very difficult for me to take it off in a way that doesn't unconceal my gun. So if I was going to leave it in my car, I'd have to crawl into the back seat and kind of, but that would be whenever I'm out of my house. So all day long, wherever I go and whatever places I have to be, if I'm shopping, if I'm working, if my daughter, who does drive kids around very often, will call me in the middle of the day and say, hey, I can't make it to the Little League pickup in time. Can you go and pick them up now? Okay, that's, if I can't do that without stopping, unholstering, and doing whatever it is. I'm also afraid it's like not only that with somebody, if somebody's carjacking my car, I'm more worried. I look and see whether my car's still there in the morning. If my gun was in my car and I've got a safe in my car and it's cabled to the seat, but I think that if my car is stolen, I've got the same paperwork I have to file about losing my gun as if it was taken, stolen out of my house. So just in general, any place that I would go during the course of the day, I expect to be armed. I'm also, because I'm on the security committee of my synagogue, if something were to happen there, I would make sure, and I was not at home, I don't want to have to go home, find a gun, and then go and find out what's going on there. So there's no reason for me there should not be a reason for me to have to remove my gun during the day or leave my house without it, because this is what I use for my personal protection.
For you, so you're talking about family get-togethers, shopping, places of worship,
Exactly.
just fluid going throughout the day. And
Right. And if I have to stop and think, if I turn this corner, or if I drive past this place, or
I
if
drive
I
through Towson University.
pick somebody up at hang out with friends who have kids in a park, or, in a playground, or any of those kinds of places, it's crazy to have to think, do I have to just be unarmed today?
Right.
I don't want to ever have to be unarmed today. I came here, I'm unarmed today, but
Could I
other than
potentially
that,
get 4 years and 3 months in jail for?
and never be able to own a firearm again.
Thank you.
All right, Delegate Taylor.
Thank you, Mr. Chair. My question is for Galen Muhammad, my constituent. Thank you for testifying today. You are a firearms instructor also, right?
Yes, ma'am.
How would this bill, if enacted, affect your business? And you've also written me about the new rule with regard to the change in the special purpose area yardage from 1,000 to 100 yards. Can you speak to both of those, please?
So it would greatly affect me because, number one, because I am a firearms instructor, I don't just carry my own, concealed carry. I also carry several firearms for my students. I may go to the range, I may shoot my handgun, then I may switch over to my AR, my shotgun. So I'm carrying multiple firearms to and from the range. The reason why, and I got my permit to carry before brewing. So, and the reason why it was issued to me because I am a firearm instructor, and the state police are aware of the fact that if I carry my firearms as a HQL holder, a license holder, my firearms have to be unloaded. And that's the prime time for someone to actually come and at knife point, take all my firearms from me with the ammo. So that's why, again, like I said, I definitely need to keep my concealed carry permit as a concealed carry permit and not an HQL 2.0. As far as the yardage, I know Senator Feldon questioned, he brought it to the attention of Senator Wallstrecker. He said, well, I'm going to do you a favor. You know that current state law states that you can't be within 1,000 yards of a demonstration. He said, so you can lob rounds in a lot easier at 100 yards than you can at 1,000. And the senator said, thank you. And I thought for sure that piece would at least be offered or accepted as a piece of friendly amendment, but I see it hasn't been. And I was curious as to why that happened.
Thank you.
You're welcome.
All right, thank you very much. Go ahead.
One last question.
Yep.
Thank you, Mr. Chairman, and I'd like to thank both of the witnesses that have come down from Washington County today. I really appreciate your testimony. And this is for either or who would like to answer this. Could you put it in perspective in some of the rural counties in which we are members of? If you're in a prohibited location or a safe zone, just how far away, if something would happen, for a law enforcement response in some of our counties, like our counties might be, and why this legislation, why it's so critical to have wear and carry to protect ourselves. And that could be for either one of you ladies.
They will never make it in time. It's probably 15 to 20 minutes if you're lucky.
And I use as an example, say South County or any parts of our county.
Exactly. Even with some of the towns having a local police force, they're not 24/7. They are supplemented by the Washington County Sheriff's Department, so they're even wider spread. You know, it really would
A 911 call is not a 2-minute response.
No, it would be 2 minutes till you reach the operator.
Yeah, actually, yes.
Thank you, and thank you again for coming down.
All right, thank you very much. We're going to keep bringing up more witnesses to the panel here. I'm going to start calling names. If you hear yourself, please come up. Gary Paretsky, Wendy McGowan, Kathy Wright, Cheryl Vernon, Stephanie May. All right, whoever would like to begin, you have 2 minutes.
Good afternoon. Thank you all for your time. My name is Gary Paretsky. I am here in my capacity as president of the Beth Abraham Congregation in Baltimore City, where I reside with my family. I'm also a practicing attorney. Before I get into the specific issues I have representing my synagogue, I would point out I have been following, as I'm sure you are, the legislation, and stuff keeps getting enjoined, and my concern is that this piece of legislation is not ready for prime time and will just wind up somewhere stalled in the Fourth Circuit with a preliminary injunction. That being said, as president of synagogue, one of my responsibilities is safety and security. In fact, I'm on the security committee with Ms. Rosberg, who you just heard from. I'm sorry. Orthodox Jews have seen a 69% increase in anti-Semitic attacks in 2022 alone. If I'm doing what I'm supposed to, go to synagogue at least 3 times a day. My concern is very specific and narrow in terms of my community and my congregation's parochial interest. By making it so complicated as to where and when you can carry, even with a concealed carry permit, a lot of people are simply not going to. And quite frankly, as I'm also approached by my congregants as an attorney, a lot of times I will say err on the side of caution until we have clarity. I would much rather not have you arrested and then win our appeal 3 years down the road. This is not just implicating the Second Amendment, the First Amendment as well. We are at risk, we are targeted, and we would like the ability to defend ourselves, and therefore we would ask for an unfavorable decision on this bill.
Hi, I'm Wendy McGowan, and I respectfully ask you to vote no on Senate Bill 1. I work in the real estate industry, and real estate agents have been declared a high-risk occupation by the Department of Justice. So I'm going to provide you with more facts of why you should oppose SB 1. Here is data from the National Association of Realtors, and I'll refer to them as NAR, N-A-R. According to the 2020 NAR Safety Survey, in 1 year, nearly 60,000 members were victims of violent crimes, including assault, sexual abuse, rape, robbery, and murder. And yes, you heard that correct. Nearly 60,000 National Association of Realtors members were victims of violent crimes. Almost all crimes against real estate agents are predatory, and crime stats show a predator attacks 11 victims prior to arrest and conviction. 80% of the crimes go unreported. Male agents make up 30% of the attacks. That means the other 70% of attacks are on women. NAR is working on a trauma response team. NAR gives a warning in one of the videos. If you find my written testimony that I submitted, and you will see in there, there is a warning on their video saying what is going to be shown may be upsetting. The current right to carry without restrictions into real estate listings, showings, open houses give real estate agents a possible chance to survive if or when there is an attack. SB 1 prevents agents from many legal means of self-defense, especially their constitutional rights to bear arms and self-defense. To be issued this license to carry, the applicant has to go through a very lengthy application process, including immense training, Maryland State Police background checks. Is my 2 minutes up? Okay. Anyway, there's a lot of reasons. This SB 1 also would even prevent real estate agents from doing in their regular duties, being able to protect themselves, and we wouldn't even be able to stop somewhere to use a bathroom. So this is really a bad bill, and it endangers the lives of our industry. Thank you.
Thank you, Mr. Chairman, for this opportunity to speak to your committee regarding Senate Bill 1. My name is Kathy Wright. I'm a registered voter, and I live in North Beach, South Anne Arundel County. While I'm a volunteer grassroots leader for the National Rifle Association's Institute for Legislative Action and a member of the NRA Board of Directors, I come here today representing myself. The bill is overbearing, tramples on the rights of law-abiding citizens, and makes it harder to carry for self-defense. Senator Waldstrucker has failed to explain how disarming law-abiding, trained, and licensed individuals will increase public safety. He has presented no plan to punish violent criminals who already ignore existing laws. In addition, the chair of the Senate Judicial Proceedings Committee, Senator Will Smith, recently said on a local radio show that permit holders, of which there are now more than 114,000 in Maryland, are not contributing to violent crime. Why would the state want to make it harder for law-abiding citizens to defend themselves? It seems as if this is just a vindictive reaction to the landmark ruling by the Supreme Court, New York State Rifle and Pistol Association versus Bruin, that struck New York's proper cause requirement to carry outside the home. The bill, even as amended, is still unconstitutional, and I am sure will be challenged in court, which is a waste of our taxpayers' money. This bill does not address violent crime, nor will it make Maryland safer. I respectfully ask that you oppose this bill. Thank you for your consideration.
Hello, my name is Stephanie May. I'm a lifelong resident of Maryland, currently living in Hagerstown. I'm volunteering to give a very condensed version of my testimony and have not been paid to do so. On January 6th of 1997, I became the victim of gun violence. That evening, just after arriving home from work, the doorbell rang, and while I was returning downstairs, a man named Ralph Manna, whom, without warning, started shooting through the side glass into the house. I ran back upstairs while my mother retreated into an adjacent room. Ralph left the property, went to another residence, shot and killed a beloved neighbor. From this time that took place, I was scared to death of guns. Just the sound of a gunshot mentally took me back to that night, and I relived the incident all over again. It wasn't until years later that I was able to overcome my fear. I could have just avoided it altogether. Instead, I confronted my fear and began my journey of learning how to safely operate a gun. I eventually took my handgun safety course and subsequently applied and received my concealed carry license. It is empowering. For me, it's most empowering to know that I can face a threat no matter where I am. The reason I am here today is to remind this panel, unfortunately, violence is everywhere. Without my constitutionally given right to defend myself, as this bill intends to achieve, it only empowers criminals and those who care less about the rule of law. My testimony also speaks for the hundreds, if not thousands, of women this will affect as well. As so many of them cannot be here today, I want my unique testimony to speak on their behalf, and I ask this panel to reconsider passing this bill. I thank you for allowing me to testify today.
Sorry, we don't clap. Just a rule of decorum here, just keep things simple. Are there any questions for this? Okay, go ahead.
Thank you, Mr. Chair. Thank you to the gentleman, to the lawyer. Gentlemen, thank you very much for coming in to testify. I appreciate it.
Good to see you. How are you?
Good to see you. Just want to clarify, did you think that this bill is going to deny you the ability to carry your weapon into your synagogue?
Absolutely not. I've said that's not an issue. What I said is that because of the difficulty, if I'm coming to synagogue, let's say I have to be there at 7:15, so I'm not going to be able to go to synagogue with my weapon directly from here because I didn't bring my weapon with me. That's the concern.
Right, okay. So it's the inconvenience of having to keep your weapon somewhere locked away when you go to a protected place, and then having to be able to go back to the synagogue where you might be one of the people that is the volunteer who's actually helping protect the place.
Correct, and I think it's more than just about inconvenience. It's about people make these decisions. Is the juice worth the squeeze, as we've heard? And people are going to be discouraged from carrying these weapons because they want to avoid jail time, and it makes it more difficult for us to defend our synagogue.
Okay. All right. And is there an ability for you to? I have no idea. I don't have a gun, so I don't know this answer. But is there an ability for you to store your gun legally at the synagogue if you have a place at the synagogue to store it?
I'm glad you asked that because one of the reasons I actually got a carry permit is while walking back from synagogue, a number of congregants were attacked. I called 911. I also called the local Citizens Patrol. A few minutes later, the Citizens Patrol arrived and the attackers ran away scared. I waited on the corner for the police for over an hour and they did not come. So having it in the synagogue is great, but we are just as, if not more, exposed walking. Remember, for Orthodox Jews, we are not using cars on Sabbath and the holidays, and so we're even more exposed when we're outside of the synagogue.
Okay. Wish you a happy and a healthy Pesach.
You too.
All right, thank you very much. We're going to keep calling more panels. Tim Hafer, Rebecca Hafer, Donald Chris, Leonardo Marino Ramirez, Diana Miller, all right, whoever would like to go first.
My name's Tim Hafer. I'm the president of Hafer's Guns and Gunsmithing. I own 2 stores, one in West Virginia, one in Maryland. I'm a prior law enforcement officer.
I'm sorry, you're hanging a little bit off the screen. If you might want to switch seats with someone while you're speaking. Yep.
Tim Hafer, owner of Hafer's Gunsmithing and Guns, one in West Virginia, one in the state of Maryland. Long life resident of Washington County, prior law enforcement officer. I live one of the biggest drug interdiction intersections in the East Coast, Interstate 70 and 81. I know that through my training, knowledge, and experience as a prior law enforcement officer. I have the ability to make machine guns. The government's given me a license and training and the knowledge to be able to do so. I'm contracted by many places that protect you with their firearms. Yet now you're going to take my ability to protect that investment. Criminals don't abide by the law. Locks are meant for law-abiding citizens. My carry permit tells me where I automatically can't. I'm a law-abiding citizen, and I know where and where I can't. I knew not to bring one here today. Criminals don't abide by the law. You ask me that I can protect my family inside my home. Great, thank you. Now how about when I want to go grocery shopping? Because criminals carry their guns and don't care about you, me, or anybody sitting in this room. You're pandering on people's feelings. I get it. To watch somebody die, to see somebody shot, it's heartbreaking. But the only person that's going to stop a sick individual that obtained a firearm illegally is a well-trained, law-abiding citizen. Firearms are not lethal, mentally sick individuals are lethal no matter what object they obtained, not the firearm. Unfavorable vote, please. I thank you for your time, respectfully.
My name's Rebecca Hafer, and I am an NRA firearms instructor. I'm in Hagerstown, and I have the largest chapter of the Armed Women of America in the nation. We have 220 women that meet at least once a month to train on not only firearms, but self-defense techniques. And one of the things that I teach them is not to be a victim of circumstance. So don't go somewhere where you can't defend yourself. Don't go somewhere and step in it and say, this was a bad decision, and think about it later. Predators are planners. They will go to the place with the largest amount of people, with the least amount of opposition, to create the mass amount of destruction. That's what they do. So Senate Bill 01 takes that away from us as law-abiding citizens. You have just increased their platter of places that they can choose to take advantage of us as law-abiding citizens. If you tell me that I'm not permitted to take my firearm into the movie theater, I'm a law-abiding citizen. I'm not going to do that. But I promise you that they don't care. Those ladies in that group are all different ages. I have teenagers that are training up to 87 years old. Some of them have never touched a firearm before, but somehow in their journey, they are now ready. Maybe they're widows, maybe they're victims, maybe they've been exposed to somebody who's a victim, maybe they've just decided that they don't ever want to be the victim. This is not going to stop criminals. It's only going to stop law-abiding citizens from defending their lives and the lives of their loved ones. I agree that gun violence is an issue, but SB 01 isn't going to fix that. So I suggest an unfavorable vote. Thank you.
My name is Diana Miller. I'm a resident of Baltimore City. I live in the 45th District. My home borders Baltimore County in Parkville. That line actually runs through my neighbor's house. I have 2 adult children, one of whom was carjacked last April, right after I did my handgun qualification class. She was carjacked, kidnapped, sexually assaulted, and left. She was able to get help from a resident in Catonsville, and she was supposed to have her trial last week. It's been pushed back again for the second time, now to July. Her attacker was a 27-year-old man who was on parole for the exact same crime and had a handgun. I have now gotten my carry permit so that I'm able to help her when she's out and about. She now suffers from PTSD and was just a basket case for the last month preceding her trial date, and will be going through that same thing again in July. Please do not pass this bill. I live near 3 schools where I can't pass carrying it in my car. Thank you.
Thank you. My name is Leonardo Mariño. I am a Latino man, a father, homeowner, taxpayer in Montgomery County. And I have to tell you that I feel afraid to carry my firearm in public because I feel intimidated. I feel not safe about carrying my firearm because I don't know if I'm going to be persecuted or not. Now, data at both national and state level demonstrate that Black and Latino people are at greater risk of experiencing aggressive law enforcement and also disproportionate punishment compared to their white counterparts. So if the enforcement strategies that are being used today to enforce SB 1, I fear that this enforcement will exacerbate racial and ethnic disparities seen in the past. So I think that by enacting this law, we will put more Latinos or more minorities and also blacks in a risk of being persecuted in a way that would be more strict than other people. Now, these bills may be aimed at saving lives, but they also put more innocent lives at risk by denying law-abiding citizens to exercise their rights. So I believe that a proper response to Bruin would be to not only strike the good and substantial reason, but also have permitless carry here in Maryland. And I urge you to have an unfavorable report on this bill. Thank you.
Hi, my name is Donald Chris, and I oppose this bill. Thomas Jefferson said, "The laws that forbid carrying of arms of such nature that only discerns those neither inclined or determined to commit crime. Such laws making things worse for the assaulted rather than assailants. They serve rather to encourage than prevent homicides, for an unarmed man may be attacked with greater confidence than an armed man." The Bruin decision took away the good reason clause. That is about the only thing it did in Maryland or around this country. I screwed up here, but let me go. Okay, I'm going to go with this. I'm probably older than most of you in here. Until 1972, Maryland did not have a good reason clause. What happened in 1972 for somebody to sponsor a bill like this? Well, the sponsor said criminals were using guns in other counties to commit crimes. So what happens? They pass a bill, crime keeps rising to where we are today. And guess what? Thomas Jefferson predicted it way back then. Taking guns away only hurt the honest. And one big hang-up about this bill is carried in places that have liquor license. 80% of the places people go to eat. Up front, I do not drink. In fact, I think it is a gateway drug that is destroying this country today. In fact, we already have laws that prevent or make it illegal to drink and carry a gun. Plain and simple, it is illegal. I have more, but I'll leave it at that.
Questions? I don't see any questions. Oh, go ahead. And again, if you can direct it at a specific person, please.
Yeah, to the gentleman who was just finishing up. Would you mind finishing what you had written there?
Yes. Please tell me why I need to give up my right to protect myself, my family, and in all honesty, maybe one of your family members that may be attacked or have their lives put in danger while they're out eating. One last thing. This is really important because people have been lied and misled about this. Okay. That the sales of gun in relation to permits are not the same. People who own guns did not wake up, people who did not wake up, two people who did not own guns did not wake up one morning and say, hey, the Bruin law passed, we can carry a gun now, and I'm going to go get a gun. That just did not happen. Out of all my friends, I don't know one person who went out and bought a gun who previously didn't own a gun because of this decision. I know of no one who did that, period. If you owned a gun, like me, I was disabled in 2009. I applied for a permit. I was denied because I didn't have reasonable cause. So most of the people who got their permits now have been on the list and been wanting permits for years. The relationship between how many guns are sold and or compared to the permits, they just don't relate at all. I would challenge anybody to show me information where it does relate.
Thank you so much for coming and testifying today.
All right. Thank you very much. Now we're going to move on to the next panel. I'm going to keep calling names. Please step up if you hear your name. Michael Burke, Deanne Marino, Nicole Hardy, Joanne Pellegrini, Ella Briones. Deanne. All right, let's keep going then. Ari Plout, Frank Clary, Paige Burns, is that Paige Burns? All right, let's try and squeeze. You'll be the last one on this panel. Let's try and squeeze one more chair and flip seats when we're ready. So whoever would like to begin.
Good afternoon. My name is Frank Clary, and I'm from Montgomery County. I request that you vote unfavorably on Senate Bill 1. My testimony today will focus on the discriminatory aspects of this legislation, especially as related to women, minorities, and people of color. The Second and 14th Amendments protect an individual right to keep and bear arms for self-defense. Strictly speaking, Maryland is bound to respect the right to keep and bear arms because of the 14th Amendment and the Declaration of Rights. The bill violates the 14th Amendment because it rations rights to the people based on income, race, affiliation with state, and other factors. It also empowers a single state official to limit the geographic area, circumstances, or times of day, week, or month in which a permit is effective. The law entitles specific state employees the right to self-defense without cost and without limitation. It entitles veterans to exercise the right with reduced cost. Members of the public are required to pay extensive costs for the right and can only exercise the right in severely restricted locations. The law requires members of the public to pay a fee every 3 years to exercise the right. Those that can afford the fee and costs can afford the right, and those that can't afford the fees and the costs can't afford the right, and they don't get the right. Women in general are at higher risk for assaults, sexual assaults, and rape. A domestic violence victim is at heightened risk for violence and murder because a violent abuser and criminal can and will strike anytime and anywhere. This law would prevent any woman and any domestic violence victim from protecting herself traveling to or visiting any medical facilities such as women's health clinics, pediatric facilities, and elder care facilities, locations that sell or dispense alcohol for on-site consumption, stadiums, museums, locations for organized sporting or youth activities, live theater or music performances, fairs and carnivals, racetracks, and any permitted events such as farmers markets, block parties, and similar events. Due to these vast restrictions, this law obliterates the right of self-defense for domestic violent victims and women. It renders the right to those that use public transportation meaningless. Please vote no on this bill. Thank you for your time.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Ari Plout. I'm here on behalf of the NRA, respectfully in opposition to SB 1. We oppose the bill for many of the reasons that you've heard today. I'll just speak to a few of them. We believe that permits should not be discretionary. We believe the Secretary of Police specifically, should issue permits to applicants that fit the criteria outlined in the bill. The bill gives too much discretion to the Secretary to issue permits. We also disagree with the Secretary mandating revocation. We believe this role should be reversed, that the Secretary should not be forced to revoke, but should have that discretion. And then more specifically in the bill, Section 5310 of the bill, as I spoke to, the revocation must be done if the applicants don't meet certain qualifications. And some of these qualifications are very tough to meet. If one qualification cannot be met, the revocation must occur, meaning many permits will be revoked for many unfair reasons. The bill will require a lot of classroom education on many different topics. We fear we may not be able to comply with all these required classes. We believe the current requirements are sufficient and do a good job of educating the public. Many of these class requirements are superfluous. And with that, And also speaking to 5310, this would include those who have current permits and did not obtain the new training required. So this would effectively everyone with a permit. So people who currently have permits may have them revoked if they don't take the up-to-date qualifications required. And with that, I would ask for an unfavorable report. Thank you.
Is this on? My name is Joanne Pellegrini. I'm a resident of Boonesboro in Washington County, Maryland. I'm in my 70s. I am a holder of both a firearm license and a carry permit, both of which require hours and hours of education. I'm also a member of the Armed Women of America that Rebecca is head of, and we meet once a month for 4 hours. Half that time is education of some sort with firearms or shooting, and the rest of the time is supervised firing on the range. You know, I could be, to each of you, your daughter, your mother, your sister, your aunt, your grandmother, or even your great-grandmother. I've been granted the right to defend myself by the United States Constitution and reaffirmed by the United States Supreme Court. The people who are proponents of this law are attempting to severely restrict my ability to defend myself and my loved ones by making all these so-called sanctuary places. My response to the proponents of this can be found in the United States Constitution, which all of you have sworn to support. Quote, "The right of the people to keep and bear arms shall not be infringed," end quote. Thank you for allowing me to testify against this bill.
Good evening, Vice Chairman and committee members. My name is Ella Briones, and I reside in Cecil County. I am speaking today unfavorably on Senate Bill 1. Once again, we have a bill before us to impose restrictions on our constitutional right to self-defense. Law-abiding wear and carry permit holders are not the problem. We are not the ones committing acts of violence in our communities. This bill will not curb gun violence. Gun control will not keep our communities safe. Criminals, by definition, do not obey laws, and they will ignore any new laws. When are we going to hold criminals accountable for their actions or make it a felony to be in possession of a stolen firearm? We do not have a gun problem. We have a criminal problem. And until we tackle this at the root cause, the criminals, we will continue to see acts of violence in our communities. I would like to close with the following statement: my constitutional rights do not end at my property line.
Hi, my name is Nicole Hardy, and I'm also from Washington County. I am opposed to the passing of this bill. Not only is it my constitutional right to carry a firearm, but I also believe it is my duty. I am a wife, a mom, and believe it or not, I'm also a grandmother to 2 grandkids. As we all know and probably can all agree on, this world has went a little crazy. The passing of this bill is literally a punch in the belly to all law-abiding citizens. It is not us, the law-abiding citizen, whom are committing these horrific crimes, mass shooting sprees throughout our country. Based on current Maryland laws and regulations, there's a lot already being done proactively to ensure that those who choose to carry in our state do so in a way with plenty of knowledge and training. I do believe these measures are pertinent to ensure that those who are carrying do so in a safe way. To say that I can't carry anywhere goes against everything our Constitution stands for. There's so much talk today about feeling safe. Personally, I don't want a false sense of security. I want to know that if I am attacked, or my kids or my grandkids, that I have the ability to protect myself by whatever means necessary. Let it be clear, I have no desire to ever have to use my firearm that I am legally authorized and trained to use. However, in the event that any of us are attacked, or even you next to me, citizen next to me, I would like to know that I have the ability to do so. I should not be forced to feel safe when I in fact can be safe. I should have the right to protect myself. I do not ever want to be a victim. I'm also an insurance broker who works on most days with men and women in various places. I've been put in some various dangerous situations, which is why I originally got my wear and carry permit. Please, I beg of you, please do not take my right away to protect myself. I feel as if many who are for this bill do not understand the processes that already go into place to get these approved licenses and permits. We have a very high standard here in Maryland. I'm now an instructor. I am actively a part of a women's group that we do train each and every month. 2 years ago, I would have walked out of a room if you had firearms. Education is key. I am opposed to this bill, and I hope that you will be as well.
I'm Paige Burns. I'm a Charles County resident. The Constitution obviously protects our right to bear arms. Maryland law already restricts its citizens significantly. A person must pay fees, get fingerprinted, background checked, and trained to obtain a wear and carry permit. Anyone with a permit has been certified as competent to safely use and carry a firearm. Many people received a permit by citing a good and substantial reason. I'm one of those people. This law would prohibit wear and carry in many places, requiring an ever-changing map of restricted areas, creating a navigational labyrinth. When in daily transit, those who lawfully carry firearms are often required to make decisions regarding safe storage in a vehicle due to unplanned circumstances or emergency stops and the like, all governed by various complicated laws and restrictions open to interpretation, causing great difficulty for those trying to follow the law. Firearms are much safer when carried by a person with a permit rather than kept in a vehicle, which could be burglarized. This bill is unnecessary. It negatively impacts law-abiding citizens. Are the lives of those who ignore the law more important than those who abide by it? People with nefarious intent are not concerned about the laws at all. If someone is determined to commit a violent act, which is already illegal unless it's done in defense, they will not be deterred from criminal behavior by this law. I would argue that any place is safer in general when permit holders are present with firearms. The more places advertised as gun-free zones, the more targets created for those wishing to injure and kill. Most lawfully armed citizens, when put in harm's way, would protect themselves and anyone else in the vicinity. Violence in any form is not stopped by creating layers of mindless, unenforceable laws. Evil actions emanate from people's hearts, hence the need for firearm possession for protection in the first place. Firearms are called great equalizers for a reason. Many people, including myself, may not have the ability to defend themselves by physically fighting someone or running away, but with a firearm, we stand a chance. So I urge you to give an unfavorable report to this bill.
Had to make sure.
No questions?
No questions.
We came from all over the state.
Wait.
It's real quick.
Go ahead.
It's not that quick, so that's all right.
Okay, great. I'm glad to hear it. All right. Thank you, everybody. That's going to conclude the hearing on Senate Bill 1. That's going to conclude our hearings for today. Sorry, what's that?
Michael Burke, I'm on the list. Haven't been called.
We called you.
Sir?
We called you a while ago. Do your 2 minutes. You're here. Let's go.
Thank you, sir. First, I'm curious. So, for the rest of my life, I'm going to have to wear my jewelry everywhere I go if this passes. Why? I don't need a permit. I don't have a permit. I'm not required to have a permit. Michael Burke out of Baltimore. In my written testimony, I'm law enforcement. I've been an instructor for over 40 years. I teach most of these things you've talked about. But according to this bill, I would have to wear my jewelry everywhere I go. Every time, every place. And no gun zones don't apply to me. Why? A few details not covered in previous discussion. SB 1, as said, does nothing to prevent crime or violence. It creates a false impression that the General Assembly did something. 30 states across the country allow open carry of firearms without a permit today. 26 states require no permit at all to carry firearms. North Carolina just changed that today. This bill would require an off-duty police officer from Pennsylvania, Virginia, or Texas who's coming in to see the National Aquarium or coming into Ocean City to go spend a weekend vacation, to disarm himself at the city line, at the county line, at the state line, because you suddenly no longer recognize other law enforcement officers from other jurisdictions as having any right to defend themselves, or Maryland citizens. Under this discussion that was held earlier, 4203, the limits on a permit holder, not me, disqualify that person from having a permit the minute they step into a prohibited place, which means they then fall under the criminal sections of 4203 because they no longer possess a permit. There's no penalty for a person without a permit for carrying a gun anywhere they want, because generally the state here, while it has a crime against carrying a firearm without a permit, yes, sir, historically only penalizes minorities, young black men of color, Hispanics, and other minorities. And they typically get 30 days suspended sentences for possessing a firearm without a permit. So, I'll happily entertain any questions if any remain.
All right, we got one more. Clyde Van Dyke, are you here?
Yes, sir.
Yeah, we're hold it.
Not as long as you all, but for 3 hours.
All right, you got 2 minutes. Let's go.
Mr. Chairman, members of the committee, Clyde Van Dyke, Cecil County. I am here in opposition of SB 1. As I sit in this room, 2 quick reflections from the last 3 hours of sitting here, and I applaud you all because I know it's been a very difficult day for you. There's a lot of intellect in this room. We can't be so intellectually smart that we become common sense ignorant. Every place, and what else I've heard is sensitive places, it can be argued that every place where there is human life is a sensitive place. We are at war against evil, and evil doesn't discriminate against individuals or places. New York, California, Illinois, Maryland have some of the toughest gun laws in the country, yet violence still runs rampant. Criminals do not obey laws. Guns do not kill people. People kill people. Unless you can pass a law that changes the condition of the human heart, the only way to reduce violent crime is to enforce the laws we have and hold people accountable for their actions. You can't barter, compromise, or reason with evil. It must be met with the force it displays. Gun laws, no matter how strict, will never deter evil. We cannot hide from it, wish it away, compromise, or reason with it. Evil must be met with decisive force. Why is my life, my family's lives, your family's lives, discounted to the life of the criminal population? If you give this bill a favorable report, that is exactly the message you are sending. It is not a Second Amendment right, not just a Second Amendment right, but a human right for someone to be able to defend themselves and their family's lives. If it were you or your family facing a life-ending threat, you would thank God if an honest, abiding citizen was there to intervene. We must replace emotion with logic. If we allow good people, when needed, to confront evil with the necessary force required, we will have the opportunity not just to feel safe, but be safe. I implore you, do not let fear, emotion, and politics allow evil to triumph. Let those who are good have the opportunity to protect and preserve the innocent. With this, I am requesting an unfavorable report on SB 1. Thank you for your time.
I don't see any questions. All right.
Thank you, Mr. Vice Chair. Thank you, gentlemen, for coming in to testify. Mr. Burke, you said something about the 30-day suspended sentence. Can you repeat what you were saying?
I've been involved in law enforcement in Maryland for an extensive career. The average sentence for a person who is caught in Baltimore City, Prince George's County, Montgomery County, Wycomico County, Hagerstown, for a first offense is 30 days in jail.
That's without a permit, right?
That's without a permit. So a citizen who has ignored state gun laws and carried a handgun without a license, without a permit, typically gets 30 days suspended and walks out of the courtroom.
And what do you think the penalty will be now if a person goes to a separate place and they have their firearm, but they forgot that they weren't supposed to go into that place. with
Could be
their firearm.
15 months.
Thank you very much.
So why would you penalize someone who has spent $1,000 to obtain a valid handgun permit, but you would give them a greater penalty than a 16-year-old who's carrying a gun illegally?
Thank you very much.
All right. I think this might actually be happening. That's going to end the hearing on Senate Bill 1. Thank you very much.
Thank you, Mr. Vice Chair.
All right. So we are going to reconvene in 15 minutes for a voting session. Thank you very much.